ಬರ್ಬೇಕು ಸಾಹೇಬ್ರು. ಆ ಥರ ಮೆಮೊ ಎಲ್ಲ ಡೈರೆಕ್ಟ್ ಆಗಿ ಹಂಗೆ ಕೊಡಂಗೆ.
ಜಡ್ಜ್ಮೆಂಟ್ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ಬಂದಿಲ್ಲ ಅಂತ ಮೆಮೊ ಹಾಕ್ಬೇಕಾಗಿತ್ತು. ಡಿಟೇಷನ್ಸ್ ಕೊಡ್ಬೇಕಾಗಿತ್ತು ಅಲ್ಲಿ.
ಇದು ಮಾಡ್ಬಿಟ್ಟು ಕೊಡಿ, ಓಪನ್ ಕೊಟ್ಟರೆ ಕೊಡಿ.
ಏನ್ ಸಫಿಷಿಯಂಟ್
ಈ ತರ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಆಗಿದೆ. ಸಪೋರ್ಟ್ ಆಫ್ ದಟ್ ಪರ್ಮಿಷನ್ ಸೈಟೇಷನ್.
ಪೇಪರ್ ನಂಬರ್ ಹಾಕಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. ಚೆಕ್ ಮಾಡುತ್ತೆ ಸರ್, ಇದು ಎಷ್ಟು ಟೈಮ್ ಆಯ್ತು?
ಲಿಸ್ಟ್ ಆಗಿದೆ
ಲಿಸ್ಟ್ ಆಗಿದೆ ಸರ್,
ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆ.
ಇವತ್ತಿಗೆ ಸರ್ ಲಿಸ್ಟ್ ನಂಬರ್ 69
ನಂಬರ್ ಚೇಂಜ್ ಬೇರೆ ನಂಬರ್ ಬಂದಿಲ್ವಾ?
ಅದು ಗೊತ್ತಾಗಲಿಲ್ಲ.
ಈ ಕೋರ್ಟ್ ಓಪನ್ ಮಾಡಿ. ಈ ಕೋರ್ಟ್ ಇದೆಯಲ್ಲ ಹೈಕೋರ್ಟ್ದು, ಅದು ಅದನ್ನೊಂದು FR ನಂಬರ್ ಗೊತ್ತಾದ್ಮೇಲೆ ಆಚೆ ಹೋಗ್ಬಿಟ್ಟು ಲಿಸ್ಟ್ ಚೆಕ್ ಮಾಡಿದ್ರೆ ಮೇಲೆ ಬರುತ್ತೆ.
ನಮ್ಮ ವೈಕ್ ಕ್ಲೋಸ್ ಆಯ್ತಾ?
ಪೇಪರ್ ನಂಬರ್ ಡಬ್ಲ್ಯೂ ಇದೆ.
ಜಾಸ್ತಿ ಇದ್ದಾವೆ, ಏನೋ ಮಿಸ್ಪ್ಲೇಸ್ ಆಗಿದೆ, ನಾಳೆ ಹಾಕೊಡ್ತಾರೆ. ಬಟ್ ವಿಚಾರಿಸಿ ಹೇಳಿದೆ ರೇಟ್ ಇದ್ದಾಗ ನಮ್ಮ ಮೇಲೆ ಕನ್ಫರ್ಮ್ ಆಗಿ ಹಾಕ್ಬೇಕು. ಬಟ್ ಏನಾಯ್ತು ಗೊತ್ತಿಲ್ಲ, ಇಲ್ಲ ಪರವಾಗಿಲ್ಲ. ಬಟ್ ನೀವು ಫಾಲೋ ಅಪ್ ಮಾಡ್ಬೇಕು ಸರ್. ನಾಳೆ
ಏನ್ ಸ್ಟೇಜ್ ಇದೆ ಆಫೀಸರ್ಗೆ ರೆಫರ್ ಮಾಡೋದು ಕೇಳ್ತಾರೆ.
ಇನ್ನು ಲಿಸ್ಟ್ ಬಂದಿಲ್ಲ.
ನನಗೆ ಹೇಳಿದ್ರೆ ಇನ್ಕ್ರೀಸ್ ಮಾಡಿ ಕೊಡ್ತಾರೆ, ಏನಾದ್ರು ಕೊಡೋದು.
ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ.
ಅಡ್ಜರ್ಮೆಂಟ್ಸ್ ಲೀಸ್ಟ್ ವೈಸ್
ಪೇಜ್ ವೈಸ್ ಅಪೋಸಿಟ್ ಸೈಡ್ ಇಂಟಿಮೇಟ್.
ಯಾವ ಲಿಸ್ಟ್ ಎಷ್ಟೇ ಮ್ಯಾಟರ್ ಚೆಕ್ ಮಾಡ್ಬಿಡಿ. ಅದ
ಹೇಳಿ
ಮಾಡ್ಬಿಟ್ಟು ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಕರೀತಾರೆ.
ಪೇಜ್ ವೈಸ್ ಅಪೋಸಿಟ್ ಸೈಡ್ ಇಂಟಿಮೇಟ್ ಮಾಡಿ.
ಆ ಟೈಮ್ ಬೇಕಾದ್ರೆ ಚೆಕ್ ಮಾಡ್ಕೊಂಡು ಬಂದ್ಬಿಡಿ. ಈಸಿಯಾಗಿ ಇರುತ್ತೆ, ನನಗೆ ಗೊತ್ತಾಗಲ್ಲ ನಮ್ಗೆ ಯಾವ ನಂಬರ್.
Emergency ಮೆಮೊಗಳು ಕೊಡ್ಬೋದಾ? ಇಲ್ಲದೆ ಇರುವಂತ ಮೆಮೊಗಳು. Emergency ಇಲ್ಲದೆ ಇರುವಂತ 2 weeks.
What is that order? Yes, being spoken to tomorrow.
Being spoken to.
I've not your file.
ಅಲ್ಲಿಂದ ಬರ್ತಾರೆ ಈ ಕಡೆಗೆ ಸ್ಲೋಗ ಬರ್ತಾರೆ ಒಂದೊಂದಾಗ ಬರ್ತಾರೆ.
What is that next date? Tomorrow, yes.
இல்கம் பொறுமையா இருங்க வரும் ஒன்னா கூப்பிடுவாரு சொல்லுங்க அர்ஜென்ட் பண்ணாதீங்க.
Monday.
ஒன்னா கூப்பிடுவாங்க பிரச்சனை இல்லை.
Tomorrow, yes. Monday, yes. Tuesday. Monday, yes. Let us see on Monday. Monday we'll see. Monday, yes. Monday we'll see on that day, yes. Yes, tomorrow, yes. Tomorrow. Yakri adu. Tomorrow.
My lordship.
Wait, something.
Yes.
What the parties are agreed? Yeah, so. Thing will happen. We'll see at yes, Monday. Monday, yes. We'll see. Yes.
ತಗೊಳಪ್ಪ ಫಸ್ಟ್.
ಕರೀತಾರೆ ಬರ್ಲಿ ಯಾಕೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿಬೇಕಾದ್ರೆ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ರೆ ಪೋಸ್ಟಿಂಗ್
What is that order? Yes. You have filed an application for vacating. Yes, Tuesday. Vacating Tuesday. Why they have locked the premises? So directly going to implement the tomorrow. Yes, tomorrow. Yes, tomorrow. Yes. Now let us see if there is a caveat at all. We have some ordinary. Understand. I there is yes, matter has been argued and interim order is not granted. Hence, there is no ordinance. We will have tomorrow. Monday.
My lordship.
Monday. What can I do by the petitioner? Then why you are appearing? If petitioner is there. Yes, you have argued when I have not granted any interim order. That means you say you are not convinced. Then I have issued an notice. Again, you are moved. No, what is that affidavit I asked to file? Yes. When that notice has been issued, then it has to be taken at that to 2:30. If it is a first matter, I can take it at 2:30. No, you said that you have argued and I have directed to file an affidavit then. Said that first matter, you said that you have argued and there is a direction to file an affidavit. Tomorrow, yes. Yes.
Is the defendant number one before the trial? By argument, the matter was listed before this on the court on Monday, but it didn't reach. On that day, it was subsequently posted before the trial court, and cross-examination of P.W. is taken as continuous. Again, it is listed on Monday.
Monday. It is already listed on Monday.
No, the trial court is Monday.
Yes, we will act on Monday.
My lordship.
If you want to reach, right? Stay on the warrant. The report is already issued to
General.
Tuesday.
Yes, tomorrow.
Let us see very urgent. What will happen, Mr. Nothing will happen. Yes. 6-3, yes.
6-3.
No, 6 will 6. No, we'll take it on that day, nothing will happen. Yes. That's what that. You can't take it on that day. Then you will have it on 7-3, yes. Now, what is that urgency? Yes, he said that it's only tomorrow. Yes. Yes. Tomorrow, yes. Execution. Tomorrow, yes.
My lord.
Close up.
Monday will see. Yes. Let us see. Yes. Yes.
ఎక్కువ ಬರ್ತಾ ಇದೆ ನೋಡಪ್ಪ ಒಂದು
ಏನಾಗುತ್ತೆ ಬಿಡಿ ಏನಾಗುತ್ತೆ. Yes.
My lord, there is a stay from the Supreme Court with regard to election and the administration, my lordship. They are conducting the meeting on Saturday. It will be taken up tomorrow, my lordship.
No, what is that by election?
They're conducting executive meeting, election with CSHS, which has been stayed by Supreme Court.
No, what is that order you are challenging here?
There is a part of that portion of the church might also conduct the meeting. They're conducting the meeting. Church meeting they're conducting. The Supreme Court has very clearly stated the administration work in election also might not.
Monday, yes.
But Saturday is the meeting might not.
Monday, yes.
Saturday is the meeting.
Let us see on that Monday, yes.
Chief, officially, before we there for the first dependent, tomorrow is the final of suit for eviction. My application is able to dispute for that.
What application?
Our 18/17 application, 2024 matter eviction suit you run. Tomorrow is the final of Friday, end of the list.
Tomorrow, yes.
My lord, I filed vacating stay application.
Yes, madam, what is that?
Party in person.
Party in person, my lord.
We are plaintiff of trial court case. We have filed vacating stay application on the appeal filed by the. We are requesting a matter to be listed on 19th March.
Yes, Tuesday, 4th or 3rd.
We have asked for 19-3, my lord.
19th March we have asked.
19th March, yes, 3rd, yes, 19th.
Thank you.
Thank you, my lord.
19th March.
But one,
What is that matter? What has happened to that? Petition and not read. I have not reserved any matter.
my lords, one matter for tomorrow. My lords, my husband's claim petition.
Yes,
My husband passed away. Some third person lady who is not I am the legally wedded wife.
yes.
She has entered appearance and joint memo file ಮಾಡಿ 31 ಲಕ್ಷಕ್ಕೆ settlement after registrar ಮುಂದೆ ಇದೆ dispersal ಗಿದೆ ಸ್ವಾಮಿ.
Tomorrow, yes.
ನಾಳೆಗೆ ಇಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಟಿಕೆಟ್ ನಾಳೆ ಲಾಸ್ಟ್ ಡೇಟ್ ಇದೆ. ಆಲ್ರೆಡಿ ನಾಳೆವರೆಗೂ ಇದ್ರು ಕೂಡ ಆಪರೇಟ್ ಮಾಡ್ತಿದ್ರು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
Tomorrow, yes.
In this, there is a prior suit and there is a subsequent suit filed. The subject matter and the issues containing issues and the parties are one and the same. I filed application for section 10, which came to be rejected by the trial court. Hence, I filed the WP member. Kindly have it.
Yes, Tuesday.
My lords, tomorrow.
What will happen, Mr. Section 10 application is?
Tomorrow it is posted for cross.
Nothing will happen, yes.
For page wise adjournment, list number 1, page number 1, serial number 1 to 6, page number 2, 7 to 15, see page number 3, serial number 16 to 24.
Yes, at the request of counsel for the petitioner, leave this matter of 2 weeks.
Page number 4, serial number 25 to 31. Page number 5, serial number 32 to 36. Page number 6, serial number 37 to 40. Page number 7, serial number 41 to 44. Page number 8, serial number 45 to 48. Page number 9, serial number 49 to 51. Page number 10, serial number 52 and 53. Page number 12, serial number 54 to 58. Page number 13, serial number 59 to 64. Page number 14, serial number 65 to 71. Page
60. Yes. You are appearing for? Yes, at the request of counsel for the petitioner, leave this matter next week. 2 weeks.
Page number 15, serial number 72 to 78. Page number 16, serial number 79 to 81. Page number 17, serial number 82 to 87.
83, my lord, I am going to.
80?
83 ante sir.
83 dismissed as withdrawn. Yes.
Page number 18, serial number 88 to 93.
90. Yes, at the request of counsel for the petitioner, leave this matter on 12th March. Yes. Interim order granted earlier is extended till next date of hearing. Yes. Yes, we'll do it. Yes. Yes, we'll do it when the matter is called, because I have to dictate that order. Yes.
Page number 30, page number
But we'll
19.
note it down. Your presence is not necessary. Yes.
Note ಮಾಡಿ. Page number 19, serial number 94 to 96. Portal number 17 matter, list number 2, page number 1, serial number 1 and 2. Page number 2, serial number 3 and 4.
4.
Yes. Yes.
Yeah,
Yes, what you want?
matter is getting settled in my mind. So
What do you want now?
25th of
Yes, sir. The request of parties leave this matter on 21st March. 25th March. Yes.
Portal number 20 matters, page number 1, list number 3, serial number 1. Page number 2, serial number 2 to 4. Acceptance of paper copy.
Yes. Yes, we'll pass an order when the matter. Yes.
List number 1, for preliminary hearing, serial number 1, Shruti C. Chaganti.
I appear for the petitioner, my lords.
Yes.
Lords, an arbitral award is passed against me by the Deputy Registrar of Chits Telangana against me and the respondent number 2 to 4, my lord. It's an
Yes.
ex parte award that is passed.
Yes.
No notice is served on me. Then an execution proceedings are initiated.
Yes.
Before notice is served on me, the memo is filed by the respondent number 1, giving up their claim against the principal debtor, who is the respondent number 2. And before any notice is served, an attachment warrant is issued against me, my lord. I am working as a professor before in a college.
Yes.
My 70% of my salary has been attached. Now, my lord, an order is passed for attachment of the entire amount. And no
Where is the-
notice has been served, my lord, on.
Where is that order?
Please, my lords, may just see, the execution order sheet is at page 20, page 23, my lords may just see.
Yes.
Page 23, my lord, the first order, counsel for DHR present, cause notice to JDR number 1 and 4 returned unserved. Counsel seeks for reissue of notice to JDR number 4. I am JDR number 4.
Yes.
For the present by RPAD and through court. Hence, reissue notice to JDR number 4 by RPAD and through court if PF is paid.
Yes.
Next date, my lord. Memos filed not pressing the petition as against JDR number 1 and 3. That's the principal debtor.
Yes.
And files IA number 1 under Order 21 Rule 48A CPC seeking for issue of salary attachment warrant against D2 and 4. In view of the submission made in the memo, same is accepted and the petition as against JDR number 1 and 3 is hereby closed as not pressed. Issue salary attachment warrant against JDR number 2 and 4 as prayed for. Then, my lords may just see for a moment, page 26. So notice was not served on me, my lord. Even before any service of notice, this order is passed, page 23.
Yes.
It will be seen, my lord, on the last date, that is on 12/1/2024. Counsel seeks reissue of notice.
Yes.
Notice is not served.
No,
Then-
warrant against the D2 to D4.
That I am D4, my lord.
Yes.
An attachment warrant is made, issue salary attachment warrant. So immediate, without any service of notice or summons, this salary attachment warrant is made against me.
No, that can be. Is there any bar under that
My
provision?
lord, what I am submitting is, there are two grounds, my lord. One, execution proceedings are ex parte. I have received no notice. They have, as per the arbitral award, which I have placed as Annexure B, what it says is that there was a paper publication taken. I had no notice of the same. Even as per them, I'm a surety. Principal debtor is,
That order you have not challenged.
my lord, I am to challenge it, my lord. The difficulty I am facing now is my March month salary is going to be deducted. Now, my lords may see, if my lord sees, I have placed my salary slip at Annexure F.
Now, what is that arbitral award amount?
Arbitral award is at Annexure B, my lords.
10 lakhs.
Yes. And my lord, once they give up the claim against the principal debtor, section 134 of the Contract Act, my lords, once there is a discharge of the principal debtor, the surety cannot be held responsible.
No, discharge in that main this thing. This isn't that execution petition.
Please, my lord, but if my lords would see the manner in which this entire thing is conducted for
No,
a moment.
Surety is same liability as a principal debtor.
My lord may see the manner in which this is conducted. Arbitration, this arbitral award is passed. I have no service. I have no notice of the same.
That you can challenge that. But
Then my lords may see my difficulty that I'm facing. Then execution order is passed. I'm sorry, in execution proceedings, no notice is served upon me.
Yes.
My 2 months salary has been deducted. My salary, my lord may just see the difficulty that is I am under. Annexure F at page 30.
No, you see the difficulties of persons who has, given money.
Lords, I understand that, but in this manner, in a completely without any form of notice, Annexure F, my lord.
In a surety, you should know that.
My lord,
Difficulties.
if at least if notice was served against me, I would have gone. I only became aware of this entire proceedings, my lord, when my salary is deducted.
Yes.
Annexure F, page 30.
Deposit some amount.
My lord, already 2 months salary has been deducted. Already 88,000 has been deducted at, if my lord would see page 30 for a moment.
Yes.
Annexure F.
Now tell me, what is the remedy for that person who has
My lord,
obtained the degree?
finally, my lord, I will also have to challenge that arbitral award. Already 2 months of my salary is deducted.
Yes.
They give up the claim against the principal debtor. Now an order is passed for entire amount to be recovered from me. And only against insofar as this petitioner is concerned.
That can be.
And my
There is no
yes,
bar.
my lord, but at least there should be some semblance of me having had an opportunity to be heard. At Annexure F, my lord may see my salary, my wage slip.
Even if there is an opportunity, when there is a degree which is not challenged.
But I'll have to challenge that. I only become aware of these entire proceedings when my salary is withheld.
Yes.
At Annexure F,
Or-
the deduction.
Stay of order dated 7/3/2024 passed by 10th Additional City Civil and Session Judge, Bangalore, in execution number 1969 of 2023 till next date of hearing.
My lord, also order dated 14/2, my lord, for the subsequent recovery, page 26. 14/2/25, my lord.
What's
Page-
that order?
For further steps to recover the entire amount immediately. Page number 26, my lords.
Council preparing DR submitted that the claim is against the JR 1 and 2, therefore notice to the same.
Last line, my lord. For further steps to recover the entire amount immediately.
23. No, which page? ma'am?
Page 26, my lord. I'm sorry.
Yes.
Last line, my lord. For further steps to recover the entire amount immediately.
Now, what is this amount?
My lord, this is they've already recovered insofar as that 82,000.
7/3/2024, what is that order?
70, it's in continuation of that, my lord.
Now, where is 7/3/2023?
7/3/24 is at page number 23.
7/3/2024, what is that order? Consent.
My lord, that is for issuance of salary attachment. And then, my lord, page 26, it is for further steps to recover the entire amount.
Now we will stay only that order dated 24/1/2025.
My lord, 14/2.
14/2 now. Where is that? Ah, yes, 14/2. Yes.
14/2,
Stay
my lords.
Stay of order dated 14/2/2025. Passed by the executing court in execution number so and so till next date of hearing.
My lord, my request is also that 17/7/3 may be stayed so that there is no confusion before the execution court, my lord.
No, that is that you have already complied.
It's not compliant, my lord. It's a continuing order.
Hmm.
That's the reason. 7/3 may also be kindly stayed, my lord. So there's no confusion on that.
No,
front.
but you are not challenging that order.
I am, my lord. I am. My interim prayer may be seen at page 7.
What is that interim prayer?
I am challenging 7/3, my lord. This is a continuation.
7/3 only. Where
Please,
is
my
that?
lord.
You have not challenged any
My
other.
lord, 7/3 may be stayed, my lord.
I said
And
only
sub-
7/3. Yes.
I'm sorry, my lord. 7/3 and subsequent
7/3,
proceedings.
2023, 2024 till next date of hearing. Yes.
Cell number 2, Abhim.
Most grateful.
Appear for the petitioner.
Yes.
This is an execution proceedings.
Yes.
I am the decree holder.
Yes.
The judgment data, my lord, is respondent number 1. During the pendency of the execution proceedings,
Yes.
3 persons come to implead themselves as additional decree holders. Something unknown in order 21.
What is the degree?
My lord, decree is the memorandum of settlement at page 39. 39.
Page 39 is
Yes, my lord.
settlement.
Settlement.
Yes.
It was under 89, my lord, a settlement was entered into.
Yes.
And we, my lord, said we will nominate some persons
Hmm.
for receipt of certain sites. And therefore a list was given.
Yes.
And then we've also said they should be inducted as members. Then sites can be allotted to them.
Where is that suit plaint?
The plaint, my lord, yes. The plaint, my lord, your lordships will find at page 30. 30.
30. Yes.
It's a suit filed, my lord, by the judgment debtor against us with respect to a claim for money.
Yes.
Then under a settlement, my lord, it was agreed that they will transfer certain sites to us,
Yes,
about 10 sites.
yes,
We said we will nominate certain persons. Now, in the settlement, 3 persons' name was also indicated. These 3 people's name was indicated,
Yes.
but they were never inducted as members.
yes,
Therefore, my lord, we filed an execution against the judgment debtor, that is the plaintiff in the suit,
yes,
saying you must now execute the sale deeds. At that point in time, an application under Order 1, Rule 10 is filed in the execution proceedings,
yes,
saying implead me as a decree holder.
yes.
in-
Where is that?
My lord, that application, Lord, please come to page 50.
Where is that order?
The order, my lord, Annexure A at page 20.
Yes, what is the reason given?
The reason given is their names are found in the decree,
Yes,
and therefore I'll implead them as a decree holder.
yes.
In my humble submission, a decree holder can only be a person who's
Issue notice. Stay of order dated 22/2/2025 passed by 15th Additional City Civil and Session Judge
16th. my lord.
in execution petition number 479 of 2023 till next date of April.
Great.
Serial number 3, Rakesh B. Bhatt.
For the
Yes.
petitioner, my lord.
Hmm.
Suit for partition is filed in the year of 2023 February, my lord.
Hmm.
And thereafter, my lord, the defendant number 2 and 4 who are contesting defendants
Hmm.
filed their return statement on 22/3/2024, my lord.
Hmm.
I have filed the application for order 12 rule 6 on 26/6/2024, my lord.
Hmm.
The only prayer I'm asking is to dispose of that IA number 5, which is pending from past 8 months, my lord.
Where is your IA?
IA is at Annexure E, my lord. Annexure E, page number 49, my lord.
Annexure?
E. There is a clear admission given by the defendant number 2 and 4 who are contesting, my lord.
49.
49, my lord.
Yes, for the reason of. Yes,
Even the defendants also agreed that they are also entitled for 1/7 share and does
Yes.
not dispute anything in their return statement, my lord. The
Yes.
return statement can be found at page number 39.
you take out handsomens.
My lord, they are not even ready to address their arguments, my lord. That is the
No,
reason.
you
The
take out
handsomens may be-
handsomens, then you will dispose of.
If it is, any direction may be given to dispose it of in 1 month.
Yes,
Because next date is on 7th of the next month, my lord.
yes. Issue notice.
My
In
lord,
addition,
notice may be dispensed with, my lord.
in
Otherwise,
addition,
the
no, you have to serve notice, then we will dispose of. In some of the cases, I have disposed of. Then they come and move that. There are all some other directions and all. You give in a notice.
No,
then you
nothing.
dis-
I have produced the entire order sheet, my lord. There is nothing direction,
No,
nothing is there.
They are the party before this court.
Please, my lord.
If you want to disposal, serve in a handsomens, move the matter, then you will dispose.
A short accommodation, the advocate on trial court may be directed to
Yes.
take notice, my lord. A short
Issue
may.
notice. In addition, petitioner is also permitted to serve a copy and the counsel appearing for the respondent before the trial court. When you will come back?
The next date is on 7th, my lord. Before that only, it may be,
Yes.
a date may be fixed, my lord.
Sixth.
Please.
Serial number 4, R. Hemant Raj.
So the
Yes,
petition is a plaintiff before the trial court.
yes.
This is a suit for specific performance. Your Worship, kindly see, Your Worship, page number 31. I produced, Your Worship, the copy of the plaintiff prayer.
Hmm.
The second prayer is, Your Worship, the decree ordering the
Page 21.
31, Your Worship. Page number 31, prayer number B.
Yes,
A decree ordering the first defendant to convey the suit property in terms of the said agreement dated in favor of the plaintiff. Your Worship, this prayer is not specific. Though, Your Worship, this is a suit for specific. Prayer is not specific. Under this background, Your Worship, I filed a amendment application. Kindly take, Your Worship, Annexure B, page number 37. Page number 37, Your Worship, the 10 ಅಲ್ಲಿ first. Page number 37, this is the amendment application. Due to pass a judgment and decree and direct both the owner subsequent purchase executed sale deed in favor of the plaintiff in respect of the usual property. Earlier, Your Worship, the prayer is not specific. Your Worship, I am sought this. Now, Your Worship, the application is rejected on the ground. The trial is already commenced. Kindly take Your Annexure E, page number 59.
you are the plaintiff.
I am the plaintiff before the trial court.
Yes.
Page number 59, impugned order, Annexure E. The sixth line, your worship, the
Yes.
when the case is posted for the plaintiff evidence, sixth line, page
Yes.
number 59 ali.
Or issue notice. Stay of further proceedings in OS number 7237 of 2012, pending in the file of 31st Additional City Civil and Session Judge, Bangalore till next date of it.
Serial number 5.
Move it for handover because tomorrow matter is set on for your worship.
Yes.
Maintain.
Pradeep Kumar RH. Memo. Everyone.
Brought suit for specific performance, my lord.
Yes.
The order impugned is the trial court has refused to grant an ex parte interim order. Suit for specific performance. The agreements have been executed by the respondents. The 4 agreements which has been executed in favor of the petitioner area,
Yes.
right from 29/11/2002 to 2/12/2011, my lord. I produced the agreements of sale.
What is that you are challenging?
I filed an along with the specific performance suit, I filed an application restraining the respondent from alienating the suit schedule property. The trial court has refused to grant the interim order, my lord. But therefore, I before this honorable court.
Where is that order?
Wide annexure A, my lord. Page number 23 in page number.
Annexure?
A, my lord. In page number 23.
Ex parte they have refused.
They have refused, my lord.
Notice has been issued.
Notice has been issued. Now they are trying to alienate the suit schedule property. What happens?
Issue notice. Parties are directed not to create third party interest in respect of petition scheduled property till next date of hearing.
Serial number 6. KV Narasimhan. Petitioner. Murthy AP.
Day of. The difficulty is that sugarcane cultivation, my lord, which is there, that is sought to be cut with the help of the police help. That is the main submission.
You don't do that till Tuesday. If you are undertaking, no means you want to cut it.
No, my lord, tomorrow.
No. Two things. I will grant the time. Till then, don't cut that. That's what. Then that means to say you want to cut. If you say no, that means to say you want to cut that by tomorrow. We'll grant till Monday. Don't do that anything. Whatever there, let it be there. Yes. Use this matter on Monday.
Tuesday, my request on
Tuesday. Yes.
Let him make.
No, yes. Yes, Mr. You want recording or will instruct that your party not to do anything?
Inspected, my lord.
Yes.
Not quite. ಆಮೇಲೆ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂದ್ರೆ
No, advocates we have to be.
ಅಲ್ಲ ಅವ್ರ ಪಾಪ ಅವ್ರು ಮಾಡ್ತಾರೆ ಬಟ್ ಅವರು
No,
ಕಮ್ಯುನಿಕೇಟ್
he has to instruct, otherwise we'll pass an order because you are counsel on record. Yes. Yes.
great.
Serial number 7. Bhanu Prakash HV for petitioner.
For the petitioner, it's a consequential order pursuant
At the request of respondent, we will run Tuesday.
Serial number 7.
for the
Yes,
petitioner.
Mr.
The suit for eviction, madam. It's a defendant's petition. It's a consequential order. The trial court has struck down the defense on the ground of non-payment of the rent. That's it, my lord. Even the trial court order declaring to directing me to pay make the payment of rent is also.
Where is that order? What is that order?
Annexure G, madam.
Page.
Annexure K, madam.
Page.
77 on.
What is that application you have filed, Mr.?
They had filed, madam. Plaintiffs had filed.
Plaintiff has filed red with substance striking the defense of the defendant for non-compliance with the order of this court dated. What is that order? 9/12.
Madam, even that order is also under challenge. That is been coming under serial number 15 today.
No, what is that 9/12/2024 order?
The trial court has directed me to make the deposit of the rent to the tune of 12 lakh rupees.
Suit for?
Suit for eviction.
Oh, then you have to deposit that money.
The point is, my lord, I have not been allowed to conduct my business. It's a business. Scheduled property is owned is used by the.
Which is that serial number?
15, my lord.
15.
15.
Yes, we saw this matter.
Connected.
15.
Please.
Let us first we'll see whether yes.
Serial number 8. Poonam S. Patil.
She requested for tomorrow, my lord. ಸ್ವಲ್ಪ ಕೈಗೆ ಏಟಾಗಿತ್ತು ಅದಕ್ಕೆ ನಾಳೆಗೆ ಕೇಳ್ತಾ ಇದಾರೆ.
Yes,
Days
the
accommodation.
request counsel for the petitioner Monday.
Tomorrow, my lord.
Tomorrow.
Please.
Yes.
Serial number 9. Dinesh SK.
Yes.
This is petition filed by the impleading applicant. Whereas respondent number 1 initiated a suit for specific performance of a sale agreement entered into between him and the respondent number 2.
Yes,
Respondent number 2 happens to be petitioner's father.
yes,
Then what's at page 36, if my lords would kindly see, the suit prayer.
yes,
Suit prayer is, my lords, direct the defendant to execute the registered sale deed by specifically performing the sale agreements in favor of the plaintiff in respect of the scheduled property. There the claim is, my lord, the suit scheduled property is the absolute property of the respondent number 2. Anta.
yes,
But actually, suit scheduled property is ancestral property in which the petitioner has a 1/5 share.
yes.
Therefore, my lords, he filed an application for impleading, which my lords would get at page 13.
No, that agreement is executed by your father.
My father, when I was a minor.
Yes. What is that order passed by the trial court? Why your application is rejected?
Why they reject? Only reason on which it rejects is I am not a party to the sale agreement.
Yes.
That is finally that is contrary to judgment of the Supreme Court in Mumbai International Airport, my lords, where the Supreme Court said,
Yes.
where a person has an interest in the property, either you have to dismiss the suit if he is not impleaded, or you have to implead him even when he comes.
Yes.
That is the kindly see the reasoning given by the trial court. Reasoning given by the trial court is at page page 10, page 20, 26.
Yes.
Last 2 lines. Applying the principles to the facts of this case, since even the applicant is not a party to the agreement, instead of claiming that the suit property is junk, that court finds no hesitation in holding that viewed from the application requires to be dismissed.
Yes.
For that,
Issue notice. Stay of further proceedings in OS number 458 of 2006, pending in the file of Principal Small Class Senior Civil Judge MEACT Mysore till next date of hearing.
Great.
Bill number 10, Chetan AC.
For petitioner.
Yes.
Petitioner said by the impleading application which was rejected, my lord.
Yes.
Suit is for declaration and injunction.
The land, the prayer suit is based on the sale deeds, my lord. But actually the land is a burial ground. And my contention is my first petitioner's father and second petitioner's mother are buried there, my lord. And therefore it is a
suit for declaration.
Declaration and injunction.
On what basis they are claiming a title?
They are claiming on the basis of sale deeds, my lord. And they are also admitting in page 42 that government had initiated some acquisition proceeding. So even some effort is page 42, 5th, 6th line, my lord. The documents produced, though not admitted, they don't disclose that father of so and so. Upon reading on the documents produced by the applicants, it shows that government tried to acquire the suit property from plaintiff for the purpose of the burial ground, but same is not pursued. And so and so. My lord, so when there is some public interest involved, my lord.
No, what is that earlier round of litigation?
Earlier round is the defendants had asked the document from the Tahsildar, my lord. That we had come to the High Court and that was rejected, my lord.
No, in the very same suit or?
In the very same suit, my lord.
You are not yet impleaded.
Now we are not, this is a different IA 22. We want to implead. We are not impleaded, my lord.
No, before impleading that, you have come before this court.
I come before the defendants had come, my lord. Defendant
has come.
A defendant had come. That is that we had asked the Tahsildar to bring the IL and RR before the court. So that
what is that order passed by this court?
My lord, this court said that the stage is late and if while filing the written statement itself, they should have realized that IL and RR is not there and they should have asked for the topic. Just for the purpose of disclosure, I have produced, my lord.
Yes.
My lord, in a similar case, in the road was many people of the village, they wanted to implead themselves. And Honorable Court has allowed the impleadment of the villagers in page number 10, my lord, para number 10.
Yes.
The bare reading of the provision shows that the court has power to direct a person to be made party to the suit if any such person ought to have been made party. So and so in case such a party is only a proper party, then that party can be added if the court holds that his presence is necessary to decide the dispute between the parties effectually and completely. Court has to exercise its discretionary while impleading the party in the light of the above provision. In the instant case, any such order that is to be passed in favor of the petitioner will adversely affect defendants 2 to 16 and other general public who are using the road in question. Prayer made in the suit is to restrain the first respondent in forming the road. Materials have been produced before the court show that the road was already formed and is existing.
Yes,
since
heard. Issue notice. Stay of further proceedings in OS number 49 of 2019. Pending in the file of Senior Civil Judge JMFC, Sidligatta, till next date of it.
Much of it.
Cell number 11, Rakshit Tar.
Petitioner, my lords.
Yes.
Let's suit for injunction, my lords. My application for under 39 rule application has been rejected. Suit for injunction, my lords. My lords, there is an agreement between the respondent number 1 and 2, my lords, to sublet the issued shell property. Accordingly, respondent number 1 lease out the property in my favor, my lords. Still, lease period is in existence, my lords. The respondent number 2, without terminating lease between the respondent number 1, has issued a legal notice saying that you vacate the premises, my lords. So that is the reason why we approached the Honorable Trial Court and filed 31 and 2 applications, my lords. That application, my lords, Honorable Trial Court denied to grant interim order, my lords, and issued emergent notice, my lords.
Yes, what is the threat, Mr.?
My lords, my lords, there is no agreement between me and the respondent number 2, my lords. There is an agreement between the respondent number 1 and me. And they have issued a legal notice saying that you vacate the premises without paying my advance, amount also.
No, where is that your lease agreement?
My lease agreement annexure. First lease agreement at annexure E, my lords, page 52, and subsequently it is renewed at page 56, my lords. From the date of April 15, 2024, lease period is 2 years, my lords. That is between me and respondent number 1. So agreement between the respondent number 1 and 2 is in at page.
I think take notice. No, what is that? You have filed an application for, can they come and throw you from that house?
Please, my lord.
How can that without any degree and all?
That's why, my lord, without due process of law, they're trying to throwing.
You go and given a police complaint. How can they do it, Mister? Without
That's
that.
what we have filed my lord, suit before the trial court, my lord. Suit for injunction, my lord.
I thought if suit for injunction,
please, my lord.
Is it can be thrown you out without the due courses of law?
Please, my lord.
Have you stated in this petition?
Please, my lord.
Where is that?
In the grounds, my lords. The Honorable Trial Court failed to respond. Respondent number 2 has sent a legal notice 28/10/2024 to the petitioner, and respondent number 2 vacate the sold property and terminate the lease agreement, whereas the lease agreement is still in existence. The fact that 12th Brown, my lord, respondent are trying to dispose of the petitioner without due process of law, hence the need of interference of the Honorable Court, my lord. They can vacate me with the due process of law, my lord, without without paying the amount, which is I paid 15 lakh rupees. That too in the online transaction, my lord.
How they will, Mister? If the person is in the possession, how can that? You are saying that law and order is not there in that.
That is the.
No, you explain.
Kindly see the legal notice, my lords. Kindly see the legal notice.
He has to give a legal notice before initiating the proceedings.
That too, there is an agreement between me and respondent number 1.
That will be decided in the court.
Please, my lord.
There is no bar for him to give a notice.
Please, my lord.
By giving in a notice, it means that you can be thrown out from that house.
Please, my lord. That he is a owner, because he is a owner.
No, owner can throw out that any person is in the house without due process of law.
That is he is doing, my lords.
No, I want to know that explanation. How can they do it, Mister?
And they have disconnected the water connection also, my lords. For that effect, my lords direct us
where
to
is
file
that?
affidavit, my lords.
Yes.
I'm filing affidavit also, my lords. Para number 3, I stated, my lords.
Yes.
Submitted that respondent number 2, property owner has disconnected the water supply connection and
demanding the monthly rent to the ton on the water connections, and also warned they will disconnect the electricity connection to the plot in few days. Though we have entered into a lease agreement with the respondent.
Learned counsel for the petitioner. Learned counsel for the petitioner filed an affidavit saying that without due course of law, the respondent to herein try to disposes the petitioner from the house suit scheduled property, the suit scheduled property, and he has already disconnected the water connection. In spite of that, trial court has not granted ex parte order of injunction. The affidavit filed by that petitioner is taken on record. Respondents are directed not to dispose the petitioner from petition scheduled property till next date of hearing.
Only direct them to give water connection, my lords.
All that we'll see first. We
Please,
file an
Serial number 12, G.S. Prasanna Kumar for petitioner, G. Balakrishna Shastri.
Respondent.
Yes.
It's the plaintiff's petition, my lords.
Yes.
The plaintiff filed suit for declaration.
Yes.
After full-fledged trial, he filed IA number 8 seeking appointment of commissioner, 3 commissioners.
Suit for
declaration and possession. Schedule A is the large extent of the land in which even this 4th respondent's property is also situated. My property is also situated. Schedule B property, a portion of Schedule B property is encroached by him. That is described as Schedule D. D is in my possession only. E and F belongs to 4th defendant. This property is carved out of survey number 103. Presently, it is within municipal corporation limits.
Yes.
No sketch is prepared. Under the guise of conducting survey, they come and encroach my property. There was a specific admission during the course of cross-examination. There is no sketch available for which portions. My lords, it is not the measurement dispute, my lords. Here, Panktikarana, alignment. ಇದನ್ನು ಎರಡು ಎಲ್ಲ ಇದೆ ಒಂದು ಹಿಂಗ್ ಮಾಡಿದ್ದಾರೆ ಒಂದು ಹಿಂಗ್ ಮಾಡಿದ್ದಾರೆ for that I am producing exhibit P13 and 14 which I have already produced before the trial court.
Where is your application for appointment of the commissioner?
Annexure C, my lords, at page number 39.
Yes, what is that you are sought for?
These are the commission, that is assistant director of land records, surveyor and engineer of Unsur Municipal Corporation. Council anta bardidana correction madidini. Correction you madilla anta nan application reject madidare.
For the reason accompanying affidavit, plaintiff praise this honorable court may please to appoint the below mentioned commission for local investigation and scheduled A property. Where is that order?
At page number 54, my lords, relevant portion.
What is the reason given by that?
Ali, before coming to the court, I would have got a competent authority survey, or I would have tried after filing up the suit, which is impossible, my lord. Once the matter is precipitated before the trial court, no officers will come forward and they are seriously contesting this matter.
That is what that you are asking, that commissioner has to be demarcating that property.
No, my lords. Actually, what exact that I have produced a document, my lords.
This is how, now that you are saying that identification of the properties is difficult. Which properties is, there is large extent of property. Then it should be, POD has to be done by that revenue authority. That should be done before filing the suit. Now by in the guise of the suit, you want to get it, POD that property.
No, my lords, no, my lords.
That is what you want to do.
That is not the intention of filing this application.
No, see, if everything is there, POD is there, property identification is there, A has encroached B property, then commissioner has to go and see that These are all, everything is there available, whether he encroached or not. That is the only duty to the commissioner. He can't survey, demarcate saying that this is your property. This is nothing but you are asking in revenue authorities to do that.
No, my lords, that
Under
is-
Land Revenue Act.
ಏನಾಗಿದೆ, ದಿಸ್ ಕಮ್ಸ್ ಬಿಫೋರ್ ಕೌನ್ಸಿಲ್ ಮ್ಯಾಮ್. ಅಲ್ಲಿ ಲ್ಯಾಂಡ್ ರೆವಿನ್ಯೂ ಅಥಾರಿಟೀಸ್ಗೆ ಹೇಳಿದ್ರೆ ಅದಾಲೆ ಕಾರ್ಪೊರೇಷನ್ ಆಗೋಗಿದೆ, ಅಲ್ಲಿ ನೋಡಿ ಅಂತಾರೆ.
ಅದೇ ಅದಕ್ಕೆ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು. ಲಾ ಪ್ರಕಾರ ನಿಮಗೆ ಡಿಮಾರ್ಕೇಶನ್ ಮಾಡ್ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ರಿಟ್ ಹಾಕ್ಬೇಕು, ಡೈರೆಕ್ಷನ್ಸ್ ಕೇಳಬೇಕು. ನಾಟ್ ದಟ್ ಅಪಾಯಿಂಟಿಂಗ್ ಎ ಕಮಿಷನರ್ ಇನ್ ದ ಸೂಟ್, you get it sort out your problem.
Because it's a comprehensive suit that I filed, my lord.
No,
If at all it was an injunction suit, or otherwise this would have been different. Your title is an issue.
No, comprehensive suit for declarations also, identification of the property.
That is also part-
Demarcation ಇದ್ದಾಗ ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ನಿಮಗೆ you should know specifically when you come to the court for declaration, this is my suit schedule property. If others has encroached that, then commissioner can be appointed whether there is an encroachment or not. Identification ಹೇಳ್ತಿದ್ಮೇಲೆ ಕಮಿಷನರ್ ಯಾವ್ದನ್ನು ಅಂತ ಹುಡುಕ್ತಾರೆ, which is the suit schedule property. He has to now demarcate, this is your property pursuant to the sale deed. Then he has to demark his property. Then he has to say that. That cannot be done by that commissioner.
Because of the absence
Mr.
of the sketch, my lord.
Lord, it's a case of Lord troubling a purchaser, Lord, by the plaintiff. The learned trial judge rightly understood. Now, my lord, what has happened is, his sale deed, my lord, exhibit D5, he has released the property on 27th February 1974, as per exhibit D5. He takes a petrol bunk to his share, my lord. The total area shown as 10,500 square feet. Now, he shows his area in the suit as 11,500 square feet. Based on that, my lord, excess area, he is claiming I have encroached. Now, my lord, his case is, this petrol bunk is in existence from 1974. Your lordship, see, 50 years.
Yes.
PW1 in the cross-examination admits they have constructed compound wall around this petrol bunk. So, my lord, for 50 years, they have let it out, my lord, to HPCL. So, he takes to his share this petrol bunk and releases other property to his brothers. He is asking some area, my lord, beyond this petrol bunk. Beyond this petrol bunk on the western side, sold to my client. He applied for license in year 2000. Then, and has raised the pillars in the first floor. At this stage, he filed his suit, says there is something encroachment beyond my compound wall, and obtains stay. These questions are asked not in the cross-examination. He admits in the cross-examination for 35 HPCL petrol bunk,
yes,
wall between my property and beyond my property. In none of these lease deeds are not described any property beyond compound wall as that of mine. The questions, my lord, asked in the cross-examination suit, my lord, deliberately manufactured to trouble the defendant.
Yes.
Now, my lord, P1 to P26 is marked. Exhibit D1 to D32 is marked. PW1 was examined, his cross-examination is over. In encroachment suits, my lord, if there is doubt, one should start at the beginning, file an application and get it fixed so that parties can lead evidence. The commissioner's report is wrong. Now, his evidence shows, my lord, he is asking without
No,
title.
commissioner report is wrong, can be available even now also. There is no such, that is not that. Even after filing the commissioner report, you can be.
I can
My
file
question is
objections.
whether
I can file
commissioner can
objections,
be
but I
appointed.
can't lead evidence. My lord, what happens is,
You can
I
do
can
it.
again, my lord, it has to be reopened.
Yes, yes.
My construction has to remain like that.
That
My-
is, earlier,
Yeah.
some of the judgment said that commissioner seek for an appointment only after the evidence.
Yes.
Now that court said that at any time.
Right, my lord, that is not a blanket, my lord, license. Now, my lord, courts are very cautious. The words used is court may. So discretion is there. Discretion has to be, my lord, judiciously to be exercised. Now, my lord, keeping quiet till you examine yourself, you are cross-examined, unfavorable admissions come.
No, all that now in view of the new judgment, that can be done. Only thing is that
No, no,
what he
time
has
is not a
explained.
factor, my lord. Time alone is not a factor, my lord. Time alone is not a factor. It is one factor which I am telling, my lord, before the honorable court. That is all. In the circumstance of the case.
No, have you seen that latest judgment? Justice Hegde's judgment.
Arun Kumar Hegde.
You go through that and see.
I have not.
See,
gone
there
through
is
that.
no, see, even if it is in a collection for the evidence, it can be done it. If it is helpful for the court, it can, only thing is that he has, the way he has explained, to that effect, I don't think commissioner can be appointed to, he has to fix his property. If it is property already fixed, there is an encroachment, then commissioner can be appointed.
correct,
You go through that judgment.
Correct.
It is there. We will have it on Monday.
Please.
The Monday itself is posted for argument there. Let them say that they should not.
Today, don't precipitate that matter.
We will argument and judgments, my lord, again another 6 months minimum. Nothing
Monday,
to worry.
yes,
My
Monday,
lord,
let us-
has nothing to worry about.
Yes, let us see on that.
Last
Monday.
time press
Yes.
ಮಾಡಿದ್ರು ಅದಕ್ಕೆ.
Yes, Monday, please, at the request of respondent.
Serial number 13, Rajeshwara PN for petitioner, V. Ravi Prakash, Abhinav.
Defendant number 7 in the suit, my lords, is challenging the order for clubbing the suits, my lords, passed in my absence. Let's kindly see the order, my lords, at page
What
20.
are the suits?
Lords, OS number 500 of 2016 is for declaration by 12th defendant on the basis of a confirmation deed. OS number 712 of 2020 is a suit for declaration filed by the son of the defendant number 12 for declaration that he is the owner of the property based on the will. Then, my lords, plaintiffs number 1 and 2 have filed the suit 350 on the ground that as a joint family property, they're entitled to a share.
Which is that earlier, OS number?
500, man.
500 is filed by your client.
2006, no. File defendant number 12 in the present case.
Defendant number 12.
Please, my lord.
This suit is for?
Declaration and injunction.
Declaration.
And respect of 2 items of property.
Yes, what is that other suit?
That's OS number 712 of 2020 is filed by the son of defendant number 12, again for declaration and injunction.
Yes.
Based on will. Those 2 suits, I am the party. The the others are not parties.
No, that
property. Only I am the
you are that
defendant in both the suits. I am the defendant in both the suits.
What is your claim?
My claim is I am the owner of the property.
What is the relationship between that?
Relationship, lords, they are not related to us. Of course, ತಾಯಿ ಕಡೆಯಿಂದ ಹಿಂದೆ ಹೋದ್ರೆ ಎಲ್ಲ ಒಂದು ರಿಲೇಶನ್ಶಿಪ್ ಬರುತ್ತೆ. Our cases, they are not members of our family.
No, that what is your sources of title to that property?
The title is our forefathers only.
You are inherited that property.
Yes, yes. Now,
how they are claiming that?
They are claiming based on confirmation deed and will executed by one Akkanamma, who was also a member of our family at one point in time.
No, one of your family member has executed a will. That is their claim.
Please, that is their case.
Yes.
Plus, revenue record proceedings were initiated and all those things. Ultimately, he was
Now
given
that
liberty.
what is that order you are challenging?
Plus, 350, which is the plaint under which we are now concerned, my lords, is a suit filed by the brothers-in-law of the plaintiff in those 2 suits. Oh. The 12th defendant's wife is none other than the sister of plaintiffs 1 and 2 in voice 350. They are saying that this is the joint family property where they have a share in the property. And they've had 1 more property, so 3 properties. So this is their case, my lords. 2016 is that suit. This suit is of the year 2020. And that suit, my lords, we have obtained a direction by this honorable court should be disposed of within 1 year, my lords. Kindly see that direction at page 108, my lords. It was 8 years old suit. For one reason or the other, they were taking on adjournment. And the first plaintiff here in my lords also filed an impleading application in that suit. That was rejected. Now the second plaintiff also filed 1 more impleading application again to implead in OS 500.
This is OS number?
500 of 2016, mas. Annexure M. Annexure L.
500.
500, man.
This is filed by that father.
Please, my lords, filed by the father. In this, I got a direction that...
there.
Yes, it was there. So I filed an application for clubbing. Both the suits are clubbed in 2021, my lords. Those 2 suits are clubbed. I have no objection for clubbing of those two suits.
Yes.
Because one by father, one by son, claiming the right in respect of the same property. Father under the confirmation deed, but the son under the will. My lords, this is by the brothers-in-law of the father. Filed a suit for partition in respect of 3 properties. Parties are different.
On the ground that the sisters has a right in that property.
They say that they are also members of the family, they
Yeah.
have a right. That I will contest, my lords, whether
Yeah.
what is their right.
Yes.
Now, my lords, kindly see, my lords, the order at Annexure M, page 110. This honorable court in an earlier occasion, when second plaintiff's impleading application in OS 500 was rejected, he filed a writ petition challenging that order, my lords. Kindly see the operative portion at page 116.
Who has filed this writ petition?
Second petitioner, my lord, second plaintiff in OS 350
Yes, son.
of 2020, not son, my lords, brothers-in-law, one of the brothers-in-law.
Yes.
Plus, first plaintiff is also brother-in-law of the father.
Yes, yes.
Second
Now,
plaintiff
this
is also brother of the father.
third suit.
Third suit, my lords.
Yes.
Here, must the impleading application in OS 500 was challenged, my lords. That was disposed of. It is made clear that any compromise, order, decree, judgment, etc., passed or passed in OS 500 would not be binding upon the petitioner herein, or affect his alleged right, title, and interest of possession, if any, over the suitable property. Liberty is reserved in favor of the petitioner to file an application to club it along with OS number 350 of 2020 before the trial court. It is needless to state that in the event the petitioner files such an application, trial court shall provide an opportunity to the respondent to file objections and dispose of the said application on merits in accordance with law. All rival conditions are left open. Let's kindly see the order, my lords, at page 26 now. I am the 7th defendant in the case, my lords. Kindly see page 26 on 10/1/2025, my lords. Plaintiff is represented. Nowhere my name is reflected as being represented or placed ex parte. D7.
This is filed in which case?
350. Plus, kindly see the order. Instant application has been filed by the counsel for plaintiff to club the present suit with OS 500 of 2016 on the file of this court. In the affidavit, a plaintiff number 2 has stated that the plaintiff has filed the suit
Yes,
for the...
yes, mister. No opportunity has been given. That is the one, because there is specific directions from this court.
The notice has been sent to them. A fixture has been affixed. That's why kindly see the synopsis at page number 5, my lords.
You are not a party in that suit.
I'm a party in the suit. They say that summons is served by way of summons, affixture, and in my absence, they take the order.
In the suit of 2020,
my lords,
service is not yet completed to.
No. Let's kindly see the page 10/1 at page 26. I have not been placed ex parte. Even they say that the summons is served by affixture.
Where is that order sheet, mister, to show that?
Page 26 is the order, my lords, on 10/1/2020.
Order sheet of this 350.
That's what, lords. Page number 26. Sir.
Page number 26 is that
Order. The entire order sheet they are not produced.
Yes, that you have to see when he has been placed ex parte.
My lords, sir, for a moment, page number 5.
Second thing, this court said, after giving an opportunity to all the parties.
Yes, please.
Then it requires to be given opportunity, even if it is an ex parte, then for clubbing, notice has to be given.
Lords, now, may I make one submission? Lords. Now the matter is on 10th. Without, let them appear on that day and make this.
No, we will set aside and direct that to consider this application.
Yes.
We will direct him to appear on that day after hearing that.
Please.
Yes. See, now order has been passed, like in a court suo moto, since parties are similar, then properties are similar, hence disclosure. That may be the reason under 10 they can be do it, but there is a direction from this court to after hearing. That has to be complied.
They did not make use of the opportunity. Alva.
You are appearing for whom?
I am appearing for second respondent in this matter, my lords.
He is the one who filed the application.
He is the one playing.
Who filed the
Yes, others are not. You are appearing for
I am
whom?
for R13.
The father, my lords.
Yes. You file an application for dispensation of notice to others. Yes.
Whether it is placed ex parte or not, doesn't matter.
In this writ
My
petition.
lord, may I just make one submission, my lord? It is not clear whether they have been placed ex parte or they, now that, my lord, whether they have entered, that is also not clear. So, my lord, let them, my lord, place it on record or make it clear.
Produce the
They say that, my lord,
Yeah, where is that? If there is an ex parte, then they have to file an application.
Yes,
for
yes, they have produced the order sheet.
Now you
Entire-
have to say, You are that plaintiff, mister.
Sir.
You know that what has happened in your case.
My lord, sir, the entire order sheet, I am not having the entire order sheet.
Yes, I have produced the order sheet, my lords, now, my lords.
Yes, where is that?
Court of
Yes,
pudding.
called. Your defendant number?
7.
Maneya,
ಮೇಲೆ ಜಾರಿ ಅಂತ ಇದೆ ಸ್ವಾಮಿ.
ಮನೆ ಬಾಡ್ಲಿಗೆ.
ಮೊದಲನೇ ಮಹಡಿನ
It has been affixed ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಬಂದಿದೆ.
ಕೋರ್ಟ್ ಆರ್ಡರ್ ಆಗ್ಬೇಕಲ್ಲ.
accept ಮಾಡಿ I should be placed ex parte or at least a date should be fixed for my appearance.
So, my lord, 10th, we will see, my lord, what, as to the nature of, my lord, what the court may pass an order on 10th. Thereafter, my lord, my learned friend would get an opportunity, my lord, to contest the
No, that
application.
now you go through the order sheet and make out whether notice has been served to him or not. If it
First,
is
we will
placed
have
an
to
ex parte,
ascertain.
then different thing.
Yes, my lord. Otherwise, my
Otherwise,
lord,
we have to
maintaining
ask
this
them-
writ itself will not arise at all.
Yes. No,
First-
that if it is placed an ex parte, then this court has passed an order. After that ex parte order, then he has to be heard in view of this court directions.
Only if he has been placed ex parte, my lord.
No, two things.
Even if I am not placed ex parte, I should be heard, my lords.
Even if
Even
it is
if I am
not an
placed
ex
ex parte, I
parte,
should be
there
heard.
is no problem, he has to be heard. Even if he has been a placed ex parte before 27th March 2024, in view of the directions of this court, he has to be heard.
That is true, my lord. If he has been, so therefore, first that has to be ascertained is my respectful submission, my lord. That is not clear from the order.
Then, yes, we'll stay that further proceedings.
ಅಲ್ಲ,
My lord.
further proceedings stay ಆಗತ್ತೆ ಬೇಡ ಸ್ವಾಮಿ. It may be disposed of.
No, now that we don't know that whether it is ex parte or not.
No, my lords, they concede,
Let them appear.
they concede that I must be heard in the matter and they say that no order be passed by my lords.
My submission, because I am contesting in that matter, it may be, order may be set aside and let them appear on the 10th. That is the hearing date. Let this application be heard, my lords.
Yes. This petition is filed by defendant number 7. Challenging order dated 10/1/2025 passed by Additional Senior Civil Judge JMFC Devnalli in OS number 350 of 2020 on IA number 4 filed under section 10, section 151 of CPC, seeking for clubbing of OS number 500 of 2016 and OS number 712 of 2020 with OS number 350 of 2020. The said application has been allowed, being agreed by the same. The defendant number 7 before this court. In earlier round of litigation, this court in WP number 6051 of 2024 disposed of on 27th March 2024. 27/3/2024. Yes. Liberty was being reserved to respondent number 2 herein to file an application to club the above said suit and also made it clear that if such a application is filed, the trial court is directed shall provide an opportunity to the respondent to file an objection and dispose of the said application on merit accordance with law. The impugn order dated 10/1/2025 doesn't disclose that respondent in that suit has been heard. Respondent and petitioner herein. Petitioner respondent herein has been heard before That I am saying that only in respect of this application. What I have to consider that I have to see that records whether it is placed on ex parte or not. You said that this order has to be. You have to be say whether it is in ex parte or not. Now only in this case is concerned. Court said after hearing, by going through this order, it doesn't disclose that he has been heard. That is what that. Otherwise, you verify and see that records, make a submission. Till then, don't proceed with the matter. Yes, doesn't disclose that the petitioner defendant has been heard before passing impugn order. The learned counsel for the petitioner also submitted that defendant number 3 to 6 ನೀವು ಎಷ್ಟು 3 to 6 8 to 10 ex parte ಅಂತ ಬರ್ದಿದ್ದಾರೆ ಅದರಲ್ಲಿ 7 ಇಲ್ಲ ಮತ್ತೆ yes respondent number counsel appearing for the petitioner also submitted that no notice has been served in the suit to the petitioner defendant. In view of the above, since this court has specifically directed in WP number 6051 of 2024 that application has to be considered after providing opportunity to all the respondents. The same has not been complied. On that ground itself, the impugn order has to be set aside. Accordingly, the order dated so and so is set aside. The trial court is directed to reconsider that application in compliance of order passed by this court in so and so. Yes. Yes. That learned counsel for the petitioner has submitted that next date of hearing, he will appear without any further notice in the suit.
Cell number 14, Arati B.
Yes.
Lord, I'm the plaintiff in the trial court and the suit is for declaration and injunction, my lord. My lord, in this particular case, I have filed IA number 3 and 4. IA 3 is not to further alienate my property. Suit for declaration and injunction, my lord. And IA number 4 is for to stop the construction which the defendants are putting up, my lord. My lord, this particular IA was filed in the month of 12/9/2024, my lord. Subsequently, my lord, the defendants also filed their objections. And in the objections, they told they can adopt the written statement as objections to this IA number 3 and 4. And the matter was also argued between us, my lord, the plaintiff as well as the defendant. Subsequently, after that as well, my lord, the trial court did not post the matter for order. While there is urgency, my lord, I have advanced this matter twice to show the photographs of progress of construction. From the time we have been asking the at least status quo in this particular case, it was only in foundation.
Defendant number 1 to 3 filed in a memo stating written statement of adopted as an objection to the IA 3 and 4 according to adopted consecutive present heard 3 on his side. For argument on 25/11/2024.
Yes, they argued, my lord. Subsequently, the defendant also argued that particular matter.
After that, what has happened?
After that, the matter has not been posted for orders at all. And again, we filed memo, my lord.
No, madam. Order sheet alli next date ಏನು ಕೊಟ್ಟಿದ್ದಾರೆ?
My lord, counsel for plaintiff and defendant present. Then it came to
the argument on IA and plaintiff and defendant. Call on 6/1/2025.
Yes,
16/1/2025 ಏನಾಯ್ತು?
ಏನು ಆಗಿಲ್ಲ, my lord. It is just call on. After that, it's going on. I'm just producing it's going on to call on only, my lord. And in the last date of hearing, they came and filed the written arguments, my lord,
For what?
on the IA itself, my lord, IA 3 and 4.
Next hearing date,
Next
93
is
na?
19.3. Yes, my lord.
Yes.
Lord, here we have filed number of memos to show the progress of now the construction has crossed
Ex
the.
parte entry.
No, my lord, no
Yes.
ex parte.
In this writ petition, petitioner sought only direction to the trial court to dispose of the IA number 3 and 4 filed by the petitioner plaintiff in OS number 3429 of 2023 as expeditiously as possible. Petitioner plaintiff has filed a suit for declaration. Along with the suit, has filed an IA number 3 under Order 39, Rule 1 and 2 for not to for direction to the defendant to not to first one is not to alienate the suit scheduled property, and IA number 4 seeking a direction to the defendant restraining the defendant to not to put up the construction, put up any construction on the suit scheduled property. Trial court has refused to, learned counsel for the petitioner submission, refused to grant ex parte injunction order. Even after appearance of the parties, the defendant has filed a written objection to the IA. Matter has been heard. Since no order has been passed, therefore, the petitioner is before this court to seek direction to dispose of IA number 3 and 4 in view of the above, without expressing any opinion on the merit of the case. Court is directed to dispose.
Yes.
Yes.
My lord, in this D4 is placed ex parte. My lord, there are 4 defendants and 4 was D4.
Pass order it. Yes.
Yes.
Serial number 15. Banu Prakash HV.
In view of that, service of notice to respondent is not necessary. Mail account. In view of the prior. Yes. Serial number? No, this is with serial number?
15, 7 with the.
Yes. 15. Yes. What is this, Mr.? Where is that this thing direction? What is the direction? Suit for eviction.
3261 is sir.
Yes. Annexure G. Page number 78. 78. What is that direction? Recovery of arrears of rent 37 lakhs. Where is that agreement? You can say that he has sold it also by oral. How can it? You have put up in a construction and saying that it is an oral. That in where? It's in Bangalore. Okay. You have put up a construction, it is different, but where is that he said he is not ready to pay that rent? Hmm. Hmm. When you have filed in a suit? February 2024. When they have handed over the key? June. 3 months, there is a break. What about that other areas, Mr.? No, you would have challenged that. What is that in the criminal case? No, who has restrained him to go into that this thing? Is there any court order? Then what to do? No, Mister. This is arrears from when? 22. This litigation is 24. 22. There was a rent for 2 lakhs per month. If you are not paid, how that, Mr. Owner will survive? Yes. No. 22, 23. What are you doing that? They are saying that the obstruction in 24. Who, without his consent, if you are put up in a construction, again it is burden more for him to demolish all these things. No, all that, Mr. It is in Bangalore. Who will construct without the consent, Mr.? You yourself has constructed his own property. You have constructed, you are enjoying everything and all. Now, what is how much you have to be deposited? 12 lakhs. Yes, deposit 12 lakhs. Then we'll stay that striking off. Otherwise, your defense will be strike off. Yes, strike you. They will strike off if you not deposit today. Tell me what that owner has to do now. Your 2 lakhs rupees rent per month, you are not paying. You are using his property. You are putting up in a construction without his consent. He has to force him to come to that court for filing a suit. Then also you are not paying. Either if there is a consent, show me in the writing. It's in Bangalore. You have put up in a construction, commercial. Then without there is a agreement. Can it be believed? These are all, Mr. Yes. In both you take notice. I will not stay. You deposit 10 lakhs tomorrow. Yes. No. Tomorrow is the judgment. If you deposit tomorrow, then I will stay there. Yes, tomorrow 10 lakhs you deposit. Huh? No, Mr. No, Mr. You deposit. No, you will give 2 weeks if you deposit 12 lakhs. Then you will stay in both that. Yes. Yes. Stay up. Yes, no, 15.
15 and 7.
15, 3261.
Sir. 3261 15.
Yes.
556.
Stay of order dated. 9/12/2024. petitioner has to deposit 12 lakhs. Has to deposit 6 lakhs on our so and so order is stayed. ಇಲ್ದ್ರಲ್ಲಿ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು? Yes. In view of that order passed by this court in WP number so and so. The order dated 4/2/2025 passed on IA number 3 filed in OS number 982 of 2024 on the file of '83rd Additional City Seal and Session Judge is stayed till first April. Lease this matter until 2nd April. Lease this matter on 1st. Yes. On that day, if you are not, then both the case will be this.
Serial number 16, SP Totar.
For getting included as plaintiff number 3. The trial court has allowed the application even without objection based on the no objection from the plaintiff 1 and 2. The trial court has allowed the application.
No, he is a subsequent purchaser. After suit is of the year. ಆಯ್ತು ನಿಮ್ಮ what is your defense in the suit? No, that the subsequent purchaser will steps into the shoes of that. Where is that? No, his amendment is allowed. Where is that? Where is that now? What is that number? Yes, call this matter along with that so and so. You want? Not tomorrow. For
now, the application has been allowed and it has been kept for amendment of that.
ಆಯ್ತು ಮಾಡ್ಲಿ, ಸಟಸೈಡ್ ಮಾಡಿದ್ರೆ ಹೋಗುತ್ತೆ ಅಷ್ಟ ಇನ್ನೇನು. Yes. ಆಯ್ತು ನೋಡೋಣ, ಅದ್ ಬರ್ಲಿ 4th. Yes.
Serial number 17 adjourned. Serial number 18 Indu Shekhar BT for petitioner Madhukar Deshpande.
I appear for the respondents, madam.
Yes, mister, what is this?
Well, I initiated a proceedings before the small causes court for eviction. So my learned friend has filed an application saying that the rent is less than 3,500.
Less than?
Less than 3,000. Rent is 2,000. So the
rent is 2,000.
So it doesn't come under the.
No, what is that? This thing, property size.
Size is a residential property, my lord.
Commercial property.
Residential.
Yes, residential property. If it is 3,500 below.
Below his contention is below 3,500.
Below 3,500, it has to be small cause court.
No, rent act is applicable. My lord, the case is pending before the small causes court only. It is a case of my learned friend, the suit is not maintainable. It is HRC has to be initiated, my lord.
No, if it is rent is less than 3,500, it has to go to that civil court.
No.
It has to some small cause court.
Small causes court, it will be nominated as HRC, my lord.
That will be decided. Now your case is that if it is
If my learned friend could use the mic, my lord, I can hear, my lord.
Mic on. Yes. What a small cause.
Mic on ಮಾಡಿ.
Act. Which is that
section 2 of the Karnataka Rent Act. Application of the Act.
Yes.
To E, my lord.
Yes. To any premises.
To any premises deemed rent on the date of commencement of this act or the standard rent of which exceeds 3,500 rupees, then the Karnataka Rent Act is not up. Any rent which is less than 3,500, it is the rent tax.
Specified chapters, nothing contained this act shall apply. Yes, Mr.
My lord, kindly see the explanation, my lord, further. What is the deemed rent? Explanation. Deemed rent on the date of the commencement of this act shall be the rent calculated in the manner provided in section 7, together with revisions, if any, as provided in section 9, and decreased in the case of premises constructed after the commencement of this act at the same date as enhancements printed in the third schedule to reflect the position on the date of commencement of this act. So, my lord, under section 7, it has
in
to
case
be
of premises constructed. No, this is not constructed after the commencement.
No, it is about
This is before.
his case is that
what is that section?
Section 7. Section 7 lays down how standard rent has to be calculated, my lord. Section 6 says rent payable in relation to premises shall be, my lord, one is rent agreed between
Standard rent in relation to the any premises shall be rent calculated on the basis of the 10% per annum of the aggregated amount of the cost of the construction and the market price of the land comprising in the premises on the date of commencement of the construction. Standard rent calculated as aforesaid shall be enhanced in the manner provided in the third schedule. Now, it is not that rent admissible, Mr.
Yes, my lord. Yes,
standard rent has to be calculated under.
Howdu. Ad certain ಮಾಡಬೇಕು. Standard rent,
the premises
even section 6 also, my lords can see, my lord.
Deemed rent on the date of the commencement of this shall be rent calculated because all rent has to be calculated on the date of the act came into the force.
Howdu. These things have to be collected.
ನೀವು ಅವ್ರ agreed rent ಅಲ್ಲ.
Para 6 of the plain terminal. As if I was inducted into the premises just about 2 years back, and a monthly rent of rupees 2,000.
No, what is that deemed rent has been explained here, Mr.
ಅವ್ರು ಏನು ಹೇಳಲ್ಲ 2,000 rupees rent ಇಂಡಕ್ಟ್ ಮಾಡಿದ್ರು.
ಅವ್ರು ಹೇಳೋದಲ್ರಿ ಕಾನೂನು ಏನ್ ಹೇಳ್ತಿದೆ ಅಂತ ನಾನು ಕೇಳ್ತಾ ಇರೋದು ನಿಮ್ಮನ್ನ.
ಕಾನೂನು ಏನು ಸ್ಟ್ಯಾಂಡರ್ಡ್ ರೆಂಟ್ ಅಂದ್ರೆ ಅವರ in relation to any premises shall be the rent calculated on the basis of 10% per annum of the agreed
to any premises deemed rent on the date of the commencement of the act, rent of which exceeding 3,000 rupees, 3,500 rupees per month in any 3,500 rupees, not on that amount you have agreed. You have to be calculated as per that section 7.
ಹೇಳಬೇಕಂತ ಅವ್ರ ಪ್ರಕಾರ
section 7 ಅಲ್ಲಿ
kindly turn to para 6 of the plain.
Section 7 ಅಲ್ಲಿ you see that section 7 how it has to be calculated.
ಅದು ಅವರು ಹೇಳ್ಕೊಂಡು ಬರ್ಬೇಕು ಅದನ್ನ. ಈಗ ಅವ್ರ ಪ್ರಕಾರ just 2 years prior to the filing of the suit.
No, according to you, what is that value of standard rent as per section 7, Mr.?
ಅಲ್ಲ ನಾನು ಇಲ್ವೇ it is my property. It is my property. Fraudulently created the document.
Now, Mr. Counsel, you read section 7.
Please, my lord, if I were to be a tenant, then question of applying this provision would arise. Standard rent ಏನು ಎಷ್ಟು ಬರುತ್ತೆ construction ಏನು ಅಂತ. I am not a tenant at all.
ಅದಕ್ಕೆ
No, it is my property.
ಆಯ್ತ್ರಿ ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಆದ್ರೂ ಟು ಅಪ್ಲೈ ದಿಸ್ ಪ್ರಾವಿಷನ್ ದಿಸ್ ಇಸ್ ದ ಲಾ ಮಿಸ್ಟರ್.
Correct. Our ಪ್ರಕಾರ it is according to the plaintiff. Rate of rent was.
This Karnataka Rent Act says not according to you, not according to him. It says according to 7. It is not admissible rent, Mr. 7 says how it has to be calculated. You have to be
It is the plaintiff who has to say that, but nowhere he has stated so. It is at para 6 of the plaintiff. Your Lordship kindly peruse para 6 of the plaintiff.
per annum of the aggregated amount of the cost of the construction and market value of the land. You have to be calculated on the basis of the market.
ಅವ್ರು ಹೇಳ್ಬೇಕು ಅವರು ನಾನು ಟೆನೆಂಟ್ ಅಂತ ಅವರು ಹೋಗಿರೋದು.
Yes, Mr. What is that standard rent?
ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಅದು. ನಾನು ಯಾಕಂದ್ರೆ it is my property.
May I request my lord to
my
kindly.
property. Title is in dispute. Even assuming for a moment that the small cast court has got no jurisdiction.
Construction rate to owner ಹೇಳ್ತಾರ tenant ಹೇಳ್ತಾರ. What is this?
ಅಲ್ಲ ನಾನು ಓನರ್, ನಾನೇ ಓನರಾ? ನನ್ನ ಟೆನೆಂಟ್ ನಾನೇ ಓನರಾ? Your Lordship may.
Yes, Mr. It is very difficult, Mr. Yes.
ಅಲ್ಲ ಹಾಗೆ.
May I request kindly to 2F, my lord, once for a minute, my lord. 2F. 2F, my lord.
Your Lordship kindly.
ಆಯ್ತು ಬಿಡ್ರಿ, ನೀವೇನು ಹೇಳೋದಿಲ್ಲ ಅಂದ್ಮೇಲೆ ಸುಮ್ಮನೆ ಇರ್ರಿ.
2F, my lord.
Yes.
To any premises constructed or substantially renovated either before or after the commencement of this act for a period of 15 years from the date of commencement of such construction or substantial renovation. But this act itself is not applicable for a construction for the first 15 years of the construction. Now I kindly request to my lord to peruse page number 32, my lord.
Substantially renovated either before or after the commencement of this act.
For a period of 15 years from the date of commencement.
10% ತಗೊಳ್ಳಿ, 10% ತಗೊಂಡ್ರು 2 years ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತಾರೆ. ಅಲ್ಲಕ್ಕೆ ತಕೊಂಡ್ರು ಎಷ್ಟಾಗುತ್ತೆ? 2400 ಆಗುತ್ತೆ.
Now I request
400 ಆಗುತ್ತೆ 2 ವರ್ಷ ಅಂತ. Para 2, para 6 of the plaintiff, Your Lordship kindly peruse.
ನೀವು
There vendor.
section 7 ಅನ್ನು ಓದ್ಬಿಟ್ಟು ಅದು ಏನು ಅಂತ ಹೇಳಿ. You read section 7 and read.
May I read it?
Yes, read and tell.
Standard rent in relation to any premises shall be the rent calculated on the basis of 10% per annum of the aggregate amount of cost of construction and the market price of the land comprised in the premises on the date of commencement of the construction, provided that the standard rent calculated as aforesaid shall be enhanced in the manner provided in third schedule. They have to go before the rent controller for calculating this rate of rent, provided they are able to prove that there was a relationship of land.
All that can be proved before the court. Then the court can come to and decide that whether it is.
Yes, my lord. That is my respectful submission, my lord.
Now it has to be decided based on the plaint governments. Plaint governments are para 6 of the plaint is very clear. That the rate of rent is 2,000 rupees. According to the plaintiff, these petitioners were inducted just about 2 years back by his vendors.
Yes.
Your Lordship kindly peruse para 6 of the plaint, which is at page 23.
No, you show me any judgment that provision has to be applicable, applied on the basis of that rent admissible by the parties. You have got it.
ನಾನು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿಲ್ವಲ್ಲ ನಾನು, ಯಾಕಂದ್ರೆ it is my property is mine. Property is mine. I have not admitted.
Is this matter next week? ನೋಡೋಣ, ನನ್ನ ಅದೃಷ್ಟಕ್ಕೆ ಏನಾದ್ರು ರೋಸ್ಟ್ ಚೇಂಜ್ ಆದ್ರೆ.
ಅಲ್ಲ ಕೇಸ್ ಇವತ್ತೇ ಇದೆ.
Yes. This is
kindly.
No, Mr.
ಅಲ್ಲಿ ಡೇ ಟು ಡೇ ಹಾಕೊಳ್ತಾ ಇದ್ದಾರೆ.
No, it's have it on Tuesday. Yes.
Tuesday, Wednesday.
Yes, Wednesday. Yes.
Serial number 19, Okkun Sonatai.
Appearing for the petitioner, my lord.
Yes.
My lord, the petitioner is the owner of a property. The approach and the reason I have approached this honorable court is for seeking directions that the matter may be disposed of in 3 months if this honorable court may direct the learned civil court to dispose the matter in 3 months.
Yes.
The reason being this, my lord, that if your lordship may kindly look into page number 80 of the petition, there is a rental and default agreement, my lord, where
Suit for
my lord, this is regarding OS 3322 filed by the respondent. The suit is for injunction.
yes.
I am the owner, they are the tenants. They have gone
Yes.
ahead and filed this suit for injunction. There is a rental and default agreement which is a part of this, my lord, which can be found at page number 80. My lord, it is the
What is that order we are challenging, madam?
not challenging any specific order. I
Hmm,
am
then-
here before this honorable court seeking directions that that the entire suit may be disposed of in 3 months, because I have lost my husband in the last
Yes,
4
yes,
months.
you
I have
take
lost-
notice, yes, issue emergent notice. In addition, petitioner is also permitted to serve a copy on the counsel appearing for the respondent before the trial court.
My lord, the
Number
same,
20,
my
Madhu
lord, a
MP.
civil
Yes.
matter is at 29, my lord.
My lords.
No, you serve a copy and move that matter. Yes,
Very well, my lord. Much obliged.
yes.
Petitioner in this case, my lords, may I request, maybe have it next week, my lords.
Serial number?
20, my lords.
Yes, sir. The request of counsel for the petitioner. Leave this matter next week.
Bill number 21, SP toted for petitioner V. Ramesh Babu.
Petition, my lord. This matter, my lord, arises out of but when Sushila, my lord, was the petitioner, lord, is not binding, was a relief sought.
Suit for not to.
Cancellation of sale deed, lord. Lord, the second respondent, my lord, before this honorable court, my lord, claims to be the power of attorney holder of deceased Sushilama. Based on the power of attorney, my lord, he executes the sale deed in favor of the first respondent. That was challenged.
No, Sushilama has filed in a suit for sale deed dated.
Lord, sale
Not,
deed-
where is the prior in the suit?
It was prior to the suit, my lord. Suit was filed in the year 2007.
27. Yes,
Lord, in the meantime,
but permitted to file in a indigent person.
please, she was not permitted.
You are seeking for set asiding that sale deed.
Yes, my lord. Please, my lord.
Your
Please,
relief is to set asiding the.
set aside the sale deed, my lord.
23/12/2004.
4, my lord.
Yes. Now that pendency of that miscellaneous petition, she dead,
She passed away.
passed away. Yes.
And pursuant to which, my lord, the present petitioner before the lordships had filed an application to come on record, claiming himself to be an indigent person. He has no source of payment of court fee.
No, that is true. Sushilama has filed an application as an indigent person.
Please, my lord.
She dead.
She did.
Then
Her son, that is a son, the petitioner before this honorable court, my lord, made an application to come on record. He too claiming himself to be an indigent person. 3 installments, 3 applications were filed. 122 rule 3 was filed, my lord.
yes, then what has happened to that?
All the 3 applications dismissed, my lord. 2 applications were dismissed without considering an application for setting aside the abatement.
Now, why it is dismissed?
Dismissed solely on the ground, my lord, no application is filed for setting aside the abatement. Could your lordships kindly turn to page, my lord, where a specific order is passed in this regard, my lord, could your lordships
Page?
shall.
Why that? What has happened? This court from so many date matter has been urged.
Originally filed as a miscellaneous first appeal, then converted into a RFA, then into
then-
CRP and finally.
Yes, yes. Yes, why it is, where is that impure order, Mr.?
Lord, impure order annexed H, my lord, page number 53.
Why it is dismissed?
Could your lordships kindly turn to page number 57, my lord?
Yes.
Well, para 9, page number 57 may kindly be seen. It says, if your lordships permit, I may be permitted to read.
Yes.
Lord, kindly appreciate. IA number 1.
Lapse of 8 months.
Please. IA number 1 filed on order 22 Regulation 151 CPC on 15/11/2007. After a lapse of 8 months from the date of death of the petitioner, and IA number 2 under section 5 of the Limitation Act is filed on 8/7/2008. That is after 8 months from the date of filing of the IA. in the affidavit filed by the application in support of the IA number 2, simply
Yes,
it
we
is,
will permit him to file an application for abatement, set aside that abatement delay and
Lord, even that application is filed. Sorry, please wait. And even that application is filed, my lord, but unfortunately, the learned judge says, my lord, the application itself is not filed. That application was filed
all three application has
All-
been filed.
on different dates.
Yes.
Could your lordships kindly turn to,
Where is that?
I shall produce. It was filed as IA number 4. Lordships get at page number 49, my lord.
49.
49.
Yes.
Even though, my lord, the provision was wrong, but the prayers were intact. Prayer says, my lord,
To permit that to set aside that abatement.
abatement
This is IA number?
4.
Then.
My lord, this was filed on 28/10/2010.
No, where is that IA for condonation of delay and
My lord, that application, my lord, is at page number 36, my lord, I'm sorry, 35, 33, I'm sorry. Lord, IA number 2 was page number 33, is page number 33.
33?
33 where, Lord, my relief is for
Application 5.
under section 5 of the Limitation Act.
Consider this amend affidavit in order to condone the delay in furnishing the LR application. Yes.
Lord, page number 31 is my application for bringing me on record as an LR.
Yes, Mr.
Correct. Two questions. After all this, by what was read out to your lordship, that page 53 order method. That was the application rejecting all these applications. That was the order rejecting all these applications. This order was sought to be reviewed by another review petition, review application dated 18/7/2014 at page 64. Now that is also dismissed. They have already availed a remedy against that order, that is also dismissed. Now that review order is what is under challenge before your lordship. Now one question which will arise for consideration is whether an LR can also maintain. The legal position, there is no dispute that the LR can maintain, provided the LR is also an indigent person.
No, he has to again prove.
Please.
Now, first he has to come on record.
That may not, because even according to the judgment cited by them, they rely on AR 1952. The LR must prove that the LR is also indigent. If the LR is also, therefore there has to be an inquiry as to the indigency or financial capacity of this petitioner.
No, even if he's come on record, then that application will be.
No, my lord, because the position is the right to sue as an indigent is a personal cause of action. That has died with the original petitioner. The LR has two options. If the LR is financially capable, then the only remedy available to the LR is to
Pay the court
suit by paying court fee.
No, see, two things. If it is sufficiently as an source, he can pay that court fee and continue that suit. Or in this miscellaneous case, he has to establish that I'm a pauper.
Only then the LR application can be allowed, because otherwise an LR does not get a right to be an LR unless the LR himself is a pauper.
No,
that is the position, my lord.
No, where is that? No, that is not that.
Kindly see, in fact, the impugned order also refers
No,
to.
where is that judgment?
The impugned order refers to page 15.
No, impugned order is wrong. Therefore, they are coming.
It refers to a
Judgment. Yes.
Page
Sure,
15.
Page
59.
Yes. Yes.
In that portion, my lord, it is extracted. The right to sue as a pauper, what is extracted, I am reading. The right to sue as a pauper is a personal right which dies with the plaintiff. It follows that the legal representative should not be permitted to continue the suit unless he pays the court fee or establishes that he himself is also a pauper. That establishment that he is a pauper can only be on an inquiry. Your lordship may set aside these orders and direct the trial court to make an inquiry. There is another aspect, my lord.
No, how without he is in a party and without application, there cannot be inquiry.
Application is filed. An application is there. Application to bring on record is admittedly there. There is no dispute. I cannot dispute. It's a matter of record. That on 15/11/2007, this LR.
No, you are saying that first inquiry, then impleading.
Because the right to continue this proceeding, that is this order 33 proceeding, is dependent on the financial capacity of the LR. That the LR can establish. I will have a right to cross-examine also in terms of order 33 rule 5. And
Yes, Mr. Is there any other way of that judgment?
Lord, kindly. Can I?
No, either way.
Could your lordships
Let us
kindly
see
turn
which
to
is that correct position of law?
Lord, kindly turn to page number 61, my lord.
In 61, even before the order could be passed, subsequent to it, my lord, I have already filed an affidavit saying that in form
No,
of.
he's saying that first inquiry has to be done.
No, my lord. That cannot be the law, because if not to permit me.
That's what I am asking, that what is the law first?
She'll give you a copy.
See, ultimately, both are coming to the same point. But how it has to be proceeded is.
Is there inquiry first or?
No, my lord. He has to be brought on record. Subsequently, only inquiry with regard to his pauperis. So kindly turn to my lord, EIR 1962, Mysore, page 47. Would your lordships kindly turn to paragraph number 5, my lord, page 2 that.
Yes.
Lordship, this is what the observations of dishonorable court, my lord, that yes. Your lordships permit me, what it says, that being so, an application presented for permission to sue as an pauper is potential plain and becomes one moment it is granted. If before the application is granted, the application dies, it is not easy to understand why the entire proceedings comes to an end without his legal representative having the right to continue the application presented by the deceased. Further, my lord, it is true that the right to sue as a pauper is a right personal to the person who applied for the permission to sue in that way. But to say that it is not the same thing as saying that because the right is a personal right, the entire proceedings come to an end and the lapse the moment the application dies. The right to claim the reliefs specified in the application, which would become the plain if the application for the permission to sue as a pauper was granted, is a right which undoubtedly devolved on the legal representatives of the deceased applicant, since the right to claim the other relief is not a personal right. Further, my lord, that being the position, when the applicant who sues for permission to sue as a pauper dies, his legal representatives have no right to contend that they are themselves not paupers. They should be accorded a permission for which the deceased had applied. It is clear that they would not take the advantage of the pauperism of the deceased and claim to sue as a pauper in the place of the deceased if they themselves are not paupers and had sufficient means to pay the court fee. Precisely, but further. But it would be open to the legal representative ask the court to bring them on record as legal representative of the deceased and to prosecute the proceedings. Lord, I pause here for a moment, Lord, and respect to it. With due respect to my learned friend, I submit. Lord, pauperism is totally different from me coming on record as a legal representative.
No, you see, once that person claiming in a pauper is dead,
please,
it's end of the matter. Your right, court said, your right for the LRs will be survive if you prove that you are in a pauper. Then you can be.
Well,
here also, if you read that, that shows that first it has to be determined.
Please, my lord, if my endeavor and persuasion, my lord, please set aside, please, all these orders. I may be permitted to enter the witness box and say, my lord, I am a pauper.
That's what
that has already been done. That has already been done, my lord.
No. She has given a judgment that Justice Venugopal. You have that copy?
Judgment of 2011.
No, Justice Venugopal God.
Please.
2011 has.
That is even that was I
Yes, you have. Yes,
I have
yes,
the copy.
It is there. Yes.
It refers to this 1962 also.
Yes. What is that in that judgment said?
The other thing is state is deemed to be a party. State was not made a respondent. The trial court state has.
Curable.
Ali, again, then they have to ask
Give a
the
report.
but Tahsildar to get in a report and then affidavit from the registrar.
Your lordships kindly turn to paragraph number 14, my lord. Last page number 14. Para 14. Sorry.
Yes.
May I?
Yes, please.
There is no dispute that the petitioners are the wife and children of deceased R.V. Revanna. Their application to come on record as a legal representative of the deceased petitioner having been filed within the prescribed period and a suit having been instituted claiming right over the immovable property, the right to sue having survived ought to have been allowed and they ought to have been granted reasonable time to pay the court fee of rupees 86 also in terms of the valuation slip. If they have also applied to continue the proceedings as an indigent person, the same ought to have been inquired into and a decision taken. Furthermore, the order passed impugned herein being otherwise is
ultimately first it has to decide. If you are in a, you have any sources, you can directly implead in the suit and prosecute. That is what that.
Please.
Yes, that.
My respectful submission will be, my lord, set aside these orders and I may be permitted to inquire.
Yes,
because already affidavit is already.
All application is there, let them consider.
Please, my lord.
My right to cross-examine.
Yes. All procedure has to be followed. Yes. This petition is filed by petition is filed under Article 227 of Constitution of India, challenging order dated. What is the date of the order? 18/3.
Two orders have been challenged. One is on 18th of March 2019,
What is that order?
or review order, my lord.
Review.
Review order is on 18th of March 2019.
18/3/2019, whereby review petition filed by the petitioner seeking review of order dated 8/7. What is the order you have?
18/11. 18th of November 2011.
18th of November
2011.
2011.
Annexure
Seeking
H1.
reviewing of 18th of November 2011 has been confirmed. Review petition has been dismissed, whereby application filed by the petitioner for common records as a LR of one Srimati Sushilamma is dismissed. Srimati Sushilamma filed a petition under, where is her application? Property suit
Petition at page
50?
22, my lord. Page number 22, my lord.
22 na?
Outside.
Yes. Filed in a suit under order miscellaneous petition under order 33 rule 1 of CPC seeking a permission to file in a suit as an indigent person. During the pendency of our PMIS number 23 of 2005 was pending before City Civil Judge Bangalore. She died. You know the date?
Please, my lord. Death certificate produced.
8/12?
8/2006.
8/12/2006. Petitioner herein claims to be legal representative of deceased Srimati Sushilamma. Have filed an what are the tie number?
Lord, IN number. Lord, IN number, I'm sorry. IN number 1, 2, and 4.
One is for?
One is for to bring the LAS on record.
Yes.
IN number 2, my lord, is for the condonation of delay.
Yes, set aside. Yes. Filed
IN number 4 is for
IN
setting aside
number
the
1
appointment.
for bringing LRs on record. IN number 2 for condonation of delay in filing an LR application. IN number 4 for set asiding that abatement. The trial court by impugn order has dismissed that application. All three applications dismissed that application on the ground that there is no application has been filed for set asiding that abatement, and also on the ground that before petitioner has to prove that he is an indigent person, he cannot be permitted to come on record as an LR. Since petitioner has already filed an application IN number 4 for setting aside that abatement. The reason given by the trial court for dismissing that IA number IA filed for come on record as a LR of Sushilamma is contrary to that material available on record. On that ground, the order dated so and so and order passed on review also has to be set aside. The trial court is directed to first decide that whether petitioner who is claimed to be LR of Sushilamma, is also an indigent person. The same may be considered after giving an opposition to all the parties in accordance with law. In case, if it is proved that he is also an indigent person, then his application to come on record as an LR has to be considered in accordance with.
Please, your lordship only kindly say, because my lord, the PMIS was filed in the year 2007, my lord. One direction to dispose at least PMIS, my lord, on or before at least about 2 months.
Yes, what is that next date? Date is not given.
No, disposed of.
I will give it, I will give the date. You both of them appear with that.
My lord, for expeditious disposal, I tell your lordship, fixing a date, one factor will have to be taken into consideration. The petitioner is a resident in Tamil Nadu.
No, all that, no,
I will manage.
I am not reporting
I may have to manage.
disposal expeditiously. I will fix the date for hearing.
Please,
Yes. The parties are directed to appear before the trial court on 12th March. 12th March, 18th March, without any further notice.
Please.
The trial court is directed to dispose of that PMIS as expeditiously as possible.
Bill number 22, Chandrakant Paul.
Yes, none appear. Use this matter of 2 weeks.
Bill number 23, Sujayendra Sridhar
For
for
the petitioner,
petitioner,
my lord, in
connected matter.
23.1.
2RATN.
And for the petitioner in 23.1.
Yes. Where is your opponent?
Yeah.
You are there, yes.
But
Who is that Guruvar Reddy?
I'm for the
You are appearing there.
Yes.
Yes. Yes,
but suit for injunction. The subject matter in dispute is a car. The car is a Toyota Innova car of 2017 make. Suit came to be filed in 2019. I am the suit for permanent injunction.
Yes.
I am the defendant in the suit.
You are the defendant.
I am the defendant.
What is that injunction they sought?
The injunction, my lord, is to restrain me from taking possession of the car, which is in their custody. It's a Toyota Innova car. The plaintiff sought for an injunction to restrain me from taking custody of the car from them. Illegally obtaining custody of the car from them. That is the injunction sought by them before the trial.
Who is that owner of the car?
My lord, the owner of the car is one Samba Shiva Murthy. And that fact is not in dispute. He died in 2018.
Yes.
Defendant number, I am the son of the Samba Shiva Murthy Swamiji. And claiming succession, I claim that I have become the owner of the car and the car has
What
to come
about
to
that, who is that plaintiff?
plaintiff, my lord, she is, in the fact of the matter is that this Samba Shiva Murthy Swamiji, he had constructed a temple. It's actually a renowned temple in Kolar district called Kotilingeshwara Swami temple. And he was administering the temple during his lifetime. Her case is that she was a secretary in the temple. And after her death, he had accepted sannyasatva. Therefore, all the properties, including his car, will vest with the deity.
Yes.
And it will come to the temple and she is entitled to use the car is her case.
Now, what is that order you are challenging?
Lord, 2 applications had come to be filed. One application by them for a permanent injunction. And we had filed an application seeking for mandatory injunction.
Yes.
Interim injunction to restrain me was their application. I had sought for an application of interim order of mandatory injunction, directing them to hand over the car to my custody.
Yes.
I had also raised a counterclaim in my written statement for an order of declaration of title as well as for possession of the car. Initially, the trial court rejected my application, which was I number 6, and allowed their application. The reasoning of the trial court was that, my lord, interim mandatory injunction cannot be allowed. An injunction in the nature of interim mandatory injunction cannot be allowed. And the settled position avaratrai the car, because the position is in there with them, it cannot be disturbed in the interim month held. The trial court rejected my application. I had filed 2 appeals, miscellaneous appeals, my lord, challenging their the order granting them injunction and the order refusing an interim mandatory injunction to me. In the appellate court, MA 43 and MA 44, the first appeal, the MA court, my lord, dismissed, allowed my appeal insofar as their application is concerned, and rejected my appeal insofar as my application is concerned. Therefore, virtually the trial court now,
Appellate court, what they done?
appellate court ಇವಾಗ ಏನ್ ಹೇಳ್ತಾರೆ, they have also not made out prima facie case, you have also not made out prima facie case, the car should be kept idle. The car should not be used. Their case is not maintainable because they have not sought for a declaration. Also, their case is that the car vested with the deity. There are no records to show that how the car came to the temple and how, as an administrator, she has got the right to use the car. There is nothing on record. Therefore, she has not made out prima facie case. As regards our case, Manoj, the only reasoning of the trial court is that we have suppressed material facts while coming to the court anta ಹೇಳ್ತಾರೆ. The reasoning is at Manoj, page number 47, ink page 47. This is the only reason on which my application has come to be rejected. At paragraph 27.
RC book stands in whose name?
Right now, it is standing in my name. This transfer was made during the pendency of the suit. It was a list pendants transfer. I'll come to that point, my lord. It was a list pendants. Suit was filed in 2019. In 2019 itself, it was transferred in favor of defendant number 1, who is my mother.
Earlier, it was in the name of Dr. K. Shiv Prasad.
No, now it is in the name of Shiv Prasad, who is
It was in that Shamba Swami Murthy.
undisputed. Undisputedly, it was in his name. 2018, he died. That is also not disputed. After his death, 2019, this suit came to be filed for permanent injunction.
Yes, Mr.
Alla, suit pendency iddage, my lord.
Property of that mutt, it is his
Individual property.
It is our case, Lord, that Lord, Swamiji, Lord, after he took sannyasa, Lord, he built this Kotilingeshwara temple. Those are hundreds of temples. And all his properties, Lord, vested with the temple. The RC book may be standing in the name of Lord, the individual, because it can't stand in the name of a temple. But otherwise, our case is that all the properties stood in the vested in the temple. And Lord, if your lordship will see, Lord, our application.
No, we'll come to that.
Yes.
You just answer this. Now, it should be in that individual name. He can be seek as an LR.
No, now let me just.
No, I will tell you that. I will tell you what we can answer that. He can be seek as an LR.
Yes.
Till deciding, without their somebody's name, car cannot be allowed you to use. Tomorrow something is happen, who is responsible, Mr.? There is
The
no
precise
owner.
reasoning given by the trial court.
Yes.
First appellate court.
Yes. Now, the facts of the case is, Lord, that after the Swamiji died, Lord, there was still some loan which was remaining. I have paid the loan. Lord, I have taken the insurance, all the documents, Lord, I have produced before the trial court when I filed the, initially suit was only for injunction.
Yeah.
Thereafter, I have sought declaration also that the property is a temple property. And Lord, there is a will of the Swamiji by which I am made administrator of the temple. So my case is as an administrator. Now, this matter has traveled up to Supreme Court, not regarding the car, but regarding, Lord,
Regarding
the Kotilingeshwara temple. There, my lord, the court said that I will be administering the properties of the
No,
temple property.
all that properties stands in the name of the temple. There is no difficulty.
All the properties, unfortunately, my lord, all stood in the individual name of the Swamiji. my lord.
Swamiji. Yes.
All the properties stood in the, that is where, my lord, the litigation has arisen. If the property had stood in the name of the temple, my lord, then he could not have claimed as a successor at all. No, my lord, before he took sannyas, Lord, he has.
No, yeah, what
That
has
act
happened,
itself is disputed.
what has happened to that suit? It has been declared that it's
Still
Pending.
then.
That is also still pending.
No, properties we can, but the thing is that vehicle.
But one
it should
submission.
be standing.
This vehicle is not subject matter of that suit. That is the reasoning given by trial court. Vehicle na suit, other, it is not made a subject
Why you
matter.
have
No
not
declaration
included
is sought.
that vehicle as a part of that suit property?
Neither it is part of the suit, neither it is part of the will.
Wait, mister, I am asking them, you are answering that. Yes.
But that was left out. That is why the suit was filed, my lord. But
Presumption
otherwise-
is that it is not the, therefore you have not included.
No, but even the-
Now, you have not sought for any declaration, you are only
sought for-
injunction. His suit is for only injunction.
Ivaga, after this, when during the pendency of the writ petition, they filed the application, got the plaint amended. Merely because the relief is sought, my lord.
It's a counterclaim, my lord. The trial court will decide, my lord. He has sought counterclaim seeking declaration that he is the owner. He has become the owner by inheritance. But that issue will definitely come whether he becomes owner or not.
Now,
So-
service is completed.
Yes, my lord.
You are appearing for whom?
Respond. My lord, I will take notice for in 23.1
Yes, in,
for
will, then matter required final hearing.
final hearing.
Yes.
But my lord, there is. Lord, your lordship also have now expressed that, but now the trial court really says, don't use the car, my lord, which is. little
No,
difficult.
Adagala.
if it is allowed, No, if it is allowed, it should be allowed to that, the person whose name RC is there.
No, RC book, he has got it not fraudulently.
No, that.
By filing a false affidavit.
Mister, that still, that has to be cancelled. He is a RC owner. You can't use it. Suppose tomorrow if you use it,
There is an
something is
accident.
happen, then he will be responsible. You
No,
can't do
we have-
anything that.
We will file an affidavit if necessary, my lord, that we will take the entire responsibility.
No,
that may
that's not that,
We'll
law
file,
is-
we'll
yes,
file objections to.
yes, yes. In connected matter, Kotri.
Connected requisition 701.
Connected matter. First matterly, you are appearing for only two, you are appearing for that response.
Yes.
Yes, connected matterly, you will take notice.
I'll take notice for the sole respondent.
Yes, first matterly, K-Vetter is undertake to appear for respondent. Second matterly, Sujendra Sridhar, learned counsel is undertake to appear for respondent. What is the stage in the suit?
Lord, evidence is to be.
No, amendment of, amendment of.
Is this matter next? Yes, next week, yes.
Serial number 24, S. Raju for petitioner.
The petition
Yes.
challenging the amendment application, allowing the amendment application filed by the respondent of. But initially, the suit filed by the petitioner and the brothers and the father Malad.
No,
Why-
you
why
are
is-
the,
Pardon?
you are the defendant.
You are the dependent.
Suit for,
Suit for parties, the second partition, after lapse of 16 years, daughter, sisters filed a suit before the trial court. Malad. He filing the application, amendment application, changing the survey number measurement without looking the document, bringing to file the 60 scheduled properties as mentioned in the second suit. Malad.
what is that order you are challenging? Next.
Annexure G. Annexure J. Malad. Annexure, the petitioner wife property na add ಮಾಡಿದ್ದಾರೆ.
Petitioner?
The wife property, it is a Salpako property. Petitioner wife property is gifted the property in favor of the petitioner wife. Is in position 2012 ನಲ್ಲಿ. ಆ ಪ್ರಾಪರ್ಟಿನ ಇದನ್ನ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಸರ್ವೆ ನಂಬರ್ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹಾಕಿದ ಅಪ್ಲಿಕೇಶನ್ adding the property of the my wife. Therefore, I start for this.
Plaintiff under order 7 read with section code of praying permitted amendment pursuant so and so.
Without discussing without giving any reason to this application, allowing the application filed by the respondent 1 to 4. Malad. Only
Not by the plaintiff is permitted to enable this court to adjudicate the matter.
full trial ಆಗಬೇಕು ಅಂತ ಹೇಳಿ ಒಂದೇ ಲೈನ್ ಅಲ್ಲಿ ಅದನ್ನ ಅಲೋ
You
ಮಾಡ್ತಾರೆ.
can object that way, you can prove there that it is.
ಅಲ್ಲ ನೋವೇ ಕನ್ಸಲ್ಟ್ ಅದು ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅವ್ರ ಹೆಸರಲ್ಲಿ ಇದೆಯಾ ಇಲ್ಲ ಅಂತ ನನ್ನ ಹೆಸರದಲ್ಲ ನನ್ನ ಹೆಂಡತಿ ಹೆಸರಲ್ಲಿ ಅವ್ರು ಸಪರೇಟ್ ಆಗಿದೆ ಅವ್ರ ಪಾರ್ಟಿನೂ ಅಲ್ಲ ಇದರಲ್ಲಿ adding the property.
They have not produced the documents to.
ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದು
property.
ಪ್ರಾಪರ್ಟಿ ಹೌದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ annexure G and H ಖಾತಾನು ನನ್ನ ಹೆಂಡತಿ ಹೆಸರಲ್ಲಿದೆ 2012 ಇಂದ ಇದೆ.
Who has given that Dana Patra?
Pardon?
No, that this.
Annexure J is the gift deed bala.
Oh, yes.
It's my Sarvakaran property. I gifted the property in favor of my wife bala in the year 2012. Suit filed by in the year 2021.
Yes.
ಈಗ ಅವರು after lapse of 2 years after filing of the suit, after lapse of 2 years ಈಗ ಹ್ಯಾಡ್ ಮಾಡ್ತಾರೆ ನನ್ನ ಪ್ರಾಪರ್ಟಿ ನನ್ನ ಹೆಂಡತಿ ಪ್ರಾಪರ್ಟಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದ್ದೀನಿ ಲೋನ್ ತಗೊಂಡಿದ್ದೀನಿ ಲೋನ್ ರೈಸ್ ಆಗಿದೆ more than 50 lakhs ಲೋನ್ ತಗೊಂಡಿದ್ದೀನಿ.
Issue notice. Stay of further proceedings in OS number. '92 of 2021 pending in the file of Senior Civil Judge JMFC Chanpatna till next date of hearing.
Much okay.
With objection, first time matter, serial number 25, C.A. Ajit.
Yes, I am for the petitioner, Your Honor. There is another connected matter which I have been moved memo in the morning, Your Honor.
Yes.
The same may be connected to the.
In the meantime, you comply that office objection also.
Yes, Your Honor.
This
There is
matter-
an
Age of the defendant at that verifying affidavit.
and a better copy of annexure
A
J,
copy of annexure J.
which has been filed in the connected matter, Your Honor.
Yes. Call this matter along with that so and so.
Tomorrow date given.
ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ದಾರೆ ನಾಳೆ?
ನಾಳೆಗೆ.
Yes, tomorrow.
Serial number 26, Mahabaleshwar.
For petition in this matter.
Yes.
It's a partition suit, my
Now,
lord.
what is that office objection?
It's office objection, my lord, it's non-production. of-
Signation of the court to be, notary signature is not forthcoming. Annexures, names to be stated correctly. Yes, you have to comply this.
It's curable. I'll comply, my lord. Meanwhile, my lord, maybe heard, my lords.
No,
There's a
these are all
urgency.
the office objection. Without compliance, we can't, we'll pass it over, you comply. Please. Yes. Notary seal in the documents and Allah, if you can hear antandra, what is this?
It will be taken up tomorrow, my lords, kindly, my lords, I'll come.
Yes. Weeks, days, 1 day, we press days time to comply office objection. Yes, use this matter tomorrow.
Grateful.
Serial number 27, Vinayak Kirti M.
Appear for the petitioner. 3 office objections are already complied, your lordship.
Katidara, 100
Court fees
rupees.
kattidene.
When?
On that day itself, your lordship. That is already noted in that.
On 3/2/2025, it is raised. ಇದು ಏನ್ರಿ ಅಲ್ಲಿ ಕೋರ್ಟ್ ಆಫೀಸರ್
Complied.
ಯಾವತ್ತಿಂದು ಅಂತ ಹೇಳ್ಬೇಕು ಅವ್ರಿಗೆ ಎಲ್ಲಿ ಕಟ್ಟಿದ್ದಾರೆ ಅನ್ನೋದ ಇದು ಏನಂತ ವಾಟ್ ಇಸ್ ದಟ್ No, another 100 rupees you have to pay, Mr.
That I will pay that.
Yes, pass or you pay it and come back. Yes.
Office objection, second time matter, serial number 28, P. N. Harish for petitioner.
The office objection is age proof of the second petitioner. I will not claim the senior citizen status.
Yes.
And ಇನ್ನೊಂದು I will do that in the meanwhile. ಮಾಡ್ಬಿಡ್ತೀನಿ. The matter is requires.
Pass or.
Please.
Yes.
ಅಲ್ಲ, Rashik may kindly hear the matter. It's only simple Order 1 Rule 10 application.
Oh, you comply it.
ಅಲ್ಲ, ಒಂದೇ ಲೈನ್ ಬರ್ದ್ಬಿಡ್ತೀನಿ ಅದನ್ನ. I will complete now.
Yes, yes.
Please.
Serial number 29, Wakun Sonata for petitioner.
Yes.
My lord, appearing for the petitioner, my lord, this matter is connected with serial number 19. This honorable court was pleased to issue emergent notice in that. I will comply the office objections in the next 2 days, my lord. If the matter may be called
Yes.
along with serial number 19.
Yes, week's time is granted to comply office objection. Yes.
Much obliged.
Serial for order, serial number 30, S. Venkateshwaran.
I am for the petitioner. ಇದರಲ್ಲಿ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಕೋರ್ಟ್ ಫೀಸ್ ಎಲ್ಲ ಕಟ್ಟಿದೆ, ಕ್ಲಾಸಿಫಿಕೇಶನ್ ರಾಂಗ್ ಅಂತ ಆಗಿದೆ, ಅದು ಫೈಲ್ ಸಿಕ್ಕಿರಲಿಲ್ಲ.
Petition under section 24 of CPC. What is that order you are challenging?
No, transfer, we are asking for a transfer of the OS suit from Alur, Asan district to Bangalore, because both the petitioner.
You have to file in a CP, mister.
ಅಲ್ಲ, ಸಿವಿಲ್ ಮಿಸ್ಲೆನಿಯಸ್ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಚೇಂಜ್ ಮಾಡ್ಬೇಕಷ್ಟೇ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ ತಾವು ಪರ್ಮಿಟ್ ಮಾಡಿದ್ರೆ ಐ ಕ್ಯಾನ್ ಚೇಂಜ್ ದಟ್ ಅಂಡ್ ಗಿವ್ ಇಟ್.
No, that is not coming before me. It has to go before that other judge.
ಅಲ್ಲ, ಅಲ್ಲಿ ಕೇಳಿದ್ದಕ್ಕೆ ರಿಜಿಸ್ಟ್ರಿ ಇಲ್ಲಿ ತಮ್ಮ ಮುಂದೆ ಬರುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರು, ಅದಕ್ಕೆ ಆ ಫೈಲು ಸಿಕ್ಲಿಲ್ಲ ನನಗೆ. ದಟ್ ಈಸ್ ವಾಟ್ ಐ ಮೇಡ್ ಎ ಮೈ.
CP is not coming before me, mister.
ರಿಜಿಸ್ಟ್ರಿ 2 ಸಲ ಹೇಳಿದೆ ಸ್ವಾಮಿ, ಆದ್ರೂ ಇಲ್ಲಿಗೆ ಕಳಿಸಿದ್ದಾರೆ.
No, CP is coming before you. First, file in a memo for this thing. Learned counsel for the petitioner has filed in a memo seeking leave of this court to convert this writ petition into civil petition.
ಅಲ್ಲ, GMCPC ಅದಕ್ಕೋಸ್ಕರ ಇಲ್ಲೇ ಇದ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಕಳಿಸಿದ್ದಾರೆ ಸ್ವಾಮಿ ರಿಜಿಸ್ಟ್ರಿನಲ್ಲಿ.
CPC ಅಲ್ರಿ, section 24.
ಆ ಸೆಕ್ಷನ್ 24 ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾನೆ, ಅವ್ರು 22 ಅಂತ ಹಾಕಿದ್ರು.
See, you are seeking for a transfer.
Yes,
it should be CP.
I agree ಸ್ವಾಮಿ.
ಅವರು ಏನೋ ತಪ್ಪು ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಅಲ್ಲಲ್ಲ, ಅವ್ರು ಫಸ್ಟ್ ಏನಂತ ಹೇಳಿದ್ರು ಅಂದ್ರೆ GMCPC ಬರುತ್ತೆ ಅಂತ ಹೇಳಿ ಸೆಕ್ಷನ್ 22 ಹಾಕಿದ್ರು. ಐ ಸೆಡ್ ಇಟ್ಸ್ ನಾಟ್ 22, ಇಟ್ ಇಸ್ 24 ಅಂತ ಹೇಳಿದೆ. ಆಮೇಲೆ ಅಗೇನ್ ದೇ ಗಾಟ್ ಲಿಸ್ಟೆಡ್ ಹಿಯರ್.
Not 24.
24 is transfer of the case.
Suit governed by that 24. ಇದೇನ್ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಏನ್ ಮಾಡಿದ್ದಾರೆ?
General power of transfer and withdrawal.
No, then I think it will be classified as in a CP.
Sir,
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡಿರೋದು ಆರ್ಡರ್ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ
ಅಲ್ಲ, ಆರ್ಡರ್ ಅಲ್ಲ,
ಅದನ್ನ CP ಅಂತ ಮಾಡ್ತಾರೆ. ಇದನ್ನ
ಟ್ರಾನ್ಸ್ಫರ್ ಫ್ರಮ್ ಹಾಸನ್ ಟು ಬ್ಯಾಂಗ್ಳೂರ್ ಬಿಕಾಸ್ ಬೋತ್ ದ ಪಿಟಿಷನರ್ ಇನ್ ಬ್ಯಾಂಗ್ಳೂರ್ ಆರ್ ದೇ ಆರ್ ಮೋರ್ ದನ್ 70 years old.
Yes,
that's what I'm seeking. That's all, nothing.
No, that will be classified as a civil petition. ಅದಕ್ಕೆ ಬೇರೆ ಕ್ಲಾಸಿಫಿಕೇಶನ್.
ಸಿವಿಲ್ ಮಿಸ್ಲೇನಿಯಸ್ ಅಂತ ಬರುತ್ತೆ,
ಸಿವಿಲ್ ಪಿಟಿಷನ್ ಅಂತ ಬರುತ್ತೆ. ಸಿವಿಲ್ ಪಿಟಿಷನ್.
I can make the changes here. This will come before you only, sir.
No, CP is not coming before me. It is coming to that other court, mister. Adun verify ಮಾಡ್ಸಿ. Yes, filed in a memo seeking leave of this court to convert this writ petition as civil petition. Memo is taken on record. The petitioner is permitted to convert this writ petition into that civil petition. Yes.
Some list on Monday or Tuesday because urgency is there.
Yes.
In the matter.
Office is directed to post this matter before appropriate roster bench on Tuesday.
Serial number 31, Venkatesh Soma Reddy.
I seek 1 week time to comply with office functions.
Week's time is granted to
Please.
comply.
Serial number 32, Sagar BB for petitioner, Manjula D.
I'm for the
Petitioner.
respondent number 6 and
Yes.
7, Maro.
My lords, the petitioner before your lordships, my lords, has instituted, my lords, an appeal.
Awaiting service of notice.
My lords, by hand, my lords, all the counsels representing before the trial court, my lords, are served, and the contesting, my lords, respondents are before your
Respondent number
court.
6 and 7, Maro. I'm
My lords,
for
my limited prayer, my lords, in the writ petition is, my lords, for consideration of IA, my lords, which is filed along with the RA. IA number 1, my lords, filed along with RA, is for, my lords, stay of the impugned judgment and decree.
No, you are the plaintiff or a defendant.
My lords, I am defendant, my lords.
You are the
Second defendant, my lords, has challenged the
Put for
partition and separate position.
partition.
Partition, suit is decreed.
Suit is decreed.
Suit is decreed.
You have filed an appeal.
Yes, my lords.
You are appearing for whom?
respondent number 6 and 7, Maro. Before trial court also respondent number 6 and 7, Maro. Appellate court. In respect of agreement, my lord,
One,
please,
here you are appearing for 6 and,
please, 6 and 7, Maro.
no, what about the plaintiff?
Basavaraju and Kumaraswamy.
Plaintiff has to serve Allah.
Plaintiff, my lords, by hand, we have served, my lords, the counsel, your lordships, my lords, had permitted me to serve the counsel, my lords.
If they are
Represent-
appeared, it is well and good. If they are not appeared.
No, the difficulty is, my lords, now the
Now, what is
respondent, my lords, who has appeared before the court, my lords, has already entered into a sale agreement. Now,
Who?
this respondent, my lords, who has appeared before the court. Respondent number 6.
Directed to, when is the next date?
My next date, my lords, it was brought to the knowledge of the learned trial judge, my lords, appellate judge, that, my lords, we have filed, my lords, a writ petition, and, my lords, your lordships had permitted to take out notice, my lords, with regard to
No, where is?
next
what is
date,
the
my lords, is 5th April.
5th April.
My lord,
In spite of, my lords,
one submission, my lord. Party bearing before this honorable court, my lord. As per party instruction, he has not sold the property. Yes, it's an agreement,
No,
but that.
I am not on that.
cancelled.
I will direct it to consider this application.
Yes, my lord, please,
Yes.
please.
All are appeared before the trial court.
all are appeared, my lords, all have appeared.
With the time frame, my lord, because my lord, it's already since 1990 in the Hillivarage case dispose
My
again.
lords, the other request is, my lords, till consideration of that IA, my lords, let them not dispose of the property, my lords.
The parliament,
Yes,
we are not the alienation of the suit schedule property, my lord, please.
In this,
I'll undertake, my lord.
in this writ petition. Petitioner sought direction to the principal district and session judge, Ramnagar, to dispose of IA number 1 of 2024, filed in RA number 18 of 2024. In view of the above, so and so, you are appearing for which respondent?
Respondent number 6 and 7, my lord.
6 and 7. In view of the prior, the service of notice to other respondent is not necessary. Plaintiff has filed a suit for partition in OS number
336 of 2009, my lords.
336 of 2009. The suit came to be decreed
26th February 2024, my lords.
26th February
2024, my lords.
2024. Being agreed by the same, petitioner herein has filed an appeal before Principal District and Session Judge Ramnagar in RA number 18 of 2024. Along with that appeal, he has filed IA number 1 of 2024 under order 41 rule 27,
5, my lords, rule 5.
order 21 rule 5 of CPC. In spite of appearance of the respondent in that RA number 18 of 2024, application was not disposed of at our submission third. The learned counsel submitted that in spite of service of notice, the appearance of respondent in RA number 18 of 2024, the first appellate court has not disposed of IN number 1 of 2024. The parties are trying to creating third-party interest, hence he sought for early disposal of that IA 1 of 2024. In view of the above, without expressing any opinion on the merit of the case, the first appellate court is directed to dispose of that application on or before 18th, on or before 21st of March, subject to condition petitioner herein has to prepone that,
Will advance.
seek for an advancement of that appeal. With that observation,
My lords, the other relief, my lords. My lords, they are ready to undertake, my lords, that they would not dispose of the property.
no, that is not that, man. The application is still pending, mister. You go and
Application is still
agitate that.
pending, my lords.
If I pass here, there is nothing is left for the.
No, only till consideration, my lords, only till consideration of that IA.
Decide, therefore I am fixed the date.
My lords, your lordship may kindly see this situation, my
Only a
lords.
mandamus to consider, mister.
My lords, before, my lords, the learned appellate judge, my lords, were to pass an order. If, my lords, they were to dispose as, my lords, based on that sale deed, my lords, revenue entries will be changed. My lords, I will have to pursue 3 other proceedings.
That is there, you go and ask, mister. Yes.
My lords,
If
till
any,
such,
any transaction during the pendency, it is less pendency. Yes.
no, that is always there, my lords.
Sir, it is only directions you have sought.
True, my lords.
Then
No, by way of interim prayer, my lords, I had sought.
you serve a copy to all. Yes. Service, 2 weeks time is granted to.
My lords, this disposal, my lords, I'll go before the learned judge.
Mister,
2
notice
days, my
has-
lords, I'll argue. From 1 year, my lords, I'm trying, my lords.
all the respondent has not served. It is only for the disposal. I have
No,
taken-
it is only these, my lords, respondents who are alienating.
No, others has to be served to pass any order, mister.
No, my lords.
You do one thing, recall ಮಾಡಿ.
Allala, Swami,
Yes.
ಏನಂದ್ರೆ
No,
only these
wait,
respondents.
mister, I have given an opportunity.
No, I'll take that order. I'll take
Yes.
that order.
Yes.
My only concern was, my lords, these respondents were
It should be
still.
a sanctity to our order. All others has not served. In mandamus, you are seeking in a direction.
No,
Can I
no
pass it?
others, no other defendant, my
It's
lords,
not that, mister.
no other respondent, my lords.
Yes, that is your convenient. They have to come before the court and say, yes.
Serial number 33, Syed Kamruddin for petitioner, V.S. Satyanand.
Lord, for respondents 2 and 3, Lord, on 17-2, when the matter got listed, my lord, notice to 2 and 3 were dispensed with. At
Yes.
the instance of
A memo was filed.
petitioner,
Hmm.
Lord, however, advance copies were served on me. 2 and 3, my lord, I represent BBMP in this matter.
Yes.
My lord, this,
It's only a mandamus, which they're asking the trial court to be dispose of the suit. I
A
don't have
memo
any
was filed
objection.
seeking.
One is served.
One is emergency notice we have taken out, my lord. My lord had also permitted us to take out hand summons. However, the counsel appearing for the respondent and plaintiff, there are 2 suits, my lord, has refused on account of the fact that he has filed an LR application and that is pending.
Now anyhow that office objection is warranted, learned counsel petitioner filed a memo seeking 2 and 3. Anyhow, you are appearing that
None
dispensation.
appear. Dispensation can be
Yes.
My lord, seeking mandamus for early
mandamus
disposal, my lord. 9 years evidence.
All are served now. Yes, what is this your suit for?
My lord, there are 2 suits, my lord. The petitioner herein has filed 1 suit for partition and the respondent number 1 has filed a suit for mandatory injunction and cancellation of khata.
Now both the suits are clubbed.
Both the suits are clubbed, my lord.
Now that what is the stage in the suit?
My lord, it is coming up for evidence, my lord. It is.
Yes. Yes, let it be disposed of. How many witnesses are there?
My lord, it is a partition suit, so both between 2 sisters, both sisters have passed away. So if my lord gives any direction, it should be done soon, my lord.
No, we can't, Mr. Supreme Court said, don't give.
I
direction to
understand,
the
my
trial
lord.
court.
But
For-
as expeditiously as
To
possible.
avoiding, I am also adapting the method to see that you serve an other side. Otherwise, all suits, they file in a writ petition saying that on the same day dispose of. Therefore, I said serve other side. Yes. In this writ petition, petitioner sought directing the trial court to dispose of that OS number 1670 of 2016 and OS number 2969 of 2016 pending in the file of 5th Additional City Civil and Session Judge, Bangalore, expeditious. Respondent number 1 is served unrepresented. 2 and 3 is represented by.
My lord, respondent number 1 has refused hand summons, my lord. It is
Refused
a
hand summons.
is refused, the advocate appearing for respondent number one.
Advocate refusing is not an service, Mr. Party has refused.
Party
No hand summons.
hand summons was on the council, my lord. He has said that the party who he was representing has passed away.
The permitted to
hence he
serve a
cannot.
copy of the petitioner on the council list, not on the service of notice dispense with risk. It is not in the completion of service. Third, so and so appearing for respondent number 2 and 3, since the direction is sought only for early disposal of the suit. Notice to respondent number 1 is dispensed. Plaintiff has filed a suit for partition.
My lord, the petitioner has filed a suit for partition.
Hmm.
The respondent number 1 has filed a suit for mandatory injunction and cancellation of khata.
Which is that mandatory injunction?
Mandatory injunction is 1670 of 2016.
Yes, petitioner has filed a suit for partition in OS number 2969 of 2016. First respondent herein has filed an OS number 1670 of 2016 for cancellation of khata
And mandatory injunction.
and mandatory injunction. The learned counsel for the petitioner submitted that both the suits has clubbed together. Now that matter has been shut down for evidence. Hence he sought for, since it is a partition suit, he sought for early disposal.
My lord, it is to hear on I-8, my lord.
Then we
Which is
can't-
for additional issues, but it was for evidence, my lord.
Matter is shut down for framing an additional issues. Under these circumstances, in the interest of justice, the trial court is directed to dispose of the suit as expeditiously as possible, not later than 1 year from date of receipt of copy. Yes.
Much obliged.
Serial number 34, Radha R for petitioner, Manu Prabhakar Kulkarni.
Please, Mr. For the rest.
May I please, Your Lordship?
Yes.
Milos, on the last day, Milos, the office objection was, there were certain clarifications given by us, Milos.
Maintainability.
Maintainability, Milos.
43 rule 1A.
Yes, Milos.
Yes.
43(1)(a), Milos, only refers to when the plaint has been returned. Here is a case, Milos, when the plaint has not been returned, our application for return of plaint under order
So
7
last
Rule 10 has
occasion
been
is said,
dismissed.
it is maintainable.
Yes, Milos.
Yes, you have also considered that. It is
I'm so grateful.
because it is not return of the plaint, it is rejected your application,
Rejected the application, Milos.
but it is a commercial code.
No, my lord, it's a regular civil.
Regular civil code, then CRP, not that writ. See, if your application is allowed, by consequence suit is terminated, then it is finality of the suit, it is in a CRP. You see that
But this is
1999.
order 7 Rule 10, here the suit.
Now, any application, if that order is passed on that application, it is terminating that proceedings, then you have to approach under CRP.
Yeah.
No, here.
Suppose your application is allowed, it is terminating that suit,
Correct.
then I think CRP.
But
You see that
but in our
Proviso
case,
to 115.
115,
in
1999
our
amendment.
case, application has not been allowed, Milos. It has not been
No.
terminated.
That even if it is allowed, then what is the consequence? That
Precisely,
read that 115.
May I read, my lord?
Yes.
Provided that the High Court shall not,
Yeah.
under this section, vary or reverse any order made or any order deciding an issue in the course of a suit or other proceeding, except where the order, if it had been made in favor of the party applying for revision, would have finally disposed of the suit or other proceeding.
Yes.
Therefore, my lords, what falls from your lordships is, if this application was allowed, it would have disposed of the suit.
That is what that I think judgment has been. If you want to verify this provision.
Milos, here, firstly, Milos, the application has not been allowed. So there is a
Court shall not under these sections vary, reverse any order decided an issue in course of suit, other proceedings, except where that order, if it had been made in favor of.
Please.
If it had been made in favor of, if it is terminated, then you can't.
then I could not. Milos, but
If
otherwise,
it had
Milos,
been allowed,
He would have filed appeal.
appeal.
Milos, I have
Like
gone
that,
through
this
several.
is that meaning.
I'm so grateful. Milos. I have gone through several judgments, including all the judgments filed by the other side. Every single judgment is, Milos, in relation to Order 7, Rule 10, and in every judgment, Milos, only a writ has been filed, Milos. And this honorable court has
No,
been.
you see this amendment, this That is the purpose of this amendment. This is brought on 1999 amendment on the constitution. It is it was
Yes,
not-
but-
1/7/2002.
Yes, 2002, and was all the
Then,
judges.
you see that our larger bench judgment, this Tamaya's case, please also discussed all these points.
Can you see that?
Otherwise, there is no meaning of this if it is not, that is why that they said.
Because if even in recent judgments, including 2024, 25, what they the judgments filed by the other side, all those judgments, it is maintainable and writ has been filed and writ has been
No, writ
allowed
has
by this
been-
honorable court.
Office is not raised objection, writ has been filed, court
Officer-
has entertained, judge has passed an order. If it is pointed out, it sees that this is the law, unless you satisfies me. Just because earlier court has entertained, we cannot be. You read or you produce the judgment and convince me that it is maintainable. To read that, if it is read, this is what that. Any judgment on application for return of plaint is rejected, considering that section 115 and pass an order, then
No.
there is a consideration of this provision, then I can understand.
No, none of the judgments.
Both of them examine this, you have
I'll do
not applied
I'll do
their
it.
mind. Yes,
We'll have to.
yes, when do you want, you apply their mind and see that.
Unless I have to come from Delhi, would my lords permit me to appear through VC in that
Yes,
case
yes,
on the
we,
next?
we have given that, specialties to appear anywhere in that world. Yes, now we have adopted that. Yes, you can appear from Delhi also, no problem.
Great,
Yes.
Any date after 15 days, Milos?
Yes, when do you want? 15th,
After 15 days, any date suitable to my lord?
17th, please.
17,
Yes.
my lord, please.
Great.
Cell number 35, Shrikant Patil K for petitioner, Prithvi Wadayar.
As per the petition in this case, apply for 1 day's accommodation, my lord. Senior counsel appears in the matter. Currently have tomorrow, my lord, to do.
Not tomorrow,
Tomorrow.
Monday or Tuesday,
Monday, my lord.
Tuesday. This.
Interim order, okay.
4th,
So, interim order.
interim order granted earlier is extended till next date of hearing.
Public.
Serial number 36, Vivekanand Anthony.
My lord, I have received the certified copy of the order. 2 days time I will be granted, my lord, I'll produce and make.
Yes, 2 days time is granted to comply that also.
Serial number 37, Vishrut C for petitioner, Surya Prasad L.
For the petition.
For the respondents in this case.
Affidavit is filed and the compliance, for the compliance, the file was not made available. I can do it today itself, Your Honor. It's
What is
just
that
only
office
one-
objection?
Office objection, the one that is left is the preamble. For G and H are the same. For G, the preamble is there. For H, it is not
Non-filed
there.
Affidavit by the advocate for the petitioner, order dated. What is that order?
My lord, by virtue of the previous order, they had to file an affidavit stating that
Petitioner is there to file an affidavit with respect to whether
Affidavit
he
is
has
filed, Your Honor.
vacated the entire suit scheduled property as on the date of passing the order. Yes, where is your?
Affidavit is filed, Your Honor.
they have filed a conditional affidavit.
Yes, what is this?
They have filed a conditional affidavit, my lord.
Yenanta?
This was not their contention earlier, but in paragraph 4, they say, I am in possession of a property adjacent to the decree scheduled property, which is separate, and this, so they give a kata number, etc., etc. This is not their contention anywhere.
No,
My lord,
that-
to this,
Just give that brief facts, I forgot.
my lord, please.
Yes.
My lord, this is a suit for eviction, my lord.
Hmm.
OS 64 of 2009. Decreed in my favor. They are asked to vacate the scheduled property.
Yes.
Later on, execution proceedings are initiated. In the meantime, they go for a regular appeal, which is dismissed, and they go for an RSA. In RSA, before this honorable court, they make a submission that we will vacate the property. Give us 3 months' time.
Yes.
Upon that submission, this court disposes of the RSA, but they don't vacate the property, upon which we file a contempt petition. In the contempt petition, they say that we have vacated the property, and they contempt court says make an inquiry if the property has been vacated. If not, take necessary action, put them to civil prison. The execution court conducts an inquiry. By virtue of the order in annexure G,
They said they have not vacated.
they said they have not vacated.
Yes.
How further clarify, my lord?
How that inquiry has been conducted by the executive?
Evidence was done, cross-examination was done. A portion of the cross-examination statements is in annexure It is recorded in the order sheet, page number 81 of the petition.
Affidavit contained that he will hand it over the vacant possession within 6 months' time in view of that memo RFS. When that RSA has been disposed of?
My lord, RSA has been disposed of. On 30th of April 2014, my lord.
April
2014.
14. 6 months means?
They fixed the date, my lord, from 1/5/2014, 6 months,
One
which comes about
1/5/2014
in the R tingalu.
1/5/2014, he has to be vacated.
He had to be vacated.
Yes, where is your affidavit? What is says? Number court, by order dated has directed me to file an affidavit stating that when I have vacated that scheduled premises, scheduled properties, as on one for date on which that IA has passed in court. That compliance with the said direction, I state that I have vacated that entire suit scheduled property, part of that.
This is nothing but a conditional affidavit.
Are not in the possession of the said property as and so on. So that to the best my knowledge, ability, information, my family, I have are in the possession of the property adjacent to the degree suit scheduled property. Now you have to
Memo.
file an affidavit saying that on 1/5/2014, you have vacated that suit scheduled property. This is not that you have filed an affidavit with different colors.
No, Your Honor, I not only just this affidavit, I have filed the memo even before the trial court in 2014 itself saying that I have vacated
No,
this.
very simple affidavit we said, because you have undertaken before this court. And on the other hand, court itself has directed that you have to be vacated on 1/5/2014. If you are vacated on 1/5/2014, it is end of the matter. Otherwise, it amounts to a contempt.
My memo, my lord. I have filed some pictures. The first picture is of the initial position. There you can see house and Mane Mundero Vatara. That is the initial position. The third image is the present position, where you can see he has constructed a house. Adr hinde iro property ಖಾಲಿ ಮಾಡಿದ್ದಾರೆ. ಫ್ರಂಟ್ ಅಲ್ಲಿ ಪೂರ್ತ ಆಕ್ಸೆಸ್ ಕ್ಲೋಸ್ ಮಾಡಿದ್ದಾರೆ.
ಇದ್ರಲ್ಲಿ ಯಾವುದು ಪ್ರಾಪರ್ಟಿ ಇದ್ರಲ್ಲಿ ಏನು ಗೊತ್ತೇ
The property is facing the road. First page ಅಲ್ಲಿ
you come to that third page.
Please, my lord.
ಅದೇನ ರೆಡಿಮೇಡ್ ಗಾರ್ಮೆಂಟ್ಸ್ ಇದೆಯಲ್ಲ ಅದಾ?
ಹಾ ಅದೇ my lord.
That is not the suit scheduled property. That is what the that is what I'm saying to this court, Your Honor. The this is the property that I'm in possession of. This was brought to the notice of this court on the last date of hearing itself. I want to take the court's attention to the suit.
Which is that suit scheduled property?
My lord, if I may clarify, kindly come to page number 83 of the petition, my lord.
No, again, the question, as per the question that let's get to the suit scheduled property itself, Your Honor.
Yes.
The suit scheduled property, the schedule is at page number 52.
Yes. Which page, mister? Red color or blue?
My apologies. It's I think it's blue. Page number 51.
Blue is that
No,
order?
In the decree, it can be seen at 56, Your Honor. Decree scheduled property.
Yes.
Okay, this is VP Kata number 1011, measuring 25 feet into 15 feet. This is the house, a small house. Along with this, there was a vacant site of 10 feet into 20 feet. This is the suit scheduled property. It is in the decree as well. And surrounding this, surrounding the house as well as the vacant site, there was a compound wall that was constructed. It is.
Yes.
The compound wall still exists, though in a dilapidated condition. I handed over the possession of the property even before, as per the RSA.
No, this compound wall after that vacant place, that was that suit scheduled property?
No. This photograph that is provided here is not the compound.
Yes.
The compound, if I'm not wrong, I'm not sure that I can, whether I can verify it or
Is
not.
that suit schedule property, Mr., according to you?
The suit schedule property. In this photograph, I cannot show, Your Honor.
You produce that, which is that suit schedule property?
I can produce that. It is part of the record, but as of now, it is not before this court.
that
It
suit
is
schedule
already
property
marked.
record?
This, in the first picture,
Yes,
the house,
yes,
and you can see a person sitting there.
yes.
That is the suit, both of these together are the suit schedule property.
That
Mane,
house-
mane mundero, whatever.
Hmm.
That is the suit schedule property. Now coming to the garments ಅಂತ ಇರೋ image photo.
Yes.
This. ಇದ್ರ ಹಿಂದಗಡೆ ಖಾಲಿ ಮಾಡಿದ್ದಾರೆ.
ಎಷ್ಟನೇದು?
This portion.
Yes.
ಇದ್ರ ಹಿಂದಗಡೆ ಖಾಲಿ ಮಾಡಿದ್ದಾರೆ.
Yes.
ಮುಂದಗಡೆ ಖಾಲಿ ಮಾಡಿ, ಮುಂದಗಡೆ ಹಾಗೆ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. To this fact, my lord, kindly come to page number 83 of their petition.
ಮುಂದಗಡೆ ಖಾಲಿ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ವೇಕೆಂಟ್ ಪ್ಲೇಸ್ ಬಿಟ್ಟು ಆ ಮನೇಲಿ ಇದ್ದಾರೆ ಅಂತ ನೀವು.
ಆ ಮನೇಲಿ ಇದ್ದಾರೆ. ಮುಂದಗಡೆ ಖಾಲಿ ಮಾಡ್ಲಿಲ್ಲ, ಎದುರುಗಡೆ ರೋಡ್ ಅಟ್ಯಾಚ್ ಇರೋ ಜಾಗ ಖಾಲಿ ಮಾಡ್ಲಿಲ್ಲ. ಹಿಂದಗಡೆ ಮನೆ ಏನಿತ್ತು
ಅದನ್ನ ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅದನ್ನ ಬಿಟ್ಟಿದ್ದಾರೆ. To this fact, my lord, kindly come to page number 83, my lord. 83 of their petition.
No, schedule ಅಲ್ಲಿ ಏನಿದೆ ಅದು?
Schedule ಅಲ್ಲಿ,
clarify ಆಗಿದೆ.
Your Honor,
83, page number 83.
This is being,
wait.
yes.
Yes.
Page number 83, second para. ಕೋಲಾರ ರಸ್ತೆಯ ಪಶ್ಚಿಮಕ್ಕೆ ಖಾಲಿ ಜಾಗ, ಅದಾದ ನಂತರ ಡಿಗ್ರಿ ಹೋಲ್ಡರ್ ಅವರ ಮನೆ ಇರುತ್ತದೆ ಎಂದರೆ ಸಾಕ್ಷಿಯು ಕೋಲಾರ ರಸ್ತೆಯ ಪಶ್ಚಿಮಕ್ಕೆ ನನ್ನ ಮನೆ ಇರುತ್ತದೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ನೀಪಿ 9ರಲ್ಲಿರುವ ಚೆಕ್ಕುಬಂದಿಯಲ್ಲಿರುವ ತೋರಿಸಿರುವ 10/20 ವಿಸ್ತೀರ್ಣದಲ್ಲಿ ನಾನು ಮನೆಯನ್ನು ಕಟ್ಟಿಕೊಂಡಿರುತ್ತೇನೆ ಎಂದರೆ ಸರಿ.
ಅವ್ರದ್ದು ಯಾವ್ದು ಮನೆ ಅಂತ ಅವ್ರು ಹೇಳೋದು?
ಇದೇ ಮನೆ ಸರ್. 10/20 ಏನಿತ್ತು ಎದುರುಗಡೆ, ಅದ್ರಲ್ಲಿ ನಾನು ಮನೆ ಕಟ್ಕೊಂಡಿರ್ತೀನಿ ಅಂದ್ರೆ ಸರಿ ಅಂತಾರೆ. Based on this inquiry, an order was passed. And even, my lord, I am giving you the order of the latest order of the trial court, where the bailiff has filed a report stating that our scheduled property al mane irutte. This is the certified copy, my lord.
No, now that what he is did is that vacant position he has built up and he is.
He has built up and he is staying there.
Where is your title deed in respect of that property, Mr.?
Your Honor, there is a revenue document this is Panchayat property.
Yes.
And this is brought to the notice of the trial court also, and it is not, I'm not claiming that it is my own property. Through Panchayat only, I'm in possession of the property. The revenue
Documents, where is that license for construction of that property?
Yes, I have all produced. It's all before the trial court. I can, it is marked also in the evidence. I can produce it on the next date of hearing, all the documents.
Monday.
Obliged, Your Honor, Monday.
Produce Monday. Let him produce, yes.
Interim order may be extended.
My lord,
Interim order.
they have submitted that the possession has not been, they are not in possession. Arrest may be stayed, my lord. They should not have problem in delivering the possession. There is a delivery warrant.
When the delivery,
arrest may be stayed.
File affidavit this court whether is vacated interim. What is that?
The order, my lord, is in 3 portions. First portion is the delivery warrant.
That copy, stay that person is put.
it's at page number 30, the order is
30.
30.
Issue arrest warrant, yes.
Arrest warrant may be stayed.
Yes.
Because there to delivery warrant and other thing may be proceeded.
Order granted by this court on 20th/2/2025 is modified. The stay of the impugn order only in respect of issuing an issue of arrest warrant against JDR.
Please, madam.
Is this matter on Tuesday? Yes.
Bill number 38, Ms. Sriraj Gowda for petitioner.
Appearing for the respondent in this matter, my lord. My kind apologies, my lord. I was unable to appear physically. I'm not keeping in good health. My lord, your lordships directed the petitioners to implead all the defendants in this matter. It seems they have not filed the application. Respondent, my lord.
Respondent.
Yes, my lord, respondent.
Petitioner. Yes, you want time. Yes. None appear for
Petitioner
the petitioner.
directed to file a certain application.
ಅವ್ರು ಯಾರು ಬಂದೇ ಇಲ್ಲ ಬಿಡಿ. Yes, this matter of 2 weeks.
Bill number 39, Kevin Narasimhan for petitioner.
Respondent number 2 is awaited, man.
Yes, awaiting service of notice to R2. Yes.
Please interim order, my kind.
Interim order granted earlier is extended till next date of hearing.
Serial number 40, Ravi Kumar NR for petitioner, connected matter, A. Madhusudan Rao.
And for the petition, my lord,
So respondent number 1.
this suit filed by the first respondent for the permanent injunction against the defendants, my lord. The defendant number 7 to 8 are the petitioners before this honorable court. And the different number 1 to 6 are the seller of the property to the different number 7 to 9.
Suit for,
Permanent injunction.
you are the defendant.
For the defendant.
Yes.
The contested defendants, the petitioners, the contested defendants, and file the written statement before the trial court. And due to oversight and due to the instruction properly, they have not inserted now they sought for the amendment of the written statement.
What is that?
Written statement at annexure to annexure D mailer, page number 37. To add the para number 3A, there is a property, how the property has been flow to the plaintiff, that has been not stated in the written statement. That is why during the course of cross-examination, they came to know that the property, how the property has came to the position of the plaintiff. That is why without pleadings, my lord, the whatever the cross-examination.
What is the reason for rejection?
It is only for the delay after the sufficient time has taken. In the earlier occasion, they have not amended the written statement. That is the only reason the trial court has. And the reason, my lord, in para number, page number 22, my lord. Further, it could be seen that the case at the trial court commenced when the case was posted for the further cross-examination DW1. At the belated stage, the defendant number 7 to 9 have filed the present application. On perusal of the affidavit, the defendant have not assigned the sufficient reason to delay in making the amendment of the application at the first instance.
No, that what is that you want to be pleaded, the amended?
Amendment, the property, how it is pro the title of the property biller to the plaintiff. That is started in the kindly peruse the.
Our suit ali nimdu title plaintiff elinda bantanta adu our prove ಮಾಡಬೇಕು.
ಅಲ್ಲ ಅವ್ರದೇನೆ ನಾವು written statement ಅಲ್ಲಿ if I not stated in the written statement, not taken the contention, we cannot take the matter because
ಅಲ್ಲಿ ನೀವು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಸೂಟ್ ಫಾರ್ ಇಂಜಂಕ್ಷನ್ ಅಲ್ಲಿ ಒಂದ್ ಲೈನ್ ಅಲ್ಲಿ ಡಿನೈ ಎವ್ರಿಥಿಂಗ್ ಅಂತ ಹಾಕಿದ್ರು ಸಾಕೆ. ಅಲ್ಲಿ ನೀವೇನೋ ಪ್ರೂವ್ ಮಾಡ್ಬೇಕಾಗಿಲ್ಲ. ದೇ ಹ್ಯಾವ್ ಟು ಪ್ರೂವ್ ದಟ್ ಎಸ್ ದೇ ಹ್ಯಾವ್ ಎನ್ ಎ ರೈಟ್ ಓವರ್ ದ ಪ್ರಾಪರ್ಟಿ, ದೇರ್ ಇಸ್ ಎನ್ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್. ನೀವ್ ಯಾರಿಗೆ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರಿ ಅವೆಲ್ಲ ಯಾಕೆ ಬೇಕು?
No, it is not stated. The property.
What court said, it is irrelevant. This amendment will nowhere connected to the suit for deciding. Therefore, they have rejected. How it will prejudice to your right? Even this amendment is not allowed. It will not prejudice to your right because they have to prove how they have got this property, not you.
That is true, but only submission, my lord, without my pleadings, I cannot go for the submission and
no,
because without
submission ಮಾಡದೇ ಇಲ್ದಿದ್ರು ಕೂಡ it will not affect your right.
ಅಲ್ಲ ನನ್ನ ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ನಾನು ಏನು ಆ ತರ ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ, ಈಗ ದಿ ಪ್ರಾಪರ್ಟಿ ಹೌ ದಿ ಪ್ರಾಪರ್ಟಿ ಒರಿಜಿನಲಿ ಬಿಲಾಂಗ್ಸ್ ಟು ಹೋಮ್ ಅಂಡ್ ಹೌ ದಿ ಪ್ರಾಪರ್ಟಿ ಅಕ್ವೈರ್ಡ್ ಬೈ ದಿ plaintiff, that if not stated in the written statement, I cannot argue the matter because if the
you are saying that how plaintiff has acquired the property or you acquired the property?
Plaintiff acquired the property. Plaintiff acquired the property.
Not our property have been purchased by the plaintiff herein and other family. You are the defendant, no?
Yes, please. That is why the latest judgment of Supreme Court also held that.
Herein other formally belongs to so and so, sold in property is that extent of 100 feet, so and so. You are admitting that she has plaintiff has purchased this property.
Purchased the property, the extension is also different, and it is not the what they claimed is it is encroached by this defendants. This what the defendants have the property is entirely different from the plaintiff. What the plaintiff has acquired the property. That is why the extent shown in the plaintiff schedule also.
It will affect
prejudicial
That's
and.
In the plaint, in the first paragraph itself, I have stated how I have acquired the property. Copy of the sale deed is also produced. The minute he has filed the written statement, he is well aware of the document that I have.
No, has he denied that?
He has denied my right in the written statement.
Adarnike explanation addition kottidara. If he has not denied, then he has taken this contention. Then it is nothing but he is improving this case.
He has denied the right of the plaintiff, and the other hand, he admits that I have purchased the property.
No, he is saying that not the entire extent. some portions to prove that.
This has been filed after 9 years. Written statement was filed in 2015 itself, my lords.
No.
After a period of 9 years, after the cross-examination of PW1, an application is filed after the matter is posted for evidence of DW1. It
I
was
thought
not-
we will not allow him to,
My lords, where is the due diligence, my lords? Because we have filed the plaint.
No,
In the
one
plaint
thing-
itself, the document is produced.
see, what is the stage now? His evidence is over.
Not yet, my lord.
Then
The defendant's evidence, my
I'm
lords.
relied on the judgment of Supreme Court, my lord, latest judgment.
evidence, see, evidence, if it is evidence is completed, we could have put in a condition that he should not recall that any witnesses for examination of this.
My evidence is completed, my.
Now he cannot-
PW1 is
see,
cross-examined.
He can only adduce his evidence. No witnesses can be recalled. We'll allow you to do it, subject to that, not to recall that any witnesses.
During the course of cross-examination of PW1 plaintiff,
No,
I came
you-
to know that how the property has been floated to the plaintiff. That is why.
To give your evidence,
Please, my lord.
but don't recall evidence which is already over.
Please, my lord.
We proceed further. That will-
PW1 may not be recalled, my lords, because
any evidence which is already over, he should not recall.
Yes, my lord.
Further, it has to be gone.
cost may be imposed, my lords. 9 years delay, there is no due.
Alert.
They have only said because they did not give instructions. Other than that, there is no reason. This is well within their knowledge, my lord.
No, see,
Proviso to section.
neither
Order
way,
617, my
neither
lord.
way, party will not get any benefit at all. It is only benefit for that party who is representing. Their one application, here is that. It is, therefore, I will just that disposed of that, yes.
Even
See,
Supreme Court.
even if he has not stated that you have not acquired these portions and all, it is for your duty to prove.
It is my case that I have purchased the property. I have
Addition, he said that you are purchased only these portions. That's pleading, only that pleading. Either way, that it will not affect. Yes. Kali, where is your written statement where you have denied?
My lord.
Paragraph 3 at page number 32, my lord, Annexure C.
Yes,
In the
Annexure C, 32, my lord.
yes,
The Sup-
33.
In the other
yes.
petition, it's
th-
there.
th- 30,
Defendant hereby
32.
specifically denied the
Yes.
plaintiff's owner possession occupation of the plaintiff's scheduled property. Stones. Yes. Kali. What is that other Vinand?
same, my lord. Connected matter. And he is a GPA holder. In the first matter.
Who is
uh,
appearing for other matter?
I appear for the respondent number 1 in the connected matter also.
No, same suit.
Same suit. So,
What is that application?
Same.
in the same, there are two suits filed by one, by the sister of the plaintiff,
In respect of same property.
different property, same schedule, same survey number,
Jointly
schedule is
purchased and there was a
jointly
partition.
Two different properties.
different property.
ಅದರಲ್ಲೂ ಸೇಮ್ ಇದೇ ತರ ಮಾಡಿ.
Houದು, same.
Yes, correct.
And the Supreme Court also recently said, my lord.
Yes, this petition is filed by defendant number 7, 8 and 9. Challenging the order dated 21/8/2024 passed by Third Additional Civil Judge JMFC Chikmagalur in OS number 18 of 2015, whereby IN number 18 filed by that petitioner under Order 7, Rule 17 was rejected. Plaintiff,
IN number
six number 1,
IN number 16, my lord.
yes. IN number 18 ಅಂತ ಹಾಕಿದ್ದೀರಾ?
In 1, it
I
is
number-
number 16.
16, my lord. In,
See that prayer, Mr.
No, no, it is IN.
It's on IN number 18, Mr. First matter.
sorry, in the first matter, the IN number 18, sorry.
Yes. Plaintiff has filed a suit for their injunction. On service of summons, defendant has filed. Plaintiff defendant has filed a written statement. Has denied that claim made in that plaint and also denied that ownership and possession, occupation of the plaintiff scheduled property by the plaintiff. When the matter is posted for evidence, plaintiff has filed an application under Order 6, Rule 17, seeking for amendment of return statement. He wants to include, where is that amendment?
IN number.
Page 39 in the first petition, my lords.
He wants to explain how that plaintiff has obtained that already your amendment is helpful to her. You have denied her title and possession. Now you are saying that she has purchased. You are denying that now that burden is, see, it is not lies on them to prove ownership because you have already admitted. Only thing is that whether you are interfering or not.
That is why how the property has been flow to the plaintiff.
And straight away you said he is not owner, he is not in the possession.
Yes.
Now the burden is heavy on them. Now you have already proved that they have purchased this property. How it will helpful to you, Mr. Yes. Filing an amendment stating that plaintiff has purchased that extent of properties. By amendment, he wants to include that plaintiff has purchased an property by sale deed only to the extent of 100 feet east to west and 200 feet north to south. By allowing this amendment, it will not cause any prejudice to that plaintiff. Since there is a delay in filing this amendment petition after filing a written statement, this amendment can be allowed subject to condition. The petitioner should not seek for recalling that any witnesses, which is already evidence of already witnesses are over. With that condition, the writ petition is allowed. The IA number 18 filed by the petitioner is allowed subject to above said condition. Yes. In the other same,
Same.
Yes. This moves. I don't know what is name on channel.
Lord, serial number 1.
Serial number 21. Yes. (91). What you want, Mister?
Any date, your lordship may fix a date.
Yes, or the request of counsel for the petitioner. This matter on 11th.
My lord, serial number 47.
47.
Kindly have it next week. I am appearing for petitioner.
Yes, 47.
The interim order may be extended.
Yes, interim order if any.
Lord, serial number 1, my lord.
7 and
47, you are for whom, Mister?
Petitioner, my lord.
Huh?
Petitioner.
Petitioner. There is an application for vacating. Have you informed other side?
47 senior argument.
Yes, they have an objection, Mister.
Record advocate is not feeling well.
Yes, he is not well, Mister.
So senior.
No, he is not well. What you say, Mister?
Yes, I forget
Yes. Yes, at the request of counsel for the petitioner. Is this matter on 10th? Interim order granted earlier is extended till next date of hearing. Yes.
Serial number 1, my lord.
Serial number? Yes, 30. Yes. 72.
89.
Yes, Kodi.
Serial number 48. Serial number 89.
48.
Wait for a week's time.
48, we are appearing for whom?
Petitioner, my lord.
Have you informed other side?
My lordship. I am not informed. He is not in the court.
Then you said, it's IA for vacating, Mister.
No, my
You
lordship.
informed and come, yes.
Serial number 89, my lord.
80. 21. Yes, sir. The request of counsel for the petitioner. Reach this matter week after next. Have you informed other side? Then if the interim order has to be extended, you have to inform. 2:30, you inform and come back. Yes.
Serial number 89, my lord.
80?
9, my lord.
Yes.
2 weeks time, my lord, for the respondent.
Henry?
It will illustrate.
Yes.
Serial number 63.
60?
3. And for the respondent number 1, the writ petition in order 7 to 10, I prayed 2 weeks for filing objections.
Respondent.
Respondent number 1.
Yes, sir. The request of counsel for the respondent. Reach this matter 2 weeks. Interim order is extended.
There is no interim order.
Yes. You are further? Memo for retirement filed by that advocate for the petitioner. Yes, at the request of petitioner, reach this matter next. Yes, interim order granted earlier.
ಇದೆಲ್ಲ ಅವ್ನ ಕೈಗೆ ಎಲ್ಲ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಮೂರು ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಸೈನ್ ಹಾಕ್ಸ್ಕೊಂಡು ರೆಕಾರ್ಡ್ ಅಲ್ಲೇ
Mr. Court Master, what the court will resume at 2:30? Mr. Court Master?
Sort of the 49.
49 it will start.
Sir, 89 ಇದೆ, 81 ಇದೆಯಾ?
ಏನ್ ಹೇಳಿ?
Master serial number ಎಷ್ಟು?
ಯಾರು VCL?
Mr. Court Master, what item will start at 2:30?
His lordship only will decide, sir.
No, it ended at what? It ended at what item number just now?
Sir, 50 ಇದೆಯಾ sir?
ತಗೊಂಡಿಲ್ಲ.
80.
ಜನಕ್ಕೆ ಹೇಳೋಷ್ಟರಲ್ಲಿ 2 ಗಂಟೆ ಮೇಲ್ ಹೊರಟಾಗುತ್ತೆ.
Sir, it ended at what item number? I guess 40.
81 ಇದೆ. ಇದೆ. 89 2 weeks adjournment.
46 ಕೇಳಿ.
ಗೊತ್ತಿಲ್ಲ ಆಗೋಯ್ತು 2 weeks ಅಂತ.
ಆನ್ಲೈನ್ ಅಪಿಯರ್ ಆಗ್ತದೆ 46 ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರು.
46
ಅವರು ಆನ್ಲೈನ್ ಇದ್ದಾರೆ ಕೇಳಿದಾರ ಡೇಟಿಂಗ್
ಏನಂತ?
Sir, I am here online, sir. I am here online, sir. Sir, I am here online. Am I audible?
63
ಮಾಡಿಲ್ಲಪ್ಪ ಅವ್ರೇನು ಹೇಳಿಲ್ಲ.
63
Mr. Court Master, am I audible?
ಇದೆ 2 weeks adjourn.
2 weeks.
2 and 3 ನಮ್ದಲ್ಲ ಸರ್.
Sir,
ರೀಚ್ ಆದ್ರೆ ಸಾಕಾಗಿದೆ ನಮ್ಗೆ. ಏನ್ ಹೇಳಿ VCL ಇರೋರು ಯಾರು ಏನ್ ಹೇಳಿ?
Sir, please help. I don't understand Canada. Sir, please speak in English. Not understand. अरे उसको बोलने रीडर को.
ಕೋರ್ಟ್ ಹಾಲು ಇದು. ಸರಿ ಇದು ಕೋರ್ಟ್ ಹಾಲು. ನಾನು ಲೀಸ್ಟ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ನಾನೇನು ಈಗ ಹೋಗಿ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಚ್ ಹೋಗಿ ನೋಡ್ಕೊಂಬರ್ಲ? ಗೊತ್ತಿಲ್ಲ. ಮೆಮೊ ಬುಕ್ ಆ ಕಡೆ ಅಲ್ಲಿರುತ್ತೆ ನೋಡ್ಬೇಕು.
Mr. Court Master, am I audible? Can you hear me?
Yes, sir. You are audible. What do you want, sir?
Sir, my only
audible.
Sir, my simple question is, I am in item 46. At 2:30, which item will start?
That his lordship will decide, sir. After his arrival, he will decide.
Okay, sir. I am
Same
connected.
thing I told you at 1:40, I think so.
Yes, sir. You are right. Thank you, sir.
ಬ್ರೇಕಪ್ ಇಲ್ಲ ಅಂದ್ರೆ ಮಾಡಿ ಅಂತ ಹೇಳಿರ್ತಾರೆ, ಮಾಡ್ತಾರೆ. ಬಟ್ ಇವಾಗ ಡಿಕ್ಟೇಷನ್ ಅಲ್ಲಿ ಆಗಿಲ್ಲ. ನೋಡೋಣ ಆಮೇಲೆ ಹೇಳ್ತೀನಿ, ಇನ್ನೊಂದ್ಸಲ ಹೇಳ್ತೀನಿ. ಬಟ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾನಲ್ಲ ಜವಾಬ್ದಾರಿ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ನಮ್ದಲ್ಲಪ್ಪ. ಏನಮ್ಮ
ಅಣ್ಣ ಮೆಮೊ ಮೂವ್ ಮಾಡಿರೋದು
ಯಾವ್ದಿದ್ರು ನಮ್ದೇ ರೀಚ್ ಆಗಲ್ಲ. ಇನ್ನು ಅದೆಲ್ಲಿತ್ತು. ಹಾ ಮಾಡು ಸಾಹೇಬ್ರಿಗೆ, ನನ್ಗಲ್ಲಮ್ಮ. ಅವ್ರೆಲ್ಲಿ ವಾಪಸ್ ಬಂದ್ರ?
ಇಲ್ಲ ಅವರು ನಾನು ತಂದು ಕೊಟ್ಟರು ಸರ್. ಅವರು
ಮತ್ತೆ ಓಡೋಗಿ ಬೇಗ ಅವ್ರು ಊಟಕ್ಕೆ ಕುತ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ. ಅದು CP ಆಗ್ಬೇಕಾಗಿತ್ತು. ನೀವು ಅಡ್ವೊಕೇಟ್ಗೆ ಹೇಳ್ತೀರಂತೆ, ಇಲ್ಲ ಅವ್ರ ಮುಂದೆನೆ ಬರುತ್ತೆ, ಹೋಗಿ 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 ಅಂತ. ಅವ್ರು ಅದನ್ನೇ ಇಲ್ಲ ನಾನು ಕೇಳ್ದೆ ಅಲ್ಲೇ ಬರುತ್ತೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಅವ್ರು ಯಾರು ಕುತ್ಕೊಂಡು ಅಲ್ಲಿ ಹೇಳಕ್ಕೆ ಅಂತ ಅವ್ರು ಕೇಳೋದು. ಅದೇನು ಕೇಳಿ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ, ನನ್ಗೆ ವಾಪಸ್ ತಂದು ಕೊಡಿ ಅಷ್ಟೇ. ಹೋಗಿದ್ರೆ ಅದನ್ನ ತೋರ್ಸಪ್ಪ ಅಷ್ಟೇ. ಆಮ್ದು ಆರ್ಡರ್ಸ್ ಹಿಯರಿಂಗ್ ಎಲ್ಲ ಹೋಗುತ್ತಾ, ಆರ್ಡರ್ಸ್ಗೆ ಕ್ಲೋಸ್ ಆಗಿರುತ್ತೆ ಟೈಮ್ ಇವಾಗ.
ಸೆಕೆಂಡ್ ಇಷ್ಟು ಫಸ್ಟ್ ಮ್ಯಾಟ್ರ್.
ಎಲ್ಲ ರೆಡಿ ಇದೆ.
Adjournment, sir, between 40 and 68. Huh? Reach agala. Okay.
Submission. Serial number 71, my lord. It may be taken up on Tuesday, my lord, because.
71.
71,
Yes,
Tuesday, my lord.
at the request of petitioner. Leave this matter on Tuesday.
Much.
Morning I was.
What is that urgency?
Execution has been moved.
RFA. Tuesday.
It is Monday.
Okay, Monday.
My
Lord.
lords, serial number 54, my lords. I have informed the other side, my lords. A week's time may be given.
50. You have no objection.
Date may be fixed, my lords. 7th or
54, ah?
yes, my lords.
Yes, at the request of counsel for the petitioner. Leave this matter on 7th.
Interim order may be extended.
7th. Interim
Status-
order granted earlier is extended till next date of.
Much of.
Lord,
Serial
item,
number 47.
item
Serial
for,
number 47. Yes,
1 week came.
new appearing for. Have you informed other side?
ಬೆಳಗ್ಗೆ ಇದ್ರು ಸರ್ ಮಾರ್ನಿಂಗ್ ಸೆಷನ್ ಮಾಡಿ
Inform ಮಾಡಿದಿರ ಅವರಿಗೆ?
ಮಾಡಿದ್ರು.
Yes, at the request of counsel for the.
Interim ಮಾಡಿದೆ
Leave this matter. Yes.
serial number 46, my lord, I request.
230 matter.
Lord, serial number 46, my lord, I request
46.
Tuesday, my lord. I need to file a compilation of a constitution bench judgment, my lord, which I am heavily relying upon. So, my lord, may I have it on a
My lord, I
Tuesday.
appear for the respondent.
Yes.
My lord, my learned friend, he will go to commercial. My lord, kindly see the order on last date.
My
It
lord, I
says
am
that
only
commercial court
requesting
can
for
go on with the
Tuesday, my lord, not on merits. I am not going on merits. I am only
No,
requesting
yes.
for Tuesday.
I will
my lord.
grant, let
On
them, what is
every-
his objection? Let me
Very
know
well.
what is his objection, mister.
Very well.
The court directed the commercial court to go on with, because this is only on the question of stamp duty.
Yes.
There is no stay of proceedings. See, this honorable court directed that the proceedings can go on. Then, my lord, we made the submission before the commercial court. Commercial court finally accepted. Now, my lord, last 2 dates, they come there and take time stating that they have moved this matter. Therefore, please don't hear that matter.
No,
And now, my lord, today when this matter is
Lord,
taken
may I
up,
then
they want this to
clarify?
be adjourned to another day.
May I then clarify, my lord,
No,
this
we'll
is
clarify
absolutely a
that
wrong,
commercial court can go on with that matter.
my lord, this is a wrong statement, my lord. May I say this? My lord, what has
No,
happened is.
okay, both are right. I will clarify that the commercial court can go on
No,
with
my
that
lord, my lord
matter.
may then hear it today, my lord. My lord may then hear it in that case.
Yes,
My lord may not have
we
it,
have
I will
to
not
do
press
an
for.
order.
No, my lord, this is a wrong submission, my lord. Your lordship is not hearing me, my lord, passing an order at respondents.
No,
behest.
I am not. No, I am not recording that
My lord,
statement.
my lord
What is that
allow me
interim
to
order
speak for
granted?
one moment, my lord. But one moment.
Interim order, my lord.
This is, my lord, my
There's a
petition,
direction
my lord, my
impounding
submission.
document and asking him to
No, my
please
lord, this is my petition. I'm
yes.
so sorry, my lord. I'm so sorry. Mr.
No,
Arun,
what
my
you
lord,
want to make submission?
my lord, may I say this with greatest respect, my lord. No, my lord, I am for the petitioner. My lord may hear it today, my lord. I have no difficulty. I will not request for Tuesday.
No, wait. No, there is already an order.
There is.
You,
But that, my lord,
No, my lord, this is
before
no,
the
my lord,
commercial court,
no, my lord,
submission
this
is made that no,
my lord,
I
this
have
is
moved the
my
honorable high court
petition,
stating
my
that this order
my lord, this is my petition. I have to open
matter
the
should not be
sentence.
heard. Therefore, please don't hear me.
My lord, this is my
I am not
petition.
hearing, mister. It is out of turn. You just mentioning that you are arguing that matter.
My lord, it is my case, my lord. I have to open
Mr.
my
Counsel, are you making any submission? No, I
Yes,
am not hearing you. You have moved it matter for adjournment. Yes,
No, my lord,
have
I
you
am saying
made
no,
a
my lord,
submission before that commercial court?
my lord, that's not the correct proposition, my lord. My lord, may hear me one moment, my lord, uninterrupted by the respondent, my lord. That's not the correct proposition. This honorable court is
My
being.
lord,
I'm not hearing on that merit. No,
My lord, I'm not merit.
see,
I am
it
not
is-
on merit
I am
at
not
all.
taken that matter. It is.
I am not on merit, my lord. I am not on merit at all.
Yes,
My lord, only one
Tuesday,
sentence.
yes.
I'm.
At serial number
My lord may
46, it may
take
be
it up and my lord, I mentioned
Yes.
this.
It may be considered at 46.
My lord, I mentioned this matter. My lord, this
Yes,
is.
wait, when the term is. Yes.
My lord, this is a travesty for me, my lord. My learned friend says something, I
Yes,
am
yes.
online, he prejudices this honorable court, my lord, and takes an order. Every time he does so, my lord. My lord, may give me one moment, my lord, to
No,
speak.
No, yes, yes. What is that? What is that you want to make submission?
My lord, I am in a new regime, my lord. I am hit by NN Global Constitution Bench judgment, my lord. Now, my lord, leave and license agreement is being directed to be impounded. Now, my lord, at that time, there was an old regime of NN Global judgment. Now, I am before your lordships, my lord. When I came before your lordships, my lord, there was an interim order in my favor. Now, my lord, thereafter, what happened, this matter was listed on 6th January. My father-in-law expired on that day. I circulated a letter. This honorable court adjourned this matter for 30th January. Now, my lord, at 4:30, the order comes and the order says stay vacated. The order says none for the petitioner, that I am petitioner, and my stay is being vacated on 6th January, my lord. And the order says something which has been contrary to what this honorable court says. Your lordship said 6th January, my father-in-law expired, own father-in-law, and the matter was adjourned for 30th January. Now, my lord, what the order says, none for the petitioner, stay vacated. Now, my lord, in my respectful submission, thereafter I moved an IA for recall for an investigation by
No, it is not vacated, mister. Where is that?
No, my lord,
stay
this is vacated. No, my lord, may kindly see that order.
No, where is that order of?
No, my lord, your lordship may kindly see 6th January order, my lord. No, my lord, I want a CBI investigation, my lord, how an order occurs contrary to what this honorable court says. And my friend always, my lord, is interjecting my submission. Now, if your lordship may kindly see the order, my lord. The last
there is
6th
no
January
interim
order. My lord may have it,
granted
when my
earlier
turn comes, I have no
of hearing.
difficulty. Now, my lord, if your lordship may kindly see that order.
2024.
Now, my lord, none appears for the petitioner. It is made clear that this honorable court has not granted any interim order.
None appears.
Tendency-
Made it clear the court has not granted any interim. Yes, we'll
That's
have it
correct.
on Tuesday.
No, my lord,
Yes,
no, my lord,
Tuesday.
most of this what happens.
Tuesday.
Very well, my lord. Tuesday, my lord. I have no difficulty. I'm so grateful, my lord. I'll come
No,
physically.
no, Tuesday, yes.
I'm so grateful.
Is this matter on Tuesday? Yes, we'll hear on that day, mister. Yes.
I'm so grateful.
Serial number 97. KYIS for petitioner. Matter, Raghunath MD.
The review petitioner, KG Raghavan, my lord, has made his submission.
Yes.
I'll briefly reply, my lord. I won't take too much time because your lordships have already seen the record, my
Yes,
lord,
yes.
very elaborately.
Yes.
I'll only meet the points, my lord, which my learned friend tried to make.
Yes.
I understand, my lord, the first submission was that the Honorable Supreme Court has not given any permission to file review.
Yes.
Lord, it was not my submission.
Yes.
That Supreme Court has granted permission to file a review. The order, my lord, speaks very clearly. And the order simply says, if your lordship has my review petition at 226 at page 281.
Yes.
81. First line of 281.
Yes.
Petitioner state they wish to withdraw these petitions, leaving it open for the petitioners to approach the High Court by way of review petition. Let's stop them, Lord.
Yes.
Honorable Supreme Court is not giving me any liberty. It is my submission that I am going to move this Honorable Court with a review petition. That is noted. Then, my lord, with liberty to approach this court, again, in case the review petition is dismissed.
Yes.
So, in other words, their lordship didn't go into the merits of the order passed by this honorable. Pointed out to them that there seems to be some error which is apparent, which requires correction.
Yes.
This is normally what happens before appellate courts, my lord. The appellate court will ask us, why did you not bring this to the notice of the learned judge or the court below?
Yes.
If you had brought it, maybe some other order would have been passed. So in such a case, the appellate court says, please go and move the learned judge of the court.
Yes.
That's not happened. Otherwise, this last sentence would not have been there. Normally, if they dismissed the SLP on merits, their lordship would have said dismissed. But now they say you can approach the High Court, and thereafter, if there is any dissatisfaction for me, I can approach the Honorable Supreme Court again.
Yes.
So that means they left everything open.
Yes.
So the submission that no permission was given, Lord, is not an appropriate submission, is my respectful submission, Lord.
Yes.
Now, my lord, the other exception he took to was, my lord, the prayer that I have sought in the petition. Your lordships will get the prayer in the review petition,
Yes.
page number 52, my lord. There are
Yes.
three prayers.
Yes.
One is review the order of 7-2.
Yes.
That is the main order, my lord, where lordship accepted the compromise.
Yes.
Confirm the order of 15-2
Yes.
passed by the honorable court in RFA. That is where your lordships confirm.
Yes.
Thereby, the compromise petition entered into between review petitioner and fourth respondent.
Yes.
So in other words, I'm saying the compromise must be given effect to.
Yes.
Your lordships passed that order, thereafter reviewed that order and recalled it. So my submission now is put back status quo ante.
Yes.
So there can be no exception to this. Only question that will arise is, if this review is allowed and the order in the impugned order in the review, if it is recalled, then the case will go back to the stage when the original review petition was there, the compromise petition was there, then they will have to argue to show to your lordships
No,
why
you are
that
seeking for review of this only this order under review.
exactly. Therefore, my lord, if your lordships would be pleased to accept this petition, then all that will happen is go back. Why I'm saying this is, my lord, in terms of the compromise, several steps have been taken. I had possession of the entire extent of 18,000 square feet.
Yes.
16,000. I have now given back 10,000 square feet of land possession. And they have in turn, my lord, sold some portion to some third party.
Yes.
And I had, my lord, the benefit of being in possession undisputedly, my lord, from 80s. So, my lord, all this was changed by the compromise by virtue of the understanding of the parties. So, my lord, if at all an order is to be passed, that should be protected is my respectful submission.
Yes.
Then, my lord, my learned friend said, we have suppressed facts. And for that, my lord, he read out page 217. Now, this is the resolution of my clients who are the owners of the property. Page 217. We are a partnership firm, so we have to pass a resolution. So in our resolution, at the bottom, which just before the bold letters, in view of the same, one line before that.
217.
Yes, 217.
217. Yes.
The last para begins like this. In view of the same, partners resolved as follows. The lordship finds that it's the resolution of Raghav Reddy and Sons.
Raghav Reddy and Associates. 27. Both the parties have decided to settle.
Yes, my lord. That's para.
Yes. Yes.
Para, kindly see the last line, my lord.
Yes.
Being an area of 10,000.
Yes. 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 That is
318 square feet.
Yes.
Earmarked in the sketch annexed to the compromise petition shall be retained by the People Charity Fund.
Yes.
Now, our compromise with them is, I will get 6,000 and odd. I will return this to you. You keep it. So I have recorded that they are going to retain it.
Yes.
But please see, my lord, what the trust says. The trust resolution
Yes.
is at 207. I had pointed this out to your lordships. My learned friend apparently did not refer to this.
Yes.
Page 207. There are 3 paragraphs relating to sale of the property, my lord. Starts at 207. They give the history, last para in 207.
Yes.
The trust has been advised in the present litigation, appeal likely to consume more time, possession, no benefit, past 40 years litigation.
Yes.
No possibility of getting any income.
Yes.
Raghav Reddy are in possession. At the end of long drawn litigations involve expenditure time, it is advised that possibility of the trust getting substantial benefit and associates other than what is stipulated is very remote.
Yes.
Proposal has been negotiated where Raghav Reddy will retain 6,000 out of 16,000. Substantial portion will be surrendered, returned back to the trust. This will enable the trust to raise substantial funds to fulfill the objectives and activities.
Yes.
Lord, I would only understand this like this, my lord. What will they use this for, my lord? This is a charitable trust.
Yes.
It's a vacant land. It has nothing on it, no structure, no building. I can understand if there's a building, they can let it out, get some rent. It's vacant land, which they're getting after this 25, 30 years of, 40 years of litigation now. So they take this, then noting this, my lord, please go to next para, my lord. The proposal was discussed, debated in the background of legal financial advice taken by trustees from the advisors. All pros and cons identified, weighed and debated. Trustees have taken advice of legal luminaries who have held responsible position. Then what? Next para.
Yes.
about 5 lines from the end of that.
Yes.
It, K. Raghavar Associates, in view of the said entity giving up its claim to the entire property, the balance area being an area of 10,318 square feet, earmarked in the sketch annexed to the compromise petition, shall be sold by the trust
Yes.
to raise funds for setting off expenditure for generating funds of finances to undertake further charitable activities in a larger scale with wider reach.
Yes.
Not is what I respectfully place for your lordship's understanding, Lord. My last date, my learned friend has no answer for this. Absolutely nothing about this. So this is a resolution of the charity, and your lordships have already seen the case law, my lord, on the question as to what is the power of the trustees to do this. Now, my lord, flippantly, my lord, with due respect, I'm submitting. Very sarcastic submission was made that, oh, ಇದು ಕಾಂಪ್ರಮೈಸ್ ಇಲ್ಲಿ ಸೈನ್ ಆಯ್ತು, ಕೋರ್ಟ್ ಕಾರಿಡಾರ್ ಅಲ್ಲಿ ಯಾರೋ ದುಡ್ಡು ಇಟ್ಕೊಂಡು ರೆಡಿ ಆಗಿದ್ರು, ಅದಕ್ಕೆ ಸೇಲ್ ಡೇಟ್ ಮಾಡ್ಬಿಟ್ರು ಅಂತ. That is completely unjustified. You see this resolution, my lord. This resolution is compromise petition.
Yes.
And, my lord, your lordships may take note of the fact that a compromise like this, my lord, involves several parties.
Yes.
And if a third party, my lord, comes and says, I am going to take this property, I am going to fund the trust in this manner, if you settle with Raghav Reddy and they take a decision that they should settle, instead of 16,000, they get 10,000. Instead of 16,000, I get 6,000. So it is a win-win situation for the trust. They have got everything that they can think of with no litigation whatsoever. And they have, my lord, if there was no buyer, if there was no negotiation, there was nothing, I asked myself, but how could I pass a resolution on 6th February? A absurd statement is made in the resolution of the trust. What I say, my lord, I am a third party. I say they're going to retain it, but they say we're going to sell it. This was before your lordships, my lord, is my respectful submission. Lord, the last point which my learned friend made, kindly take the statement of objections.
Yes.
Page 51.
Objection in which?
In RP 226. Number RP 226 ಅಲ್ಲಿ objections filed by the other side. The same thing what is there in the resolution. This is the document, my lord, under which the trust
Yes.
the objections of respondents 1 to 3.
Yes.
The sale deed under which they sold it, my lord.
Page number
43. It begins at 43. It is
Yes.
dated
Yes,
15th February 23.
Yes.
Registered, my lord, on the same day.
Yes.
It is in favor, my lord. Next page, your lordship. First page, your lordship, people charity represented by so and so.
Yes.
Second page, my lord, in favor of building blocks INC.
Yes.
Represented by so and so. He is the purchaser.
Yes.
My lord, in this registered document, kindly turn to page 51. They have actually put down in writing what the resolution of the trustees was. The para number 8, my lord, Roman number 8. The seller, Raghav Reddy Associates, were not able to fully conclude the litigation despite several years and incurring huge expenditure. Seller was not able to derive any income from larger property. Raghav Reddy was in possession, was unable to develop the larger property in view of the uncertainties in the litigation. At the intervention of well-wishers of the parties, professional advice in the interests of the seller and K. Raghav Reddy and Associates, and decided to amicably settle the disputes. Then, my lord, lower down in that, they say, the larger property is described in schedule here under, hereinafter after scheduled property, which the seller trust has agreed to retain for itself. In terms thereof, the seller trust agreed to fully and finally settle the compromise, their dispute. The seller have recorded the aforesaid settlement arrived at between themselves in terms of the compromise before the Honorable High Court. Then, Lord, next, same page, last 2 lines. Therefore, the trustees of the seller trust, after evaluating all circumstances, by its resolution dated 6/2/23, taken a decision to liquidate objectives and purposes of the trust to undertake charitable activities in a larger scale to ensure wider reach. Seller has come forward to sell the property, purchaser on the other road, then operative portion. And the trust, my lord, under this document gets 12 crores 37.5 lakhs. Your lordships will get consideration at page 54.
Yes.
No, in a situation that the trust had nothing, by this compromise, this is what the trust obtained. Now, my lord, the submission is that this is a fraudulent one. My lord, on that, my lord, we already addressed your lordships. This trust selling property is never fraud, unless they make out something, and for which they have already filed a case. So they can't again, my lord, re-agitate that matter. The last submission, my lord, was more a submission on sympathy to say that the court, this is a public charitable trust. Therefore, the court is the patria paternus of this, and court has every right to look into everything that is done. Now, my lord, the Honorable High Court exercising jurisdiction in a first appeal is different from the Honorable High Court exercising jurisdiction in a first appeal from an order or a judgment under Section 92. 92 order, my lord, under Civil Procedure Code, if they go against a trust and the district judge, learned district judge, my lord, is pleased to accept and pass some order, then when the matter comes up in appeal, your lordships are continuing the proceedings there. So the wide discretion which was available before that court is very much available to the appellate court as appellate court. But not today, that discretion, that jurisdiction is not what your lordships are exercising. Your lordships are not seeing the conduct of the parties here. Your lordships are not seeing what is this trust, why is it selling. All that can be done in those proceedings. Supposing, my lord, the trust sold the property without following any procedure. Suppose it sold at 50% of market value. This can be examined there. But that's not the case here. No such allegation is made. And that jurisdiction is not being exercised. Therefore, my lord, that should not come in the way of your lordships for entertaining. The last submission, Lord, he relied on a judgment of the Supreme Court in 2022, SCC Online, 1034, Madhusudan Reddy's case. There, my Lord, a CRP order was made that is challenged in review. A review was dismissed. A second review was filed. So, my Lord, that judgment is not of any use because here it's not a second review. There is one order passed by your lordships. That order, my Lord, is sought to be now reviewed in this application. So, this judgment will not come to that. I'm grateful. Lord, what has happened is now with this order and the compromise, 3 other proceedings got closed.
Yes.
There's a suit filed by me, there was a CRP, and there is the first appeal. Now, my lord, if this order stands, then I neither have the property, I neither have the asset, I neither have possession, and I neither have litigation. So there is nothing that I can do except to just walk out with the empty hands after 40 years of litigation. That could never be, my lord, your lordship's intention. Therefore, my submission, my lord, is that that issue may have to be re-examined by lordships is my respectful submission. I confined myself to only one point, my lord. Though a number of issues were argued before your lordships confined it to one point. That point is, you said you're going to retain, but you're selling it, you sold it. Therefore, this is not a fair thing to do. For that, my lord, there's material now to show that it was always disclosed and there was nothing secret or hanky-panky about it. There's no fraud whatsoever. And they've not alleged fraud also, at least not in these proceedings. Great.
Yes. Yes, resort. You want, I thought that one. Yes. Yes. No, when it started 2:30, I saw only Naganan. I thought that. Yes. Yes.
My lord, first of all, my lord.
Yes.
Please look at, my lord, the review petition itself. Page Tao, review petition which they had filed, my lord. Please look at the pleadings. I'll tell your lordships why.
Yes.
My lords, get that. The pleadings, my lord, in the review petition. Sorry. Bande. Ide. ಇಲ್ಲ ಅವ್ರ ಪೇಪರ್ ಯಾವ ಪೇಪರ್ ತಗೊಂಡಿದ್ದೀರಿ ಯಾವ ಅವ್ರದ 226 ಬಿಕಾಸ್ ತಾವು ಒಂದನ್ನು ಯಾವ್ದಾದ್ರು ಒಂದು 226 ಯಾಕಂದ್ರೆ ನಮ್ಮ 230 doesn't matter. I'll
review petition.
Very well. I'll just tell you.
That is.
Lord, I'll just, my lord, tell your lordships.
Yes.
Their main grounds are, my lord, 4 in number. Please come to, my lord, running page 70, 269, my lord. 1 minute.
269.
Idalre.
269 ಅಲ್ಲ.
My lord, the 274, my lord, is a review petition starts, 276 bani.
Yes, that is correct.
My lord, 4 grounds are raised.
Yes.
I'll tell your lordships why.
Yes.
A person, my lord, cannot, my lord, go beyond the pleadings.
Yes.
First ground is, suit filed, my lord, is not maintainable since it is barred by limitation. First ground avaradu.
Yes.
Please look at, my lord, clause 1. Ground only 1, first para.
Yes.
Second, my lord, contention that they have raised is,
Yes.
there is nothing to show that the second trustee has joined, my lord, in the compromise.
Yes.
This is the second contention. Third contention is that, my lord, there is an error apparent on the face of the record because they are giving up, my lord, they are giving a no objection. Compromise ಬಗ್ಗೆ ತಾವು, your lordships are not satisfied anteli.
Yes.
Third contention. Fourth contention is, having regard to, my lord, the history of litigation, there is a sudden change of heart, therefore, the, my lord, it is not bona fide. 4 contentions bittu ಬೇರೆ ಯಾವುದು ಇಲ್ಲ.
Yes.
First submission of theirs was,
Yes.
my lord, we are my lord, we are beneficiaries. Not a, my lord, whisper, my lord, in the entire, my lord, RP,
Yes.
saying that they are beneficiaries. If that is so, my lord, what they have, my lord, argued and which your lordships, my lord, found to be correct, is on the face of it, my lord, is not tenable. First two. Secondly,
Yes.
your lordships held, my lord, that they are trustees because under the will, my lord, they are trustees. My lord, they are, my lord, beneficiaries. They are not beneficiaries of this trust. Some different property is given to them, my lord. Please look at the will. Will hakidara avaru. Our will hakilla.
Yes.
Our will hakilla. And, my lord, in the entire pleading, my lord, as hakidira yav torsiya.
Along with the review.
Copy ಕೊಡ್ಲಿಲ್ಲ ನೀವು, doesn't matter.
ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ sir.
ಆಯ್ತು, ಇರ್ಲಿ, doesn't matter.
Yes.
ನಿಮ್ ಕಾಪಿನೇ ತಗೊಂಡು
Bill ಹಾಕಿದ್ದೀವಿ ವಾಲ್ಯೂಮ್ 3 ನಲ್ಲಿ.
ಆಯ್ತು, ವಾಲ್ಯೂಮ್
Volume 3
3
ನಲ್ಲಿ.
ಆಯ್ತು, ಕೊಡಿ.
Volume 3 of the documents filed in RP. RP.
RP ನಲ್ಲಿ ಹಾಕಿರೋದು ಇಲ್ಲಲ್ಲ.
Yes.
ಮತ್ತೆ ಆಯ್ತು, ಇರ್ಲಿ, doesn't matter. Please have, my lord, our first RP ನಲ್ಲಿ ಅವ್ರು ಏನೋ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ರಂತೆ ಸ್ವಾಮಿ. Please come to, my lord. Will is supposed to be at page 151.
Yes.
ಇಲ್ಲ 151. Yes. Correct. My lord, not a whisper, they are, my lord, beneficiaries under this trust.
Yes.
What is not there, my lord, I can't show.
Yes.
Please come to, my lord. If your lordships look at, my lord,
ಇದಲ್ರಿ ಹಳೆದು.
page 156 ಬನ್ನಿ ಸ್ವಾಮಿ. ಅಲ್ಲ, ಹಳೇದನ್ನು ಹಾಕಿದ್ದಾನೆ ಅಂತಾರೆ, ಇಲ್ಲಿ ಹಾಕಿಲ್ಲ. ಗೊತ್ತಾಯ್ತ್ರಿ.
159 ಅಲ್ಲಿ
ಬಂದೆ.
RP 235.
235 ಅಲ್ಲಿ ಅವ್ರೇನೋ ಥರ್ಡ್ ವಾಲ್ಯೂಮ್ ಹಾಕಿದಾರಂತೆ ಸ್ವಾಮಿ.
Volume 3. There are 4 volumes. Volume 3 ನಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ. ಇಲ್ವಾ?
My lord, I'll pass on, my lord.
Yes.
ಕೊಡಿ.
ನಿಮಗೂ ಎಲ್ಲ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ. Yes.
My lord, please come to page, my lord, 156 ಬನ್ನಿ. Will ಅಲ್ಲಿಂದ ಶುರುವಾಗತ್ತೆ. Will ಅಂತ ಬರುತ್ತೆ ಸ್ವಾಮಿ.
Yes.
156, my lord, second unnumbered paragraph. Will.
Yes.
This is the last will and testament of Ramalingam.
Yes.
Now, my lord, please come to, my lord, page 158.
Yes.
Second unnumbered paragraph. I give unto the persons named below money set out against each of them.
Yes.
Skip that. Please come to the bottom. In addition,
Yes.
what they would receive as stated above, I give the following persons the properties set out against each other.
Yes.
Please see, my lord, at page 159.
Yes.
Kausalya Ammal, my lord, is 1, 2, 3, 4. She is given only, my lord, 23 Cunningham Road, not this property.
Yes.
This property, my lord, is a separate trust created, my lord, for a different purpose altogether.
Yes.
So, my lord, they are not beneficiaries under this will.
Yes.
The mistake that has occurred, my lord, is they went on saying she is a beneficiary, she is a beneficiary. First of all, my lord, there is no pleading. Secondly, my lord, it is not even, my lord, in the will that she is a trust, my lord, beneficiary under this trust. Trust is separately created.
Yes.
Therefore, my lord, the first contention that they are beneficiaries, my lord, if your lordship look at, my lord, your lordship's order. Come to, my lord's order. At, my lord, running page. I don't know, my lord, the pages differ. I'm sorry. My
Yes.
profound apologies. Please come to, my lord, running page, my lord, 93. Adaralli.
Yes, these are either 56. Yes, internal page you mentioned. I got that.
Oh.
Yes.
Idralli your page number ಬೇರೆ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ. Sorry.
Internal page of that order under review.
ನಮ್ದರಲ್ಲಿ ಅವರದ್ರಲ್ಲಿ.
Allah, you are now referring to that my earlier review.
Yes,
petition
my lord. Yes, my lord. I'm sorry.
Yes, I got that order.
Yes,
but
yes.
you can manage.
Please, my lord. I'll just point out. Yes,
page. Yes.
I'll just point out
Yes.
the. Please come to, my lord, page 76, internal page 21.
Yes.
Adaralli second unnumbered paragraph, my lord, they have also filed ಅಂತ ಬರುತ್ತಲ್ಲ.
Yes, yes.
Miss petition number so and so
Yes.
before the principal city civil court, civil judge Bengaluru.
Yes.
Petitioners are the heirs of original creator of the trust. Also, they are beneficiaries of the second respondent, public charitable trust. This, my lord, is a error that has occurred. They are not beneficiaries under the will in respect of this trust. Therefore, my lord, their main ground was they have a locus because they are beneficiaries and theli.
Yes.
No pleading. Will, my lord, also doesn't show, my lord, that they are beneficiaries under the trust.
Yes.
Therefore, my lord, the first basis on which, my lord, they went on, my lord, what happened was, we, my lord, keep on, my lord, badgering your lordships. Our beneficiary. ಅಂತ. ಪಾಪ ತಾವು ತಮಗೆ ಅಸಿಸ್ಟೆನ್ಸ್ ಇರೋದಿಲ್ಲ, ತಾವು ಕೂತ್ಕೊಂಡು ಜಡ್ಜ್ಮೆಂಟ್ ಬರಿಬೇಕಾದ್ರೆ. ಇಲ್ಲಾದ್ರೆ ನಾವು ಇರ್ತೀವಿ, ಹೇಳ್ತೀವಿ. ಅವ್ರು ಹೇಳ್ತಾರೆ, ನಾವು ಹೇಳ್ತೀವಿ. Your lordships, my lord, have 100 cases every day. ನಮಗೆ ಒಂದಿರುವಾಗಲೇ ಮರ್ತೋಗ್ಬಿಡುತ್ತೆ. 100 ಕೇಸ್ ಇರುತ್ತೆ. Mistake ಆಗಿದೆ. That's all, my lord. That is why, my lord, we filed the review. Went to the Supreme Court. Supreme Court said, yes, file a review before your lordships.
Yes.
Therefore, my lord, the first ground that they are beneficiaries
Yes.
was the basis on which, my lord, your lordships, my lord, reviewed the petition.
Yes.
Judgment passed by your lordships. First. Second ground, my lord, is, as I was submitting, the that, my lord, trustee had not joined in the compromise. My lord, please come to the resolution itself, my lord, which your lordship, my lord, Mr. Naganand already pointed out.
Yes.
Page, my lord, 36 ಅಲ್ಲಿ ಬರುತ್ತೆ ಸ್ವಾಮಿ. Page 36. Sorry, ಅಲ್ಲ 36 ಅಲ್ಲ, sorry.
Resolution.
ಒಂದು ನಿಮಿಷ.
In 217.
217, my lord. I stand corrected. I'm sorry, my apologies.
217 is
217. Please. 207, my lord.
207. Yes.
Both trustees, my lord, are parties to the resolution, which is placed before your lordships.
Yes.
This is a resolution passed by, my lord, the trust.
Yes.
Please look at the bottom. Both the trustees, my lord, are there. Now, please come to, my lord, page 208.
Yes.
About trust has decided to settle, my lord, fourth unnumbered paragraph. Yeah, my lord, Naganand already pointed out to your lordships. There, my lord, they are saying this compromise, my lord, is in my lord, the interest of the trust. I tell your lordships why. My lord, please look at, if your lordships take, my lord, ಇದನ್ನ ಎಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ? My lord, there have been litigation for the last, my lord, 25 years, 40 years.
40 years, yes, it is.
Now what has happened is, we have, my lord, in 232 On 7/1/25, my lord, we filed the judgment. One judgment. What happened was, seven one 25 ಅಂತ ಹೇಳಿ ಸಾರಿ ಇದೇ ಆಗೋದು ಕೊನೆಗೆ ತಮಗೆ ಅಸಿಸ್ಟೆನ್ಸ್ ತಾವು ಕೂತ್ಕೊಂಡು ಚೇಂಬರ್ಲಿದ್ದಾಗ ಅಸಿಸ್ಟೆನ್ಸ್ ಕೊಡಕ್ಕೆ ನಾನು ಐ ಟ್ರೈ ಟು ಗಿವ್ ಎ ನೋಟ್ ಮಲಾಟ್ ಸೊ ದಟ್ ಐ ಟ್ರೈ ಅಂಡ್ ಬಿಕಾಸ್ ಜಸ್ಟ್ ಟು ಅಸಿಸ್ಟ್ ಮಲಾಟ್ ನಾಟ್ ದಟ್ ಮಲಾಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಆರ್ ನಾಟ್ ಕೇಪಬಲ್ ಆಫ್ ಬಟ್ ದೆನ್ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ದೇರ್ ವಾಸ್ ಮಲಾಟ್ ಎ ಸೂಟ್ ಫೈಲ್ ಬೈ ದೆಮ್ ಫಾರ್ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್. ಇದು ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಗೆ ಇಂಜಂಕ್ಷನ್ ಒಂದು ಸೂಟ್ ಹಾಕಿದ್ರು. That my lord came to be my lord allowed by the trial court. Sorry, order 7 rule 11 ಹಾಕಿದ್ದು dismiss ಆಯ್ತು. This honorable court, my lord, please come to my lord page 1. ಇದರಲ್ಲಿ suit my lord is OS 8357 of 2008. They are my lord, lessees my lord is undisputed. They are in possession undisputed. Suit my lord, page 25 one. This my lord came to be rejected. My lord, plaint came to be rejected. On the ground that they are my lord no cause of action until. This honorable court set aside that order. Please come to running page 35. Please come to my lord running page 53. 52. Appeal is allowed. Trial court, my lord, order dated so and passed by the trial court is set aside. Suit is registered as the file of the trial court with the direction to continue the suit at the stage from the stage where it was left. Dispose of the suit in accordance with law as early as possible on the merits. Made clear that whatever observations so on. Idinna Supreme Court tagondu. We went to the Supreme Court. Next page. Supreme Court dismissed it. What, my lord, why I am pointing out is under my lord 53A part performance, if a tenant my lord is in possession and my lord there is an agreement to my lord enter into my lord to sell the property because specific performance suit is my lord for idike. Your lordships have time and again held. My lord, Supreme Court also has held. Your lordships court also has held. That my lord specific performance bar adruno injunction my lord. Then they will be eternally there for the entire property. We will not get 1 cent, 1 rupee. Therefore, my lord, it was in the interest of all of us, the trust, the beneficiaries of the trust, that my lord, we had to enter into this kind of an agreement where under, my lord, we, my lord, agreed to give them, my lord, 6,000. Somebody, my lord, was willing to purchase, my lord. We said then, oh, we'll sell it and then use it, use this property. My submission to your lordships is the main ground, my lord, why, my lord, we had to do this was 40 years we have fought for. And my lord, this suit, your lordships have seen. ಇದು ಇನ್ನೂ ಪೆಂಡಿಂಗ್. ಈಗ ಮೊನ್ನೆ ಕ್ಲೋಸ್ ಆಯ್ತು ಇದಾದ್ಮೇಲೆ ತಮ್ಮ ಜಡ್ಜ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಅದು ಕ್ಲೋಸ್ ಆಯ್ತು. ಇಲ್ಲದೆ ಇನ್ನೊಂದು 25 ವರ್ಷ 30 ವರ್ಷ my lord, we will be in that same position. We will not get possession. Eternally, we will not get possession. 53A of my lord of the TP Act, my lord, if a judgment is needed, my lord, my lord, any number of judgment ತಮಗೆ ಗೊತ್ತಿದೆ. Specific performance bar ಆದ್ರೂನು injunction my lord is they can continue my lord eternally. Therefore, it was in our interest, my lord, in the interest of the trust that we had to enter into this agreement. Then my lord, I gave your lordships, my lord, several judgments on the last occasion. Pleading ilde idre. Then my lord, parties can't go beyond the pleadings. 232 RP 232 ನಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು ಜಡ್ಜ್ಮೆಂಟ್ 232 ಅಲ್ಲಿ ಇಲ್ಲ 232 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೆ ನಾನು. ಸ್ವಲ್ಪ ನಾನು ಹೇಳ್ತೀನಿ, ನನಗೆ ಗೊತ್ತಿದೆ ನಾನು ಏನ್ ಹೇಳ್ಬೇಕು ಅಂತ ಗೊತ್ತಿದೆ, ಸ್ವಲ್ಪ ತಡಿ, ಜಸ್ಟ್ ವೇಟ್.
232.
Yes, my lord. Please come to my lord. Page, second page. Parties cannot travel beyond the pleading. First page, my lord, absolutely first.
Yes.
First of all, my lord, other second page. 2008. 11 SCC 652. Parties to the suit cannot travel beyond the pleadings. So also court cannot record any finding on the issues which are not part of the pleadings. Any finding recorded on an issue dehors the pleadings is without jurisdiction. Second is 2019-11. SCC. Civil courts are decided on the basis of pleadings and issues framed. Parties cannot be permitted to travel beyond the pleadings. Third is, my lord, our own High Court division bench, where, my lord, this honorable court has held that, my lord, questions
Yes.
pleading, my lord, is what is needed to be looked into. Idralli pleading illa.
Yes.
There, my lord, that they are beneficiaries, one word illa. Therefore, my lord, my submission to your lordships is the contentions that they have raised, that they are beneficiaries, no pleading, will does not show, my lord, though the, my lord, your lordships came to the conclusion that, my lord, because they went on, my lord, badgering. Idu Goebbels anteli Hitler iddu obba information ministry idda. At time alli, my lord, judgment baribekare after, my lord, so many days, my lord, your lordships will be writing the judgment. And your lordships will have, my lord, every day 100. Namage irodu ondu 5-6 adunu marth hogbiಟ್ಟಿರುತ್ತೆ ನಮಗೆ. Therefore, my lord, the error there requires to be corrected. Third submission is, therefore, my lord, first contention that they are trustees, my lord, is not correct. Second contention that, my lord, second trustee, my lord, is not a part of it, not correct, because the board resolution, my lord, the resolution of the trust itself is placed before your lordships. Third, court is not satisfied that, my lord, compromise is lawful. My lord, ಅದಕ್ಕೆ judgment ನಾನು ಹಿಂದೆನೇ ಕೊಟ್ಟಿದ್ದೀನಿ. Ultimately, my lord, when your lordships, my lord, apply your lordships mind, it is deemed, Supreme Court has time and again held, it's deemed that your lordships, my lord, are satisfied that it is lawful. Fourth ground is litigation. In fact, my lord, litigation, my lord, support us. This pendency of the litigation for 40 years, next, my lord, another, my lord, we will eternally not get, my lord, property. Therefore, my lord, it was in the interest of the trust. Then, my lord, the next contention that has been canvassed before them is the limitation. My lord, limitation bar agide.
Yes.
Therefore, court has no use, and therefore, my lord, there can't be a compromise. My submission to your lordships is compromise, my lord, is a contract. All that, my lord, we place before your lordships is, my lord, a contract. If your lordships are satisfied that the contract is, my lord, lawful, your lordships will, my lord, approve it. Therefore, bar of the suit, my lord, or by limitation is of no consequence. What, my lord, your lordships will be looking at is the compromise lawful? That is all that your lordships will look at. Therefore, my lord, my submission to your lordships is that the question of limitation, all that is of no consequence.
Yes.
ಯಾವುದು? In fact, a specific performance alli, if, my lord, the Raghav Reddy Associates had succeeded, we would have got, my lord, ಎಷ್ಟು? 8 lakhs.
Total consideration is 10.
We, for the entire property, we today, my lord, got 12.5 crores. Ultimately, my lord, trust, my lord, is required to, my lord, carry on with its activities. For 40 years, my lord, there was a lull, because the property which was given to us was, my lord, in the custody of this tenant. Then, my lord, lastly, my lord, my submission to your lordships is that compromise is vitiated by on account of sale. My lord, the resolution itself, my lord, indicates that. And I pointed out on the, my lord, when I first started this argument of this review petition, my lord, when we, my lord, enter into, my lord, any kind of, my lord, pass a resolution that we will sell it, there's bound to be, my lord, a discussion prior to that. It's not as if, my lord, overnight, my lord, compromise ಆದ ತಕ್ಷಣ ಯಾವನು ಅಲ್ಲಿ ದಾರಿನಲ್ಲಿ ಸಿಕ್ತಾ ಬನ್ನಿ ನಿಮಗೆ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ದಲ್ಲ. It was, my lord, there they brought about, my lord, the entire, my lord, settlement, and therefore, my lord, this settlement came about. Therefore, my lord, my submission to your lordship says this is a case, my lord, where the review has to be allowed. In fact, Supreme Court found, my lord, that it is a quit case, my lord, where your lordships will review, my lord, your lordship's order. Yes. And therefore, my lord, said, yes, go and file a review petition. Therefore, my lord, my submission is this is a case, my lord, which requires to be, my lord, allowed. In fact, your main case of fraud on fraud, not even a whisper, my lord, not even a whisper in the entire pleading. Hello, hosa argument to hosa idu. Therefore, my lord, my submission is it's a case, my lord, where it has to be allowed. Ilde idre, my lord, what will happen is this will get resurrected. Even if, my lord, specific performance is not granted, suit, my lord, injunction will be granted, confirmed. Next, my lord, till eternity, my lord, we will not get this property, and we will not get anything. Therefore, my lord, it's in the interest of the trust that, my lord, the review has to be allowed. Grateful.
Yes, yes.
My lord, can I be permitted to, my lord, to go to
Yes,
other
yes,
court,
yes.
my lord?
you can-
Please.
yes.
Not my submission would be
Yes.
that the principal reason now, my lord, on which the order requires review is that, my lord, there is no finding while granting the review that there's anything unlawful in the compromise. But I have already pointed out, my lord, two judgments of the Supreme Court which say that if a compromise is to be set aside or recalled, there must be a finding that the compromise is unlawful on the grounds, my lord, urged under sections 15 to 20 of the Contract Act. But already cited, my lord, two judgments, my lord, on that aspect, my lord, and
Yes.
they've not, now the order, my lord, which is sought to be reviewed here, there is no specific finding that this compromise is unlawful on the grounds under sections 15 to 20 of the Contract Act. Therefore, my lord, one of the principal requirements for a compromise to be recalled is not present, my lord, in the order, and therefore, my lord, that's a ground for review. Secondly, my lord, that is not even urged in the review petition. Your Lordship would just have a look at, my lord, the review petition again, the grounds urged. Your Lordship would only note, my lord, two aspects. There is no plea with particulars of any fraud. At, my lord, page number. Page 276, my lord, is, your Lordship has the review petition.
Yes.
In the same volume, my lord, which your Lordship has been referring to.
Yes.
Your Lordship would only note, my lord, the surprising aspect is this review petition is filed
Yes.
after the compromise is accepted and the sale which they are claiming now, my lord, and vehemently agitating that somebody came in the corridors, was ready with money, my lord, all flippant, my lord, submissions which could be made across the bar is made. But what prevented them from urging with the same vehemence any of those contentions, my lord, in the review petition is what, my lord, belies logic. Your Lordship would have a look at, my lord, the contents of the review petition at page, my lord, 276, my lord, your Lordship has in the grounds. Yeah, in the, this is one of the earlier review petition, page 270. In that RP 226, my lord, the compilation. Mr. Holla, my lord, just now took your Lordship, my lord, through the grounds at page 276. What is, my lord, striking is the absence of any plea of fraud from 276 to 278, my lord, of the grounds.
You have, he has shown in this 226 itself, there is an error that 226.
226 itself, my lord, that's the volume, my lord, your Lordship has been having, my lord.
No, in 226 itself, that has been placed as an annexure.
Yes, my lord, that's, my lord, at page 276 in that volume, my lord.
Page number?
276, my lord.
Yes.
276 to 278, my lord.
274.
274 it starts, my lord. 276 is the grounds.
Yes, yes.
276 to suit is 78.
Yes.
What is stark, my lord, is the absence of any plea of fraud.
Yes.
Second aspect, my lord, is that it is not in the interest of the trust is also not pleaded.
Yes.
They were aware of this sale of the balance portion, my lord, in favor of the third party. Third party is not impleaded, though they are aware that now an interest is created in favor of the third party. Third party is not impleaded. There is no allegation, assertion of it being not in the interest of the trust. No allegation of fraud. Therefore, not two grounds, if at all, which could have been available for review, which is that fraud or there is anything unlawful in the compromise. That very pleading is not there. Therefore, not in the absence of that pleading, and of course, my lord, your Lordship has therefore, since there is no pleading on that, my lord, your Lordship has also not made any finding. But that is essential under law, my lord, in order to set aside a compromise decree by virtue of two judgments of the Supreme Court, which have already relied on, which clearly say solemn compromise cannot be recalled unless it is shown, and the burden is on the party asserting or seeking for recall to show that it is vitiated by fraud. Therefore, that is, in my humble submission, absent, and that itself is calls for review of this order, not is what I would submit. Second aspect, not is Mr. Naganand and Mr. Holla have pointed out how the other ground which was urged orally, that the compromise did not disclose the sale, has been disclosed. Your Lordship has seen the resolution, but apart from the resolution, Your Lordship would also recollect that in the compromise petition itself also, Lordship, just have a look at the compromise petition. Your Lordship would have that page 172, in the same compilation.
Yes.
At page 180, at para 17 of 180, in the same compilation. Clause 17 of the compromise petition.
Yes.
Your Lordship has seen earlier, that the resolution is also made a part of the compromise, because at page 178, the resolution is referred to and is annexed as an annexure D to the compromise. And therefore, not any annexures have to be read as part of the compromise. In addition to that, clause 17, at page 180, the sale is in the best interest of the respondent trust, and the sale proceeds will inure to the benefit of the trust in doing charitable activities in consonance to the deed of trust. Therefore, this has been disclosed that there is a sale of the balanced land also. But here I would draw a distinction between what is disclosed and mentioned in the compromise and what is subject matter of compromise. The subject matter of compromise is only the handing back of this one portion to the plaintiffs, which Your Lordship would find a reference at para 2 at page 173. The subject matter of compromise is between the two parties.
Yes.
That is the appellant and the respondent.
Yes.
Appellant got one portion, which Your Lordship would find at page 173,
Yes.
para 2A. He in turn gives possession of the balance to us. And then we agreed to sell that portion which is allotted to him. There was an agreement of sale for the whole of it. We say we will sell this portion. That is the subject matter of compromise. The sale of the balance, while it is disclosed in the compromise, as Your Lordship said, in all fairness, we have pointed out in the resolution also and in the compromise petition, that is not subject matter of compromise, because the appellant here is not concerned with what we are selling. We are not sold it to him. The balance we have sold it to a third party. Therefore, that really is not a subject matter of compromise. Therefore, my humble submission would be, assuming for the sake of argument, even though the record would clearly show we have disclosed about the sale, if the sale had not been disclosed, it would have been irrelevant. Because the subject matter of compromise is only what we have handed back to the appellant, we have agreed to convey to him. Now, insofar as that is concerned, it is evident that it is in the interest of the trust, because litigation has been going on for 40 years. And as Your Lordship notes, even in the order which is under review now, Your Lordship does not find any difficulty with that portion of the compromise where we have given one portion of the property back to the appellant. Appellant has given back possession of the whole. Your Lordship has not found that.
If that your interest is only to settle with that Raghavendra
Please.
Reddy,
Please.
you could have done it and leave it. You can sell the other part.
That is how we have done, but not the
But
as
why you have asked all these things?
not because we have been open.
Taken see,
It's part
not
of
relevant
not
to
as
this
was
case.
pointed out here. Your Lordship is right, Manoj. I'll just answer that, Manoj.
It's not relevant to this case.
Correct, Manoj. Your Lordship is
Not a party.
Your Lordship is absolutely right.
You want to take a seal of this court for
There is no seal of the court required for that. Manoj. Your Lordship has said, therefore, Your Lordship has to see what is the subject matter of the compromise.
No, that
What has happened? It is not our case that by this compromise, if the present respondents and the earlier review petitioners were to seek to challenge the sale, that disorder will come in the way. That's not our case at all. Because Your Lordship is right. Subject matter of compromise is this. We have disclosed because it was part of one transaction where a third party case, as was pointed out by Mr. Naganand and Mr. Holla also, he said, I will try to get the other party to settle, provided this happens. And therefore, it is part of the transaction that it happened. That yes, a third party came, he agreed to give back possession and pay a small amount, whatever is the balance, and then we sell the balance to it, because otherwise we would not be able to do anything with the property. Now the question is this. He could have, of course, not kept quiet. But we have come with open hands and told what is happening. After being aware, when this review petition is filed, he does not question it. That's what Your Lordship has to now see. What is being done is now an afterthought. Because in the review petition, he had no difficulty insofar as sale is concerned with the third party, because no allegation is made about it. And your lordship also notes in the miscellaneous which was filed, till now also there is no challenge. In the miscellaneous petition which was filed, of course it was filed earlier. Till today, either there is no challenge to that by them or not by way of an amendment, no challenge at all. Therefore, my lord, this is nothing but I would say, my lord, just a red herring being shown up to somehow, my lord, come in. And I'll point out to your lordship, my lord, why. Now, my lord, one important aspect which has been suppressed by the other side. Much has been argued that I am the daughter of Ramlingam, etc., my lord, and now, of course, Mr. Holla has pointed out they are not beneficiaries under the will. But my lord, one interesting aspect which is evident from a judgment of the Supreme Court, my lord, if I may just pass on, which has been suppressed by them, which we were also not aware. But the Supreme Court judgment now makes it clear. This, my lord, this is 1962, AR 1963, page 1. This, in fact, my lord, dealt with Mr. Ramlingam's will. That's the interesting aspect. This is a judgment of the Supreme Court. Not only not being a beneficiary, my lord, as Mr. Holla pointed out, yes. In fact, all these people challenged the will, questioned the will. Yes. Today, my lord, lot is being urged that no, I am a beneficiary, I am so interested. Yes. Kindly see, my lord, para 2 of the judgment. My lord, in para 1, yes, there is a reference to this Ramlingam Mudaliar, what he was doing, how he was a building contractor, how he acquired the properties, etc., my lord. Very same Ramlingam, very same. Then kindly see para 2. Yes. In the meanwhile, Mr. Ramlingam executed his will dated September 10, 1942. By the will, he made no provision for his eldest son, so and so, so and so. To his wife, Gajambal, he gave life witness in 3 houses, then under construction, so and so. To 5 out of his 9 daughters, not about 6 lines in the paragraph. Yes. To 5 out of his 9 daughters, he gave cash and immovable property, approximately to the value of rupees 25,000 each, and to 3 others, cash amounts varying between so and so, and excluded Bhagirathi, his daughter, altogether from the benefit of the will, so and so. Then your lordship would kindly turn to the next page, my lord, on top. The executors of the will were, 4th line, my lord, on top. Yes. The executors of the will were so and so, a retired revenue commissioner, so and so. Ramalingam died on December 18, 1942, leaving him surviving 3 sons, so and so, wife Gajambal, and 9 daughters. The executors applied to the district court, civil and military station for probate of the will. The widow and children of Ramalingam entered caveat, and the application was registered original suit number so and so. Mr. Medappa was then the district judge, dismissed the caveat, granted probate of will. Therefore, these people opposed the will. Yes. This person who now claims to be the daughter, my lord, and claiming to be so now espousing the cause. Yes. They were, in fact, opposing Mr. Ramlingam's wish and will. So far from being beneficiary, they have acted contrary to his wishes. And they contested in court, court granted probate. But this is, they ought to have been, now, my lord, a lot has been said, which is, in fact, against us, contrary to the record, because though it is not subject matter of compromise, we have referred to the sale in our resolution. That resolution is attached to the compromise. We have referred to it in the compromise petition. But here is a party who suppresses that she challenged the will along with sons and other this thing, and now claims to be interested. Therefore, this is something which is fatal, which has been suppressed. If this is the fraud now played, question would be whether this court could have entertained the review petition had this been made aware of it. Therefore, I would submit that this goes to show, apart from the fact that this property was not given to them in the will, this is another aspect which has been suppressed, and therefore this is another instance where, because this honorable court not proceeded on the basis that they are interested, because in the RP, my lord, the lordship has observed that being the daughter, she can be considered to be interested. That's the observation made. Yes. Therefore, my lord, now that calls for review in the light of that's why, my lord, I would humbly submit. In fact, what was pointed out to your lordship, my lord, para 8, my lord, page 73, your lordship has referred to the will, and kindly see, my lord, that is, my lord, if your lordship takes page 73, my lord, of the compilation, my lord. Yes. Your lordship's order, my lord. Yes, I got it. At para 8, my lord, last line at page 73, my lord. Yes. First petition is a daughter, and second, third, great grandsons of light, they are persons interested in the trust, they are beneficiaries. My lord, your lordship was not aware, was not made aware by them that they had the ones who had questioned the will in the first instance, because according to them, they were not given properties, therefore they had questioned the will itself. Therefore, not this, in my humble submission, is again an error in the light of not the fact which has been suppressed. Now, my lord, coming back to this subject matter of compromise, which your lordship, therefore, we had pointed out that because it's not that, as Mr. Nagarnath also pointed out, it's not that one day suddenly somebody appeared. No, it is a decision which has taken place, which in some time, some process has taken place. There has been mediation referred to by the court. We have tried to mediate because the court directed us to mediate, and therefore, my lord, a person has come forward where he says, all right, I will purchase, I will also try to persuade this other person to come to the compromise, take some portion and release. Therefore, my lord, it's a process. And that process, your lordship has seen, is not assailed anywhere in the review petition. Therefore, not one judgment, if I may just point out, in addition to judgment, which Mr. Holla pointed out, one 2022 judgment, my lord, on the aspect of lack of pleading. Now we'll just add that to the compilation, not which we had. Not at page para 16, my lord, if your lordship turns to. Para 16, my lord. Yes. The last line, my lord, at the bottom of the page. Yes. It is settled law that relief not found on pleadings should not be granted. If a court considers or grants a relief for which no prayer or pleading was made, depriving the respondent of an opportunity to oppose or resist such relief, it would lead to miscarriage of justice. In the case of Trojan and Company versus R.M.N. Nagapachettiar, this court considered the issue of whether relief not asked for a party could be granted, and that too without having proper pleadings. The court held, as under it is well settled, the decision of a case cannot be based on grounds outside the pleading of the parties, and it is the case pleaded that has to be found. Without an amendment of the plaint, the court was not entitled to grant relief not asked for, and no prayer was ever made to amend the plaint so as to incorporate it in an alternative case. In the case of Bharat Amritlal Kothari versus so and so, held, though the court has very wide discretion in granting relief, the court, however, cannot, ignoring and keeping aside the norms and principles governing grant relief not even prayed for with the petitioner. In this case, while directing for change of so and so, the High Court has traversed beyond pleadings, and such directions are likely to be set aside on this ground. Therefore, my humble submission is, this aspect of it was not even pleaded. No plea regarding the sale to the third party in the review petition. Therefore, my humble submission is recalling the compromise on that ground, is going beyond the pleadings, and therefore, my humble submission is that itself is an error which request to be corrected. Therefore, if your lordship now sees, insofar as what is the subject matter of compromise, in fact, there is no allegation. Now, the whole argument is not about what has happened between the original RFA appellant and respondent, because they also perhaps will not accept that the litigation was going on since 40 years. So they have tried to concentrate on a third party sale, which is not the subject matter of compromise. Therefore, my submission is, assuming that they have some case regarding some unfair nature of that transaction, that is not a ground to disturb the compromise being accepted by the court, because that is not the subject matter of the compromise. And ultimately, without it being shown how this compromise is unlawful or illegal. Yes. Therefore, if they had any grievance regarding that sale, which they did not raise in the review petition, it is open to them, if at all any proceedings lie under 92, to raise it, not indirectly do so by way of a review petition questioning the compromise by submission. Then your lordship would not just come back to your lordship's order, in the which is under review. Not at paragraph 10, my lord. Yes. The lordship has seen, my lord, in para 8, my lord, insofar as the finding, my lord, about persons being interested in the trust, my lord, I pointed out to your lordship, my lord, the error now, which is now, and my humble submission, my lord, this would be a case where, my lord, if at all, they have to urge this as a ground to seek leave in section 92 proceedings. Only, not even a person under section 92 CPC, my lord, assuming it's a public charitable trust and the public is the beneficiary, I'm not even assuming that they are somehow related to the original founder of the trust. That does not automatically entitle them to not to question any decisions in the trust. Section 92 CPC also provides either they must have the leave of the Advocate General, not, or they must obtain leave of the court. So even a person who is related to the founder does not automatically become a person interested in the trust, especially because not why the requirement of leave has been introduced. Not we have already pointed out judgments. Court says Section 92 is not meant to adjudicate private purposes or to settle some private scores. Lordship knows even in a public trust, sometimes the fight with trustees and others could be out of some private vengeance, some ego issues, or some other ulterior motives. Therefore, the Supreme Court says there must be a check placed. Therefore, leave of the court should be obtained. Therefore, a person may be even directly related to the founder, does not entitle him to straight away file a case. Leave has to be obtained, and that leave was not obtained not as on the date of filing of this review petition or even as on the date of passing of this order. Therefore, this question as to whether the person is interested in the trust or not depends on whether the person has obtained leave. If they had not obtained leave, then my humble submission is this finding also would be without jurisdiction and would be erroneous on the face of the record, because that is an aspect which lies solely within the jurisdiction of the Section 92 court. As to whether a person, a third party, can question an affairs of a trust, can be said to be interested in the trust, is a decision which squarely falls within the jurisdiction of Section 92 court alone. And what I also pointed out, one judgment of the Supreme Court, which says regarding trust, not all issues are to be dealt with by Section 92 court. Therefore, not insofar as this is the error, not I would humbly submit. Perhaps not the attention of the court was not drawn not at that point of time, not to this aspect, that unless they had obtained leave, they cannot be called as interested in the trust. Therefore, not this is the error insofar as observation in para 8 is concerned. Then your lordship would say, for the same reason, not your lordship sees page 76, my lord.
Yes.
Para 10, my lord.
Yes.
The reference is made not to the having filed a legislative petition, but there is no reference or a finding that they have obtained leave. Therefore, not if unless leave is obtained, mere filing of a petition, not, of course, anybody could file a petition. It is only when the court applies its mind and comes to a finding, and that could be subject matter of challenge, not then could it be said that they are interested. So without a finding at this point of time by a Section 92 court, not this court not could not have, in my humble submission, overlooking Section 92 and the requirement of leave and the judgments of the Supreme Court would say under what circumstances leave can be obtained or should not be obtained. Not could not have not. Then not insofar as the bottom portion of page 76, not, where your lordship has said, referring to that Naresh Kumar Jagat's case of persons being aggrieved. Your lordship would recollect, I had pointed out that was a case of central government, which had under the Acquisition Act not obtained title over the property. Here, my lord, it's not a case they have obtained title or they have any right in the property as such, because not under trust law, the trustees are considered to be owners of the property or all purposes. Not. Therefore, my Muhammad Sabish, this also aspect not, if they could be aggrieved, provided they have direct interest, which is not, I showed the lordship not one 5-judge bench of the Supreme Court under the Contempt of Court Act, which said the person aggrieved must be having a direct interest in the property. Therefore, not, they would not be having a direct, therefore, not, that has not been noticed not in this aspect. Not. Then the lordship would then turn to my lord in para 12 onwards, my lord. From para 12 to my lord para right to para my lord 15, your lordship has dealt with the issue of not the limitation.
Yes.
Unfortunately, not what was pointed out to your lordship, which is the judgments at para. I've already not pointed out these judgments at para 14 all deal with 115 review. The
Limitation is not
question of jurisdiction, not it's a question of admissibility of the claim, not and appeal being continuation of the proceedings. Not the question of jurisdiction would not arise. Your lordship would only note not the judgments which are referred to at para 14 onwards are all dealing with section 115 CPC as to whether an order is revisable or not under 115 CPC. That's a different test, my lord, than as to whether a court can entertain a compromise or not. None of these judgments are not dealing with that aspect. And the principle, my lord, is because if there is an error committed on the question of limitation, it could be revisable under 115 CPC. That there is no dispute, my lord. But the question is whether For entertaining a compromise, can it be said, unless court decides on limitation, it cannot do it? So, my lord, it's not a question of jurisdiction, therefore, in the light of the, then, my lord, is the only balance, my lord, which is remaining, my lord, is para 16, my lord, which I've already pointed out, my lord, it's disclosed, my lord, perhaps your lordship did not notice, my lord, that this sale was in fact referred to in the resolution and in the compromise petition, and this was not pleaded. So, the para 16, my lord, is a my lord, finding which your lordship has given without a plea by the review petitioners, including, my lord, those portions your lordship sees whether the transfer of property should be by way of auction or by private negotiation, whether it is at market value or not at market value. Your lordship now may not recollects. In the review petition, none of these are grounds. There is no allegation that it is not sold at market value, or it could not, nor even that it is not in the interest of the trust. That even that, and again, my lord, there is one more difficulty here, my lord. On the face of it, this is the finding which the Section 92 court, if at all, if it is maintainable, after obtaining leave, after an inquiry, after giving us an opportunity, my lord, to show how it is in the interest of trust or not. Because, as your lordship not rightly noted, it is an independent transaction to that extent. The subject matter of compromise is between the appellant and the respondent, which was handing over of that. That, my lord, neither your lordship found any difficulty with that portion, nor have they also urged anything with the, insofar as this portion, lord, that is, if at all, my lord, only a Section 92 petition after they obtain leave, and if they were to make a prayer, which they have not made a prayer till today also, my lord, therefore, my lord, my submission is, these are the grounds, my lord, on which this order calls for review. But unfortunately, in their arguments, my lord, other than only repeating that we did not disclose, and we're not making submissions that as if we just went out in the corridor and gave it off to somebody. If at all they were so aggrieved, my lord, they should have done so. And your lordship, my lord, to your lordship's question, this order of compromise would, because, my lord, the subject matter is this portion which has been settled, that cannot come in the way if they were to choose to challenge, and if they have the locus standing. If it is shown that they are in persons genuinely bona fide interested in the trust, my lord, we have a serious dispute. Now, my lord, in the light of these facts emerge, we have serious dispute about whether these persons are really interested in the trust or not, or are they doing it for ulterior purposes. But those are all which will not show in an inquiry, not in a section in RFA, my lord, compromise proceedings. Therefore, my submission is on these grounds, my lord. Your lordship would, of course, my lord, if your lordship were to be inclined to entertain a review, then, my lord, formally your lordship would have to first pass an order, my lord, allowing the review, if your lordship were to incline to, my lord. And then, my lord, of course, your lordship has already heard it, my lord, but it will only, my lord, technically 2 orders need to be passed. That's the only.
That review has to be recalled, then
again. Then your lordship would have to, my lord, if your lordship accepts our arguments, my lord, of course, both parties have in fact addressed your lordship, my lord, on the merits of the review also. Therefore, my lord, I don't think you would want to.
It is not that after recalling it has to go
before
somewhere else. It has to come before me.
Yes, yes, my lord. And, my lord, your lordship has already heard us on that aspect also, my lord. Your lordship would then take a call as to whether that my lord, review petition should be dismissed in the light of these submissions, my lord. Grateful, my lord. Lord, we'll, along with the judgment, we'll just hand over the compilation. Last time, Lord, we had given it a separate. We'll just give a compilation out with the propositions and index itself, not so that you'll access to your lordship.
Lord, 2 new points have been added, which is not part of the review petition. One is subject matter of the contract is only one part of the property, not the entire property. That is also not urged in the review petition. This argument is made. They may say that compromise itself may disclose that. That is one part of it. But subject matter of the compromise petition was the entire 16,000, wherein only 6,000 is sought to be given up. This 10,000 is sought to be retained. Specifically, it is stated so in the petition, in the compromise petition. Number 2 is that, according to my learned friend, we have suppressed that the decision of the Supreme Court insofar as the challenge to the will is concerned, which according to him in 1962 SEC online SC 112 is he has produced that. May I just make one point on that?
Yes.
Kindly see this the judgment. Lord, this was the challenge that has been made.
Yes.
By only the sons of Mr. Ramalingam.
Yes.
It is only the sons of Ramalingam and not his petitioners before this honorable court.
Yes.
The para 2 is very clear to that effect. The meanwhile, Ramalingam executed his will dated so and so. By this will.
No, that the widow and the children of Ramalingam, it's not.
Widow and children of Ramalingam, daughters Allah. Daughters of they have not challenged it. Kindly see para 3. Para 3. Other proceedings that have been during the pendency of the probate proceedings, sons of Ramalingam, who will hereafter be collectively referred to as the plaintiffs, instituted 3 actions. So on, so on.
That is separate
Those
proceedings.
sons.
Those are separate proceedings.
No, para 2.
And probate. Para 3 is separate proceedings regarding title, not this.
Your Lordship may kindly see the parties to the proceedings also. All the parties to the proceedings are mentioned in the judgment itself.
Yes.
That is one Vishwanathan and the Vishwanathan, Gajambalammat, Rukyan Mulk, Sayed, so and so. And these are the only persons who are the parties before the honorable.
And these are para 3 nalli sons have instituted separate proceedings. Because kindly see para 3.
Correct.
During pendency of probate proceedings,
some caveat has been entered into. So caveat, according to them, in that probate proceeding, some caveat has been entered into by widow and children of so and so.
Yes.
Widow and children of all children, it is not known, and those details are not forthcoming. And and it is their contention that we have not pleaded that we are not the beneficiaries under the will, etc. Even otherwise, under the will, we are not beneficiaries. We have already pointed out to your Lordship that an application for leave was filed by us in this in the earlier review petition 235. In that application, we have in details stated about how we are beneficiaries under the will and how we are interested. For the purpose of review petition, those pleadings was not necessary. It is only for the purpose of leave petition that order has not been challenged. That order was not sought to be reviewed also. Then lastly, my lord, it is their contention that several proceedings have been initiated for 40 years. The property, they were not able to get it, and the proceedings were initiated. And this gentleman, Mr. Raghav Reddy, he has been in possession of the property as a lessee, etc. Kindly see the statement of objection that I have filed. I have enclosed the very agreement itself. I will just point out that clause, specific clause about the nature of possession, 226 Miller, nature of possession of this Raghav Reddy. It is at page number 73 to the statement of objections.
Yes.
Page number 73 is the copy of the agreement to sell.
Yes.
Miller, ultimately, which is sought to be enforced under in RFA, Miller. Based on that only, Miller, the proceedings have been initiated. At one point in time, it was rejected, and thereafter in the second round of litigation. But this agreement, under this agreement, Raghav Reddy is not a tenant at all. He's a totally third party. He wanted to purchase this property. Only obligation that he has undertaken is what I would get. Your Lordship would get it at page number 80. Clause number 4. The position of this gentleman is very clear where. What was his possession? Whether he was a lessee and
yes,
how he has come in possession, etc. The vendors shall deliver possession of the property, premises number so on. So described in the schedule hereunder by adjournment to the purchaser on execution of the sale deed, and it shall be the responsibility of the purchaser to set the tenants vacated. He was not given possession. Possession is supposed to be given only at the time of registration of the sale deed. How he has come in possession, whether his possession was lawful or not, is something different. The contention is to that
yes,
he was a lessee in possession, etc. Is a wrong statement before this honorable court. He was not a lessee. He was never in possession, and he was not put in possession under this agreement to sell. The obligation Mr. Raghav Reddy has taken is only to see that he gets other tenants vacated from the property. That too at his cost. On the other hand, in the sale deed, your Lordship would get your Lordship may kindly see. it shall be the responsibility of the purchaser to get the tenant vacated. That he has undertaken. That in no way creates that will no way have the effect of the tenant being put in possession as such. Then your lordship may kindly see the sale deed. In the same documents, my lord, along with my statement of objections, the sale deed, I have produced that copy of the sale deed also. The first of the sale deed, your lordship would get it page number 13. In that, your lordship would get the page number 23 may kindly be taken, my lord. Clause number 14, then clause number 15. Under the agreement to sell dated 13/6/1984, the seller and its then trustees agreed to complete the sale of the entire Schedule A property for rupees 10 lakhs and received rupees 2 lakhs by way of advance towards the sale price. In addition to that, this purchaser claims to have spent considerable sum of rupees 14 lakhs towards eviction of tenants who had occupied the Schedule A property. The parties have now agreed by consent that since only the portion of Schedule A property, that is the Schedule B property, is now being sold by the seller to the purchaser, no further sale consideration shall be payable by the purchaser to the seller, and the advance amount of is 2 lakhs paid by the purchaser to the seller at the time of agreement dated 13/6/1984 and subsequent expenditure of rupees 14 lakhs stated to have been incurred by the seller shall be treated as entire consideration towards the sale of the Schedule B property. That is how, my lord, this 14 lakhs has been adjusted towards the expenditure for eviction of the tenants. Though agreement is, my lord, it is the responsibility of the purchaser to get the tenants vacated. That expenditure has been taken as consideration, shown as consideration in this sale agreement.
Yes.
It is for that reason only, in fact, it was brought to the notice of this honorable court. It is for that reason only, your lordship in para 16 have taken note of the fact that the sale is not in the interest of the trust.
Reserve.
Yes. Couple of days, we'll give that compilation.
Give that compilation.
Bill number 41, V.B. Shivakumar for petitioner. Vajasvi.
The petitioner, my lords. Yes. The respond number and finance not filed Wakalathila.
What do you want?
No, they have not come on record date, my lords. So interim orders may be extended.
Yes, at the request, which this matter of 2 weeks. Interim order granted earlier is technical next date of it.
Bill number 42, V.B. Shivakumar, withdrawn.
For the petitioner, my lord, withdrawn.
Permitted to withdraw.
For petitioner, Ravindra Babu Kesi.
Petitioner in this case. Seems that office objection is raised, respondent.
They are not there. Yes. Leave this matter of 2 weeks.
Interim order be extended.
Interim order granted earlier is extended to next date.
Bill number 45, D. Gangadhara for petitioner. Maresh
For the
Yangadi.
petitioner in this matter.
Lord,
Last occasion also.
My lord.
Reported regarding service of the.
Short question is involved in this petition, my lord. Whether the, after evidence is recorded, the counter claim is admissible or not. There's only question challenged here, my lord. The court rejected his application. He's filed a counter claim.
Counter claim has been filed after that issue has been framed.
Yeah, before issue, my lord. Before issue.
Before?
Before issue.
It has been filed before issue or after issue?
Before issue, my lord.
Before issue.
Yes, sir.
Yes.
As per the claim made with the petition, my lord, there is an agreement made between the respondent and petition, and the property was mortgaged to the respondent for petition. Now, as per the agreement made, that is annexure, kindly.
No, now that your counterclaim has been rejected.
Please, that is
Counterclaim is filed before that issue or after that issue?
after the issue, because we.
After the issue, evidence of the plaintiff and a cross-examination of the
After
plaintiff.
the issue, it is not.
It is a permitted also, my lord.
Where is that?
And presently, some of the guidelines of the Supreme Court is there. And please,
But yeah,
before
first,
that, before that, annexure A continue.
what is that?
And annexure A is there agreement between the respondent and
No.
petition.
First, we'll find out law.
Please,
If it is permitted, then we'll go to
It is
the,
a-
otherwise, why?
it is permitted. The as Supreme Court 2022 AC 642.
Padi.
It's a permitted. One more is ruling after that.
2000.
Yes. Which is that? Where is, which is the paragraph you want to?
That is then head note, it is also mentioned in its aspect.
Yes.
Please, Lord. Please. Tara. Page number.
Para 13 in the order.
Please, Lord.
Three-judge bench of this court has essentially considered the question in reference as to whether it is mandatory for a counterclaim of the defendant to be filed. The written statement, but answering the question, this court undertook the basic principle that to not be suitable that it should be viewed the court of further discussion of the court regarding the procedural remove section. ಏನಿದೆ ಇದರಲ್ಲಿ?
Now it is a permitted and second is the ruling.
ಎಲ್ಲಿದೆ? Where is permitted?
That is the result is there and moreover the second ruling, my lord.
No, you read that it is a three-judge bench judgment has been extracted.
2020 Supreme Court, my lord, clearly statement. 2020.
No, three-bench judgment which he is referring, which you are referring, You read that page 12.
One.
Huh?
Para
Para 13 ಅಲ್ಲಿ, para 13,
13 and
last
15
5
ಅಲ್ಲ.
line ಓದ್ಬಿಡಿ ನೀವು.
ಅಲ್ಲ, please.
Last 5 line.
Doing revision.
ಕೆಳಗಡೆ ಬನ್ನಿ. Last.
Conclude that it is not a mandatory for the conviction of the, to file along with the written statement, the court in its direction may allow the counterclaim to be filed after filing of the written statement. In view of the consideration mentioned in the proceedings paragraph, however, propriety requires that the discretion should ordinarily be exercised to allow the filing of the counterclaim till for framing of issue for the trial. This content, this extent, I concur with the conclusion reached by my learned brother. However, for the reasons stated above, I am of the view that the expenses circumstances of this counterclaim may be permitted to file a return statement till the stage of its commencement of the recording of the evidence on behalf of the plaintiff. And 15 also is there.
No, that you see that, but however, we are of the consider opinion that defendant cannot be permitted to file a counterclaim after the issues are framed and after the suit is proceeded substantially. It will defeat the cause of the justice and be determined to the principle of speedy justice. Yes, as per that amendment to the CPC. Very same judgment said it is not after that this thing.
It is also permitted, sir, subsequent. That is the finding of the court.
No, already judgment ಹೇಳ್ತಾರೆ ಅದು it cannot. See, ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಜೊತೆಗೆ ಹಾಕ್ಬೇಕು ಅಂತ ಇದೆಯಲ್ಲ, ಆ ತರ ಮಾಡೋದ್ ಬರಲ್ಲ, ಲಿಬರಲ್ ಇರಬೇಕು. ಬಟ್ even after ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಲ್ಸೋ we can file it. It should be before issue.
Before the issue. Even after that, there is no damage to the parties.
ಎಲ್ಲಿದೆ ಹೇಳಪ್ಪ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವ್ರು ಹಾಗೆ ಹೇಳಿದಾರಪ್ಪ ನೀನು.
2009.
ಅದು
409.
three judge benches has held that.
Here out the 3 judges bench, Malad.
Yes.
2020, Malad. Same, Malad.
Ashok.
Yeah, correct, Malad.
Yes.
They referred me in the court. Same, Malad.
3094.
30?
I'm sorry. 2020, 2 part, page number 394.
Filing of the counterclaim after the submission of the written statement. Only that part of that has been.
Yes, this is
that-
also.
Yes. It cannot be filed after that.
Yes, ma'am. Even the provisions of order 826A, not 6B also. Provision also says CPC. Order 826B and 6B.
Can be permitted and they are got right for cross-examination. Some of the document is also required to produce.
6C, Malad. Order 8.
C.
6. 6B and 6C.
Plaintiff contended claim is raised or to be disposed by a Yes. that is exclusion of the counterclaim.
Yes, sir.
See, after counterclaim is filed,
Yes.
plaintiff can say that
Yes, my lord.
this relief cannot be granted in this suit. He can seek for an exclusion of the
That's
counterclaim. It is not that for filing in a counterclaim. But this judgment is said that it should be before
Paper issues. my lord.
us.
Alien Heights, they are undertaken and earlier there was a suit filed by the petitioner. That is also disposed and
No, judgment which you are relying on, it says that it cannot be after that issue is framed.
subsequently it is a necessary production of document also is there. That is why it is a permitted as per the Supreme Court direct.
ಯಾವ್ದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಹೇಳಿ
Full bench correct.
ಯಾವ್ದು 20?
ಅಲ್ಲ ಈಗ 2020.
2020 ಹೇಳಿರೋದು 3 judges.
Para number 660, which is detailed observer and permitted to the person to make a necessary application for counterclaim.
No, counterclaim, they said it need not be with that written statement. You can file it later also, but it should be before
Issue.
that issue.
Some of the document is required to produce it. That is also permitted. I had to make a necessary document to produce it. That is also not considered by the trial court.
The constitution bench said you cannot file it after that issue has been framed.
One aspect, my lord. There was a
That
suit,
is the only aspect.
please.
It is not one aspect and second aspect.
There was an application filed by the petitioner in another suit. That is also clubbed. And that was also rejected. While they were rejecting my application, it is made an observation. The petitioner has got right to adjudicate the matter and to take a defense before the regular courts. When such an observation made in that proceedings, the petition is entitled. Recently I filed some of the documents.
Now, what is that order he is challenging?
My lord,
Annexure
page 106, my lord.
N is an order has been passed. by the-
Operative portion, my lord, para 10, 9 announced, 10, my lord.
It may be not the suit ejectment plaintiff has claimed that defendant is not a tenant under the.
Para 10 announced, my lord. Page 108, my lord.
Yes. Yes, read.
Please.
Yes.
The current advocate for the plaintiff has also relied on the judgment of the Supreme Court. In Ashok Kumar Karla Supra, Ashok Kumar Karla, the Supreme Court has laid down the law that the court can recognize the counterclaim, though filed belatedly after filing up a written statement, and not to counterclaim the counterclaim after framing of the issue. In this case, not only that this court has framed the issue, but
ಅದನ್ನೇ ರಿಲೇ ಮಾಡ್ಬಿಟ್ಟೆ ಇದ್ ಮಾಡಿದ್ದಾರೆ ಮತ್ತೆ ಅದೇ ಜಡ್ಜ್ಮೆಂಟ್ ನೀವು ನಿಮ್ ಫೇವರ್ ಆಗಂತ. Yes, that is what is wrong in that.
That is why I had to produce some of the document in the counterclaim also. And moreover, in the earlier judgment,
Counterclaim cannot be permitted at all. If you law permits for filing in additional documents, you file
Separate application,
photo such,
separate application.
New application, if law permits for production of additional documents, it can be.
Yes, yes.
Not as a counterclaim.
Yes,
Yes, that's all.
that's time.
when an application filed in the another suit and the trial court has already made an observation allowing my claim to, it can take a defense before the regular proceedings. That is order.
Where is that?
I thought it speaks. In subsequently I filed a necessary document along with the order passed in the another suit, where the petition was already filed a suit and that was disposed. While disposing that matter, my lord, the trial court has passed an order that is please. Additional annexed document, page number 11 in its judgment passed in OS number 4373 of 2019. Where the plaintiff, that is the petition was also filed.
Yes.
Where the petitioner filed
Page number?
page number 87, my lord. Additional annexed documents which filed furnished. As per the order of Channel Court, I filed a necessary additional document,
87.
87 page. Lord, in this suit, the petitioner is also filed a suit against the defendant for challenging that he should not evict it illegally, and he is claiming that the mortgage amount has to return by the respondent. That suit has been ultimately disposed. While disposing the matter, the observation made in this proceedings, my lord.
Where is that?
Para 11. Page number 97, my lord.
90?
97 page, para 11. Page, my lord. I read it. Bearing in mind the above notice well settled position of law.
No, 97 is something else, mister.
Page, para number 11, page 90.
Para 11, the defendant submits that during the pendency of the suit.
Type page number 97 is there. Page number 11, para number 11. Being in mind the
No, that
notice
is not.
well settled position of law. If the fact
No,
of
that
the
is
case
not
of-
the judgment, mister. That is some application under order 6 rule 17. Next
other
real.
connected matter that the observation made by the court.
Early connected matter.
This is an order passed in the
Innೊಂದು matter.
My lord, he
OS
filed,
number.
he filed a suit for injunction.
Yeah, right.
He filed a suit for injunction, my lord, bare injunction. Court said he's filed, already eviction is filed, so his suit is dismissed. That's all.
ಆಯ್ತು, ಅದು ಎಲ್ಲಿದೆ ಅದು?
Recently I filed a list of documents, additional list of documents that is filed on 13th January. As per the order of the Honorable Court.
Page number?
Page number, typed page number.
97.
Page number 97. Typed page number 11, para number 11.
ಏನಿದೆ ಇದು? ಹಾ.
Please, being in mind the notice well settled position of law, if the fact of the case, case on hand are considered, the defendant being the landlord of the suit premises has taken in recourse to procedure established by the law for ejectment of the plaintiff from the suit premises. Applying the law laid down by the Honorable High Court, Meghalaya in the aforesaid side judgment to the fact of the case on hand, it has to be held that there is no cause of action for the suit. It is needless to say that the plaintiff will have every opportunity to contest the claim for the defendant, in the ejectment suit.
Who is plaintiff in that?
Please, that is why I filed an application for.
No, who is the plaintiff in that? Why is not?
That is the same plaintiff before the other. I filed a suit against the same respondent.
Tenant
That
is a plaintiff.
And moreover, my lord, I filed application for clubbing the matter.
No, you are Srimati Shantabai.
That the same petitioner is the plaintiff in another suit.
Yes, you have
Very
filed a.
Very first time I filed a suit against the respondent in that suit.
No, what is that they said?
That
You
is
can
a-
contest the claim of the defendant in the ejectment suit. ಅಷ್ಟೇ.
that
No,
is
you
why I
are
filed
contesting.
When
that-
such was not considered to clubbing the
Mr.
matter. Allenaitu.
You are permitted to contest that
Yes,
suit filed by him. That doesn't mean that you have to be permitted to file a counter of claim after that, this thing. They said that
That was the proceedings was going on due to the corona period, I could not make it. Subsequently, it was permitted and disposed of the matter.
Yes.
Again, I filed this application for permitting the counter and as well as the production of the document.
Yes,
And
that's all.
moreover, my lord, an application was filed for clubbing the matter. Subsequent, when during the pendency of that proceeding, the
No,
respondent.
we are
filed
not,
objection.
only your application for counter claim has been rejected.
Oh.
On that only this writ petition.
Please.
Yes.
And I will permitted to continue the.
Yes,
counterclaim.
yes. No, it cannot be, yes, thoroughly.
Production document and necessary as per the,
Production of documents, if you law permits, you do it, mister. Not in this, yes.
unless the stated by detailed facts in counter.
Yes, this petition is filed by defendant challenging order dated 10/1/2024 passed by sixth additional city civil and session judge in OS number 813 of 2020 on IN number 1 of 2022 filed under order 6. Where is that order? Order 6 rule 17. whereby application is rejected. The plaintiff respondent has filed in a suit for eviction. On service of summons, defendant petitioner has filed a filed a return statement. On the basis of pleadings of the parties, the issues has been framed. When the matter is posted for evidence, when the matter is posted for evidence,
Cross evidence of PW1.
evidence that petitioner defendant has filed an application under Order 6, Rule 17, seeking a counterclaim. Since the application filed by the petitioner is belated, that too after framing that issue, the trial court, after considering the judgment of Apex Court in case of Ashok Kumar Karla versus Wing CDR, Surendra, Agnihotri and others, reported in 2020, Volume 2, SCC 394, has dismissed that application on the ground that once the issue is framed, the respondent cannot be permitted to file a counterclaim. There is no error or illegalities in the order passed by the trial court. Hence, writ petition liable to be dismissed. At this stage, learned counsel for the petitioner submits that he requires to produce some documents to establish case. If that would be the case, he has to file a necessary application for production of documents in accordance with law, if law permits. Yes.
And matter may be disposed of. My lord, 21 years, still last 3 years and he has taken time for the cross examination.
Yes, that will dispose. Yes. Now, therefore, he has taken option to file an application for. That is how the tenants are doing it, to drag that matter.
As expeditiously as possible.
Yes. All pending applications are disposed.
Serial number 46 adjourn, hearing interlocutory application matter. Serial number 47 adjourn. Serial number 48, Girish Kumar R for petitioner, K.S. Ganesha.
From the
Lord,
respondent, my lord.
I appear for the petitioner, my lord. My lord, this, we are challenging.
Wait. Passover matters is there. Will call.
Please, my
After
lord.
that, for intellect.
Passed over matter.
Yes.
Serial number 27, Vinay Kirti M.
Yes. None appear. Leave this matter next week.
Serial number 28, P. N. Harish for petitioner.
For the petition of this case.
Yes.
Can you be fixed in date, my lord, next week?
Next week. At the request, leave this matter next week.
Please, my lord.
Yes. On 5th. Yes. Paper publication.
List number 3, serial number 2, Umesh B. N. for petitioner, Badrinatha.
Serial number. This
List
court,
number 3, serial number 2, Umesh B. N.
this court by order dated 29/1/2025 permitted the petitioner to take out notice by way of substituted service to that respondent number 8 to 21, 23 to 34, 37 to 39, 41 to 46 by way of paper publication in Udaya Vani Bangalore edition in respect of respondent number ಹಾಕಿದ್ದಾರೆ 8 to 21, 23, 24, 26 to 37, 37 to 39, 41, 42, 43 and 46 by way of Udayavani. And respondent number 8, 9, 10, 11, 12, 14, 15, 16, 19, 26 ಅದ್ರ ಆರ್ಡರ್ ಇದೆ ಅದು ನಾಲ್ಕು ಇನ್ನು Udayavani Mandya edition in respect of 13 Udayavani Mysore edition, 17 32 Ballari, 18 Dharwad edition in respect of 43 Udayavani Belgaum edition in respect of the respondent number 33 the paper publication hakidara. Yes, the petitioner has filed a memo enclosing paper publication. Respondent so and so is called.
Respondent number 8, M.R. Mahesh. Respondent number 9, M.R. Prakash. Respondent number 10, Shivagangava Pakirappa Asundi. Respondent number 11, H. Venkatesh. Respondent number 12, B.N. Jayadeva Raja Aras. Respondent number 13, S.T. Govinda Raju. Respondent number 14, G. Kamakshi. Respondent number 15, C.P. Raichurkar. Respondent number 16, Sanaullah. Respondent number 17, Dr. A.R. Nagasundara. Respondent number 18, Mamami Veeresh. Respondent number 19, Pratima Rao. Respondent number 20, K.V. Prasad. Respondent number 21, S.D. Ganachari. Respondent number 23, Nagesh S. Respondent number 24, L. Mahadevappa. Respondent number 26, Pradeep Kumar Pulli. Respondent number 27, Prashant Pulli. Respondent number 28, K.B. Suma. Respondent number 29, H.R. Parashivamurthy. Respondent number 30, Prakash Veerabhadra Gudanavar. Respondent number 31, Ayyamma Prakash Gudanavar. Respondent number 32, V. Lakshmi Narsimaya. Respondent number 33, Sadananda S. Mattur. Respondent number 34, V.V. Adimani. Respondent number 37, Chaudappa. Respondent number 38, B.V. Manjunatha. Respondent number 39, Ambarisha. Respondent number 41, Jayamma. Respondent number 42, Munikrishna. Respondent number 43, Basavannappa V. Naikar. Respondent number 46, A.V. Gangachar.
Yes, called, none appears, memo is accepted. Service of notice to so and so is, what is this matter, mister? Why is this? In WP, all these, so many parties. What is this matter? Yes.
List number 1, hearing interlocutory application matter, serial number 47 adjourn, serial number
Submission.
48, Girish Kumar R for petitioner.
Serial
Yes,
number
Ganesh.
27.
Yes,
Passed over.
27 is called, nobody is there, mister.
Your Lordship, I paid the only court fees was office objection. ಅದರಲ್ಲಿ ಇವತ್ತಿಂದ ಮತ್ತೆ ನಾಳೆಗೆ ಹಾಕಿದ್ದಾರೆ. The only matter is
No, you are not there when the matter is called, mister. Tomorrow. Yes, tomorrow, tomorrow. Yes.
Lord,
Respondent number, serial number 48.
Yes.
my lord, I appear for the petitioner, my lord, in this
Paper
matter.
for the respondent, my lord.
My lord, this is a matter which challenges, challenging the execution order, my lord. I mean, execution proceedings, my lord. The MFA is pending, my lord, and MFA, there is an order that no prescriptive action will be taken by the respondents, my lord. ಅದು 14ನೇ ತಾರೀಕಿಗೆ ಪೋಸ್ಟ್ ಆಗಿದೆ. It may be posted after that, my lord.
No, sorry, my lord. I have strong objections to that because I haven't taken that. I have not proceed. I'm not going to proceed with the matter. But still, this matter requires to be decided, my lord, because he's challenging is that the arbitrator, the commercial court at Bangalore has no jurisdiction to execute the award passed by the arbitrator. I have cited a decision on the 25th, my lord. It is in the file, wherein Supreme Court clearly held that arbitration award can be executed anyway. It may be disposed of, my lord, because MFA is there pending and court will look into that.
Yes, mister. Anyhow, you have interim order in that appeal.
Court has not passed any interim order. I haven't taken before the court.
I'll argue the matter, my lord.
No, my lord. No, it is sorry, my lord. Let it be disposed of. Because Supreme Court judgment is there.
I'll argue on the merit, my lord. Then,
No, Mr. Counsel.
please, my lord.
Even then it is disposed of. You have undertaken that you will not precipitate. What is the?
Correct. In view of the pendency of the MFA, why this matter is to be kept in, my lord? MF ಹಾಕೊಂಡು jurisdiction ಈಗ jurisdiction ಬರುತ್ತೋ ಇಲ್ವೋ ಅಷ್ಟೇ ಡಿಸೈಡ್ ಮಾಡ್ಬೇಕಾಗಿರೋದು.
Serial number 49, Kashyap and Nayak for petitioner, Yashu Mishra.
The petitioner, the judgment at a writ petition, Lord, on the last statement, Lord said directed me not to create any additional encumbrances on the attached properties. My lords, I will file a purchase order that is placed on the MRI. I had already informed my lords on the last date that the only way for me to by selling the assets, which are all been attached. They have attached the assets on the at the scheduled property. They have attached my bank accounts. They have attached assets that are there in another branch of mine. I'm a diagnostic center. If my lord permits me to sell the MRI and if the decree holder agrees to cooperate, that amount of 75 lakhs will directly be paid to them.
My lord, there is an, my lord, this petition pertains only to attachment of the immovable property. Now they want to sell a movable property that has been attached. That is not in question in this petition.
No, but
Yes, it is,
you
no.
can take out that.
There is an order of this court, my lord, that there is an order of this court that if he gets the buyer and buyer agrees to deposit the money before the court, to which I am agreeable.
Yes.
Or they may sell it for a song. It is, I mean, because if it
No,
is.
who is the purchaser?
Purchaser is another entity, my lord, that does similar business.
No, let him.
Tesla
file
Healthcare
let-
Solution.
Let him file an affidavit saying that, yes, I am going to purchase. And in that amount, instead of paying, I will pay it to him.
Very well, my
That
lord.
is enough, Mr.
No, my lord, my submission is, let them undertake to deposit that amount before the court. The 75 lakhs they say, now, my lord, they don't even file it with a memo. They are
My apologies, my
simply,
lord. It has come to my hands today,
if they
otherwise I would have
undertake
produced it.
that they are going to do this, then
if-
I will be able to answer, my lord.
No, if they filed in a memo saying that if it is permitted, we will,
If they file an affidavit of the proposed purchaser saying I am purchasing it for 75 lakhs and I am ready to deposit it before the court.
yes.
I am ready to anyway give an undertaking if that's what my learned friend requests, that it will be deposited to, it will be handed over to him. It
Yes.
need not be deposited in court and then he
My
withdraw.
lord, an undertaking of the party is different from an undertaking from the council. My lord, if a party gives an undertaking and he does not comply by it, it amounts to contempt.
Yes, you file in a party.
I will file the affidavit, my lord.
Yes, when do you want?
Next week, my lord.
Yes, leave this matter. on
Interim order may kindly be extended, my lord.
6th.
6th.
Yes.
There are two interim orders, both may be accepted. On the last occasion, my lord has passed an order for them not to alienate the property.
Yes, interim order granted earlier. Is extended till next date of it.
Great.
Number 50, Balagangadhar GS for petitioner, Saravana S.
Next week. Yes. The request of counsel for the petitioner. Leave this matter on 10th.
Please, my lord.
Yes.
In the meantime, lords, I will produce the documents. I will serve them the copy and I will sell them.
17th.
ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ವಿ ರಿಮೈಂಡ್ ಮಾಡಿದ್ರೆ ಮುಗ್ದೋಗುತ್ತೆ ಅಂತ ಇಂಜಂಕ್ಷನ್ ಸೂಟು ರೆವಿನ್ಯೂ ರಿಪೋರ್ಟ್ ಇದೆ ಅವ್ರ ಪೊಸಿಷನ್ ಎಲ್ಲ ಇಲ್ಲ
10th, let us see on 10th. 11th. Why? Then we'll have it on 6th or 7th. Yes, 7th. Yes, 7th.
Serial number 51, Vivek Kolla for petitioner, Appaya PB.
Waiting for the respondent here. Yes. Ready, both of them?
Yes, your
Any date? Fourth or fifth? Yes, fifth we will hear. All the matters which is for vacating, understanding that for final. It's all only GM CPC, not take any much time. Yes. Interim order granted earlier is extended till next date of it.
Serial number 52, T. Sheshagiri Rao for petitioner, A.V. Amaranathan.
We have taken
Respondents.
R31 as indicated in the calculation. Notice has to go to R1, R2, R3, R5, R7, R10.
You have paid the process.
Yes. we have
Yes,
paid.
learned counsel for the petitioner submits that. Yes, Mr. Process notice has to be completed. As filed and submitted that needful has been done. Office to verify and proceed further.
The needful has to be done by the respondent, one of the respondent, that is R7, not
For-
by me.
For what?
Lordship, that is that R7 and R10 was dead.
No, needful in respect of payment of process.
payment of court fees concerned, we have paid it.
No, issue notice, Mr.
But office objection raised on wakalat filed by,
No, I am not on that. Now you have paid the process.
we have paid it.
Yes. Submitted that PF has been paid, office to proceed further.
Serial number 53, LM Chidanandaya for petitioner, connected matter,
Matter
Akash
may be
Kumar
extended.
Kota.
Interim order granted earlier is, yes. When do you want? Yes, leave this matter on 7th. Yes. Yes.
Serial number 54, adjourn. Serial number 55, Devaraj AS for petitioner, Somana KP.
Or respondent with us.
Yes.
My lord, suit is of the year 2014, my lord. My lords, after lapse of 8 years, they filed application for amendment of written statement, my lords. The evidence of plaintiff is concluded. Now it is posted for defendant's evidence, my lords. My lords, kindly come to the order of the trial.
What is that order they are challenging?
My lords, application, my lords, order for amendment of written statement, my lords. My lords, after 8 years, they've come before this court challenging the order, application.
8 years after that?
My
What
lords,
is
the
that order?
suit was filed in the year 2014, my lords. It is for bare injunction, my lords. My
Now
lords, what
that
has happened is,
application
my
for
lords, in
amendment
the,
is rejected.
Yes,
it is rejected, my
It
lords.
is not a matter. I came on record in the year 2019, but the matter is, it is in the year 2014. As LRs, we came on record, we filed, we are independent return statement without admitting the statement of the D7. Malad, after 2019, Malad, COVID was started. Some documents are not available.
When you have implemented as a party?
In the year 2019, Malad.
2019.
LRs.
When application has been filed?
2022, my lords.
22, we filed. In the secure markand and some of the documents from the department.
Suit is filed 2014 and application is filed after 8 years, it is not correct.
Please, my lords.
Now, the contention of the trial court is that it is after 8 years, he has not implemented, he has implemented subsequently.
My lords, he is impleted in the year 2019, my lords. The application is filed in the year 2022. After the completion of evidence, my lords, we've concluded our evidence. Plaintiff evidence is concluded. Thereafter, he files his application.
Now, when at the time of he was implemented in the year 2022,
Please,
what was the stage in the suit?
By that time, even we came on record now, my lord. By that time, it is for the evidence. Evidence stage ಅಲ್ಲಿ D7 ತಿರುಗ್ತಾರೆ ಹಾಗಾಗಿ LRs application ಆಗ್ತಾರೆ.
ಆಯ್ತು ಕೋವಿಡ್ ಇದ್ರು 1920 ಆಯ್ತು 21-22 what are you doing, mister?
Because of my lord, we have filed earlier a
The
suit
proposed
for
amendment
partition and
also is
declaration.
irrelevant for the case, my lords.
In OS number 3 of 2014,
My lord, the gist of the case is, my lords, in the year 1999, in OS number 277, the petitioner's father files an bare injunction suit against the respondents, my lords, which gets dismissed. Thereafter, he files the RA, he goes on appeal, even that gets dismissed, my lords. Then he comes before this court in RSA, my lords, that
His
is pending
application
for
for
adjudication.
His application for impleading
Please, my
is
lords.
allowed, it's at finality.
Right.
Then he entered into the suit in the year 2019.
My lords,
From that day, you have to be counted.
Please, my
Is it not? Now, what is the reason for rejection is only for the delay.
That's not for the delay, my lords.
You see that order, show me that reasoning. Court said that it in 80 years,
My
it is
lord.
not 80 years,
Order is at page 15, my lords.
1-5. Yes, 1-5,
Please,
you
my
come
lord.
to that reasoning portion, para 16.
Please, my lords.
Only on that ground, there is no any other reasoning.
My lords, but the proposed amendments are not relevant to this petition, my lords.
Where is that court finding regarding that?
My lords, it's in page
Where is that
18, my lords. Kindly come to page 18, my lords.
page?
18, 1-8.
Yes. Reasoning is start from page 24, mister. They have extracted that order 6 rule 17 Then they have given a finding in that 16, that's all. So, I mean,
My lords, what has happened in the, my lords, in the year 1999, they file a suit for permanent injunction, my lords, bare injunction. That gets dismissed. They come on appeal. Even that gets dismissed, my lords. They come before this honorable court in RSA, my lords, and that is pending for adjudication. They are not contesting in that matter, my lords. And in the last date of hearing,
see, in this
in
case,
pertaining to the same survey number, my lords, 83/12 is the survey number.
Sir, counsel, you argue this case only in
My lords,
respect of.
this case is relevant to the.
You see that finding of the trial court. I want to examine only that order passed by the trial court under that application. They said there is an 8 years delay in filing that, therefore it cannot be. That is also not correct, that is wrong. He has impleaded in the suit is filed 2014, it's correct.
Please, my lord.
8 years from the date of the suit, but he was
My
impleaded.
lords, the father expired. That is the reason they have impleaded, my
Yes,
lord.
we'll hear that next week. Yes.
For 2 weeks.
No,
That's
next week.
next week, my lord. Kindly.
ಅವರು
yes.
ಸ್ಟೇಟ್ಮೆಂಟ್
That's
ಫೈಲ್
okay.
ಮಾಡಿದ್ದಾರೆ.
This matter on 10th.
kindly direct them to serve copy to.
What is that?
ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ ಸುಮ್ಮನೆ.
You have filed a-
Vacating stay application I filed.
ಕೊಟ್ಟಿಲ್ವಾ ನಿಮಗೆ ಕಾಪಿ?
It is served of the petitioners, my lord. I'll serve it on the council as well.
ಕೊಡ್ರಿ ಅದು ಕಾಪಿ ಹಾಕಿದ್ದಾರೆ ಕೊಟ್ಟಿರ್ತಾರೆ ನೋಡಿ. ಮತ್ತೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್
ಎಂಟ್ರಿ ಮಾಡಿದೆ ಸರ್. kindly extend the entry ಮಾಡಿ.
Copy is not served, you give a copy, mister, vacating.
I will serve it.
Yes. Office has not raised any objection. Interim order granted earlier is extended till next date of hearing. Use this matter on 10th. In the meantime, respondent is directed to survey a copy on counsel for the petitioner. Yes.
Serial number 56, CM Nagabhushan for petitioner, PC Sitaram Rao.
Mullards, I appear for the respondent number 3. I have filed the application, Mullards, for fixing a date for hearing, Mullards, because the petitioner has no respect for law or for the orders of the court. Mullards,
Yes.
there is an earlier direction by this honorable court for the entire trial to be completed before
we'll fix
December
that.
2022.
We'll fix that early hearing date. Which date you want, mister?
Tomorrow, Mullards.
IA 1 of 2025 for early hearing is allowed. Post this matter for hearing on 11th.
11th, Mullards.
Yes, interim order granted earlier is extended till next date.
Serial number 57, Rukojirao HS for petitioner, Patil JM.
My lords, here, my lords, the order transferring the suit from commercial court to civil court is under challenge, my lords. It's covered by 2 judgments of Madras High Court as well as Bombay High Court, my lords. And none of the defendants have opposed, my lords. When I filed an application for transferring the suit from civil court to commercial court, defendant number 1, bank has not opposed it. They have also agreed it's a commercial suit. The commercial court.
By agreeing the party or consent of the parties, it cannot be
That's true,
transferred,
my
mister.
lord. That's true.
Object of that commercial
My lord,
court
see,
is
if you
defeated
law-
now. Everybody is saying, what is that on ground you are challenging that it is?
My lords, it's a commercial dispute, my
Why?
lord. Civil court has passed an order under section 15 saying it's a commercial dispute and transferring the suit. Thereafter, the commercial court again goes into the same question and says it's not a commercial suit and transfers it back, my lord.
Yes, we'll,
My lord, so lords may have it tomorrow. It's covered by 2 judgments, my lord.
not tomorrow, mister. On
Because
fifth,
in trial court, it's listed on 5th, my lords, any date before.
Fourth.
Okay, my lords, 5th.
fourth, yes, yes. Leave this matter on 4.
Much okay.
58, K Ravishankar for petitioner, Dinesh Kumar Rao.
And for respondent number 1 to 4. Date may be fixed. Vacating application.
Leave this matter on 10th or 11th, mister.
10.
Interim order. Interim order granted earlier is extended till next date. Yes, other matters, you take date, any date you want, except tomorrow.
Evidence is discarded, my lord. I will be out of court.
No, any date, you can take that, where there is no interim order, we'll extend that interim order.
Literally, literally.
Just you have to inform the court officer which are the matters.
Yes.
There will.
May I
extend
request
it.
for tomorrow, my lord, there is some
Monday,
urgency.
Monday, yes.
Please.
Sir, next matter.
Statement ಇಲ್ಲ ಅದು ಅವೆಲ್ಲ ಸೈನ್ ಆಗ್ಬೇಕು, ಸೈನ್ ಆಗಿ ಬರ್ಲಿ. ನಾಳೆ ರಿಪೀಟ್ ಆಗಿರೋದು ಯಾವ್ದು ಅದೇ ನಾಳೆ ಇವತ್ತಿನ 25 ಎರಡು ಇಲ್ಲೇ ಇಟ್ಟಿದ್ದೀರಿ ಅಂದ್ರೆ ಒಂದೇ ಒಂದ್ ನಂಗೆ ತೋರ್ಸಿದ್ರು. ಕೊಡಪ್ಪ ಡೇಟ್ ಇರೋ ತಗೊಂಡೋಗಿ ಕೊಟ್ಬಿಡ್ರಿ, ಆಮೇಲೆ ಹಾಕ್ಸ್ಕೊಳ್ಳೋಣ. ಡೇಟ್ ಇರೋ ತಗೊಂಡೋಗಿ ಕೊಡಿ ಅಲ್ಲಿಂದ ನೀವು ನಿಂತ್ಕೊಂಡು ಹಿಂಗಂದ್ರೆ ನಂಗೆ ಕೇಳ್ಸತ್ತ. ಅಟ್ಲೀಸ್ಟ್ ಇವನ್ಗಾದ್ರೂ ಹೇಳ್ಬೇಕು.
ಸರ್ ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟ್ರು.
ಕಂಡೀಷನ್ ಹೇಳ್ಬಿಡ್ತೀನಿ ಕೋರ್ಟ್ 17th ಇಂದ ಡೇಟ್ ತಗೋಬೇಕು ಎಕ್ಸೆಪ್ಟ್ ಅವ್ರದ್ದೊಂದು ಮಂಡೇ ಬಿಟ್ಟು 17th ಮಾರ್ಚ್ ಇಂದ ಡೇಟ್ ತಗೋಬೇಕು. ಡಿಸ್ಪ್ಯೂಟ್ ಇದ್ದವ್ರು ಬೆಳಿಗ್ಗೆ ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಕನ್ವೀನಿಯಂಟ್ ಡೇಟ್ ತಗೊಳ್ಳಿ. ಎಂಟ್ರಿ ಮಾಡ್ರು ಇದ್ದಿದ್ ಕಡೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ವಿತೌಟ್ ಬ್ರೇಕ್. ಫ್ರೈಡೆ ತಗೋಬಿಡಿ RFA ದಿನ.
ಆಯ್ತು 17th ಕೊಡಿ. ಹಾ 17th ಕೊಡಿ ಸರ್.
ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ ಸರ್ 17th ಗೆ ಕೊಡಿ ಸರ್.
ಆಯ್ತು
ಮಾಡ್ರು ಬ್ರೇಕಪ್ ಇಲ್ಲ ಅಂದ್ರೆ
17th ಸರ್ 17th. 17th
ನಾನೇನು ಪಿಟಿಷನರ್ಗೆ
17 17th. ಓಕೆ
60 5th ಮಾರ್ಚ್ ಐವ ಬಗ್ಗೆ ತಲೆ ಕೆಡ್ಸ್ಕೊಬಿಡಿ. ಬ್ರೇಕಪ್ ಇಲ್ಲ ಅಂದ್ರೆ 61
ಮಂಡೇ ಮೇಲೆ ಮಂಡೇ ಹೇಳಿದ್ರು. ಮಂಡೇ 3 ಪ್ಲೀಸ್.
62 21 ಈಗ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ. 62 ಹೇಳಿ ಬೇಗ ಡೇಟ್. ಮಂಡೇ ಕೊಡಕ್ಕಾಗಲ್ಲ ಸರ್, ನನಗೆ ಡೇಟ್ ಕೊಡಕ್ ಹೇಳಿದ್ರೆ 17. ಅವ್ರೊಂದು ಹೇಳಿದ್ರು ಅದಕ್ಕೆ ಹೇಳಿ. ಈಗ ಅದನ್ನ ರಿಪೀಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಇಷ್ಟು ಜನ ವೇಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಇಸ್ಬಿಟ್ಟಿರೋರು ಬೆಳಿಗ್ಗೆ ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಅಡ್ಜರ್ನ್ ಮಾಡಿರ್ತೀನಿ ಬೆಳಿಗ್ಗೆ 64
Sir, 64 respondent ಗೆ sir.
63 ಬೆಳಿಗ್ಗೆ
ಬೆಳಗ್ಗೆ ಆಗಿದೆ 2 weeks ಆಗಿದೆ. 64 25 63 2 weeks ಆಗಿದೆ ಬೆಳಗ್ಗೆನೆ.
ಬೆಳಗ್ಗೆ ಟೈಮ್ ಇಂಟಿಮೇಷನ್ ಇಲ್ಲ
ಮಾಡಿದೀನಿ ಅಂದ್ರು ಅವ್ರು.
ಮಾಡಿದೀನಿ
ಹಂಗಂದ್ರು ಅವ್ರು. ಮಾಡಿ ಬೈ ಸ್ವಲ್ಪ ಅರ್ಜೆಂಟ್ ಇದೆ. 2 weeks
Sir, 64.
19th ಆಗಿದೆ ಸರ್. 19th
67
ಕರ್ಕೊಂಡು
68
I go continue.
70 ನೋಡಕ್ಕೆ ಈ ತರ ಅಂದ್ರೆ ಅದಕ್ಕೊಂದು ಪಿಕ್ಕಿಂಗ್ ಬ್ಲಾಕ್ ಆಯ್ತು. 73 73 ಹೇಳಪ್ಪ.
70 ಆಯ್ತಲ್ಲ 17 ಆಯ್ತು 70.
74
ಹೇಳಿ ಸರ್.
ಸರ್ 73 ಗೆ ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ.
19
ಸರ್ 73 ಗೆ ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ.
73
73
ಒಂದು ಡೇಟ್ ಅಂತ
77
ವೇಟ್ ಮಾಡಿ ಮೇಡಮ್.
ಓಕೆ
79 80 20th ಮಾರ್ಚ್ ಬ್ರೇಕಪ್ ಇಲ್ಲ ಅಂದ್ರೆ 81 ಬ್ರೇಕಪ್ ಇಲ್ಲ ಅಂದ್ರೆ 82 85 86 87 88 93
89 intermodern to be extended. ಆಮೇಲೆ ಡೇಟ್ ಬೇಕಿತ್ತು ಸರ್. 89
ವಿಸಿಲಿಯರ್ ವೇಟ್ ಮಾಡಿ ಮೇಡಮ್ 2 ನಿಮಿಷ.
ಹಾ ಓಕೆ.
ಮಾಡ್ರ ಬ್ರೇಕಪ್ ಇಲ್ಲ ಅಂದ್ರೆ
ಆಗಿದೆ ಸರ್.
ಇಲ್ಲ ಈಗ ಆಗಲ್ಲ. ಡೇಟ್ ಕೊಟ್ಬಿಟ್ಟು ಕೊಡ್ತಾ ಇದ್ದೀವಿ. ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಎಲ್ಲ ನಾವು ಮಾಡೋದಲ್ಲ, ಚೇಂಬರ್ ನೋಡೋದು ಅಡ್ಜರ್ನ್ ಅಷ್ಟೇ. ಡೇಟ್ ಇಲ್ಲ.
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಪಾಸ್ ಓವರ್ 27 ಯಾವ ಡೇಟಿಗೆ ಹೋಗಿದೆ ಸರ್?
ಡೇಟ್ ಇಲ್ಲ ಅದಕ್ಕೆ. ಬೆಳಗ್ಗೆ ತಿಂಗ ಮೂವ್ ಮಾಡ್ಕೊಳಪ್ಪ. ಅದು ನಮ್ ಕೊಡೋದಲ್ಲ, ನಾವು ಬರೆಯಕ್ಕಾಗಲ್ಲ. ಹೇಳಿ
27 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಯಾವ ಡೇಟ್ ಹೋಗಿದೆ?
ಪಾಸ್ವರ್ಡ್ ಯಾವ್ದು ಇಲ್ವಲ್ಲ, ಮುಗ್ದೋಗಿದೆ ಎಲ್ಲ.
ಯಾವ ಡೇಟ್
ಇದ್ರು
ಹೋಗಿದೆ?
ಬಿಡಿ, ನಿಮ್ ಸೀನಿಯರ್ ಮಾತಾಡಿ. ನಮ್ ಕೊಡೋದಲ್ಲ, ನಾವು ಬರೆಯಿಸಿಲ್ಲ. ಸಾಹೇಬ್ರು ಏನ್ ಹೇಳಿರ್ತಾರೋ ಅಷ್ಟೇ ನಾನು ಮಾಡ್ಬೋದು. ಅಲ್ಲಿಂದ ಆಚೆ ನಾನು 4 ಲಿಸ್ಟ್ 3 ಕರೆಯಲ್ಲ ಸರ್, ನಮ್ ಕೊಡೋದಲ್ಲ. ಇನ್ಯಾವ್ದಪ್ಪ ಯಾರು VCL ಇರೋರು ಯಾರು?
64
ಹೇಳಿ ನಂಬರ್ ಏನು? ಸೀರಿಯಲ್ ನಂಬರ್
64
ಹೇಳಪ್ಪ. 64 ಅಷ್ಟೇ. ಅವ್ರು ಏನ್ ಕೇಳ್ತಾರ ಅದ್ ಹೇಳು.
ಸರ್ 73 ಮತ್ತೆ 89 89 ಅಲ್ಲಿ
3 ಆಮೇಲೆ
73 ಮತ್ತೆ 89
ಒಂದೊಂದು ಹೇಳಿ ಮೇಡಮ್. ಎಕೋ ಆಗುತ್ತೆ.
73 ಸರ್.
73 ಅಡ್ಜನ್
ಡೇಟ್ ಇಲ್ವಾ?
ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್
89
89.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕು.
2 weeks ಬೆಳಗ್ಗೆನೆ ತಗೊಂಡಿದ್ದಾರೆ ಅವ್ರು.
ಓಕೆ, ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕು ಸರ್.
ಬ್ರೇಕಪ್ ಇಲ್ಲ ಅಂದ್ರೆ ಆಗುತ್ತೆ ಮೇಡಮ್, ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇದೆ ಅದು ಹೇಳಿ.
ಓಕೆ ಓಕೆ ಸರಿ ಸರ್.
ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಹಾ
60 17 3 ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಪ್ಪ ನೀವು. ಅವ್ರು ಯಾರೋ ಡೇಟ್ ತಗೊಂಡೋಗಿ ನಾನೀಗ ಅರ್ಧ ಆಗೋಯ್ತು ಈಗ ತಲೆ ಕೆಟ್ಟ ಕೇಳಿಸ್ಕೊಳಕ್ ಆಗಲ್ಲ ನಂಗೆ ಇನ್ನೂ ಇಷ್ಟು ಕೆಲಸ. ನಾನೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ, ಅದನ್ನೇ ಬೆಳಿಗ್ಗೆ ಸಾಹೇಬ್ರಿಗೆ ಹೇಳಿ ಇಲ್ಲಿ ಬಿಡಿ ಆಗೋಯ್ತು. ಈಗ ಅವ್ರು ಕರ್ಕೊಂಡ್ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ ಬೆಳಗ್ಗೆ ಅದನ್ನೇ ಹೇಳಿ. ರಾಂಗ್ ಪರ್ಸನ್ ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ರು ನಿಮ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ಗೆ ಹೇಳಿದೆ, ಕೋರ್ಟ್ ಆಫೀಸರ್ ತಗೊಂಡಿಲ್ಲ ಅಂತಾನೆ ಹೇಳಿ. ಹಂಗೆ ಹೇಳಿ. ನಾನು ಅಲ್ಲಿದ್ದಾಗ ನೀವು ಒಬ್ಜೆಕ್ಟ್ ಮಾಡ್ಬೇಕು. ನಾನು ಅದೇ ಇದೊಳ್ಳೆ ಸರ್ ಹೋಯ್ತಲ್ಲ, ತಿರ್ಗಿ ಹಿಂದಕ್ಕೆ ಬೇರೆ ಬರಕ್ಕಾಗುತ್ತೆ. ಇಷ್ಟು ಜನ ವೇಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅದನ್ನ ಹೇಳಿ ಸಾರ್ ಅಂತ ನಾನೇ ಹೇಳ್ಕೊಡ್ತಾ ಇದ್ದೀನಲ್ಲ ನಿಮ್ಗೆ. ಈಗ ಇಲ್ಲ, ಅವ್ರಿಗೆ ನಾನು ಹೇಳ್ಬಿಟ್ಟಿದ್ದೀನಲ್ಲ, ಅವ್ರು ಕರ್ಕೊಂಬನ್ನಿ, ನಿಮ್ಮ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಪೋನೆಂಟ್ ಕರ್ಕೊಂಬನ್ನಿ. ಅವ್ರು ರಾಮಕೃಷ್ಣನ್ ಎಸ್ ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ, ನಾನು ನೋಟ್ ಮಾಡ್ತೀನಿ. ಗೊತ್ತಿಲ್ಲ ಸರ್, ನಾನು ಬರ್ಕೊಂಡಿದ್ದೀನಲ್ಲ, ನಾನ್ ಬರ್ಕೊಂಡಿದ್ರೆ ಅವರು ಬರ್ಕೊಂಡಿದ್ದಾರೆ. ಬಿಡಪ್ಪ, ಹಿಂಗ್ ಮಾತಾಡೋದು ಬೇಡ ಸುಮ್ಮನೆ, ಅದು ತಲೆ ಕೆಡುತ್ತೆ ನಮ್ಗೆ ನಿಮ್ಗೂ ಇಬ್ಬರು ಗೊತ್ತಿಲ್ಲ. ಹೌದು, ಮತ್ ನಾನು ಇನ್ನ ಇಷ್ಟು ಕೆಲಸ ಮಾಡ್ಬೇಕಲ್ಲ. ಆಯ್ತು ಬಿಡಿ ಸರ್, ಬೆಳಿಗ್ಗೆ ತಲೆ ಕೆಡುತ್ತೆ. ಅದಕ್ಕೆ ಎಷ್ಟಿಂದಪ್ಪ 59 ಬರ್ಕೊ, ಬೇಗ ಬರ್ಕೊಂಡು ನಾನು ಇನ್ನೂ ಅಷ್ಟು ಬರೀಬೇಕು. 59 17 3 60 25 3 61 3 3 62 ಅರ್ಜನ್ 63 ಬೆಳಗ್ಗೆ ಆಗಿದೆ. 64 25 3 65 17 3 66 19 3 67 25 3 68 17 3 69 ಬೆಳಗ್ಗೆ ಆಗಿದೆ. 70 17 3 71 4 3 72 ಬೆಳಗ್ಗೆ 73 ಅರ್ಜನ್ 74 17 3 75 19 3 76 17 3 77 ಅರ್ಜನ್ 78 ಅರ್ಜನ್ 79 ಅರ್ಜನ್ 80 ಬೆಳಗ್ಗೆ ಆಗಿದೆ. 81 23 82 18 23 82 18 3 83 ಡಿಸ್ಪೋಸ್ 84 ಅರ್ಜನ್ 85 18 3 86 18 3 87 18 3 88 ಅರ್ಜನ್ 89 2 weeks ಬೆಳಗ್ಗೆ ಆಗಿದೆ. 90 ಬೆಳಗ್ಗೆ ಆಗಿದೆ. 91 ಬೆಳಗ್ಗೆ 92 ಅದು ಡಿಲೀಟ್ ಮಾಡಿಸ್ಬೇಕಾಗಿತ್ತು, ಆಗಿಲ್ಲ. ಅರ್ಜನ್ ಮಾಡಿ ಡಿಲೀಟ್ ಮಾಡಕ್ ಸಾಹೇಬ್ರು ಹೇಳಿದ್ರು. ಆಯ್ತು. 93 ಅರ್ಜನ್ 94 19 3 95 19 3 96 9 ಅರ್ಜನ್ ನೆಕ್ಸ್ಟ್ 2 3 ಅರ್ಜನ್.
Serial number 73 date 73.
ನಂಬರ್ 2 3 ಇದಪ್ಪ. ತಿರ್ಗಾ ಪದೇ ಪದೇ ಕೇಳ್ತಾ ಇರಬಾರ್ದು, ನನಗೆ ತಲೆ ಕೆಟ್ಟು ಮೂವ್ ಮಾಡಿದ್ರೆ ಅದು ಸಾಹೇಬ್ರಿಗೆ ಹೇಳ್ಬೇಕಾಗಿತ್ತಲ್ಲ ಅವಾಗ್ಲೇ. ಹೋಗ್ಬಿಟ್ಬಿಟ್ಟು ನಾನು ಕೇಳಿ ಬೆಳಿಗ್ಗೆ ಅವ್ರು ಯಾರು ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು ತಗೊಂಡಿಲ್ವಾ ನಂಬರ್ 3 ಯಾವ್ದು ಹೇಳಿದ್ರೆ ನಾನು ಅಪ್ ಮಾಡ್ಬೋದು. ಅಲ್ಲಿಂದ ಆಚೆ ನಾನು ಮಾಡ್ತೀನಿ. ನಿಮ್ಗೆ ಗೊತ್ತಿರೋ ವಿಚಾರನೇ. ಇವಾಗ ಆಗಲ್ಲ, ಹೆಸರು ಬಂದಿದ್ದೀನಿ. 6 ಗಂಟೆ ಸುಮ್ನೆ ನಾನು ನಿಮ್ಗೆ ಹೇಳ್ತೇನೆ. ಗೊತ್ತಿರೋದ್ರಿಂದ ನಾನು ನಿಮ್ಗೆ ಹೇಳ್ತೇನೆ, ಸಾಹೇಬ್ರು ಈ ಮ್ಯಾಟರ್ ನೋಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತಾನು ನಿಮ್ಗೆ ನಾನೇ ಹೇಳಿದ್ದು. ಯಾಕೆ ಇಷ್ಟು ಮೆಮೊ ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಇದ್ರಲ್ಲಿ ಅಲ್ವಾ? ನಾನೇ ನಿಮ್ಗೆ ಹೇಳಿದ್ದು, ಹುಷಾರಪ್ಪ, ಸಾಹೇಬ್ರಿಗೆ ನೋಟ್ ಮಾಡಿದ್ದಾರೆ, ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ನನಗೂ ಹೇಳಿದ್ದಾರೆ ಅಂತ. ನನಗೆ ತಲೆ ಕೆಟ್ಟಿತ್ತಾ ಯಾವ್ದಾರು ಅಫಿಷಿಯಲ್ ಸೀಕ್ರೆಟ್ ಬಿಡಕ್ಕೆ? ಆದ್ರೂ ನಾನು ನಿಮ್ಗೆ ಯಾಕೆ ಎಚ್ಚರಿಸ್ತೇಳಿ, ಪಾಪ ಅಷ್ಟು ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಅಂತ ಹೇಳಿ. ಅಷ್ಟು ಅರ್ಜೆನ್ಸಿ ಇದೆ ಸರ್. ಏನ್ ಗೊತ್ತಾ? ಅಲ್ಲಿಂದ ನಿಂತ್ಕೊಂಡು ಏನ್ ಹೇಳಿದ್ರೆ ಅದೆಲ್ಲ ನಮ್ಗೆ ಕೇಳಿಸ್ತದೇನ್ರಿ? ಹೇಳ್ದೆ ಅಂತ ಹೇಳ್ತೀವಿ. ಹತ್ರಕ್ ಬಂದು ಹೇಳ್ಬೇಕು. ಅಲ್ಲಿ ಅವನು ಹೇಳಿಲ್ಲ, ಕೇಳು, ನಾ ಹೇಳಿದ್ನ ಇವಾಗ ಎಷ್ಟಕ್ಕೆ ಬಂದು ತೋರಿಸಿದ್ದ ಕೈ ಕೊಟ್ಬಿಡ್ಬೇಕು. ಆರಕ್ಕೆ ತಗೊಂಡು ಒತ್ಕೊಂಬಂದು ತೋರಿಸ್ತಾ, ಅವ್ನ್ ತೋರಿಸ್ತೀವಿ, ನಿಮಗ್ ತೋರಿಸ್ತೀವಿ, ಯಾರು ಗೊತ್ತಾಗ್ಲಿಲ್ಲ. ಕೊನೆಗೆ ಅವ್ನು ನೀನೇ ಬಾಯಿ ಕಡೆಗೆ ಗೊತ್ತಾ ಅವ್ನು ಹೇಳು. ಅಲ್ಲಿಂದ ನಿಂತ್ಕೊಂಡು ಹೇಳಿದ್ರೆ ಅವ್ರು ಏನೋ ಕೇಳ್ತಾ ಇರ್ತಾರೆ. 5 ನಿಮಿಷ ಈ ಕಡೆ ಆ ಕಡೆ ತಿರುಗಿದ್ರೆ ಹೋಯ್ತು ಕೆಲಸ. ಬಯಸ್ಕೋಬೇಕು. ಅವ್ರಿಗೂ ತಲೆ ಕೆಟ್ಟಿದೆ. ಅವತ್ತು ಹೇಳಿದ್ದೀನಿ ಅರ್ಜೆಂಟ್ ಇರೋದು ನಾನು ರಿಪೀಟು ಮಾಡ್ಸಿರ್ತೀನಿ. ಟು ಬಿ ಆನ್ ಸೇಫರ್ ಸೈಡ್. ಪುಟಪ್ ಆಗೋಗಿದ್ರೆ ನೀವು ತಗೊಂಡೋಗಿದ್ದೆಲ್ಲ ಪುಟಪ್ ನನ್ನ ಕೈ ಕೊಟ್ಬಿಡ್ಬೇಕು. ರೇವಣ್ಣ ಹೇಳ್ತಾರೆ ಫೋನ್ ಮಾಡಿ ಡಿಕ್ಟೇಷನ್ ಕುಂಡಿಸ್ತಾರೆ ಈಗ ಡಿಕ್ಟೇಷನ್ ಕುತ್ಕೊಂಡು ಫೋನ್ ಹಾಕ್ಸ್ಕೊಂಡು ಹಾಕ್ಕೊಡ್ಬೇಕು ಇದು 3 ಇದು 2 ಇದಿಷ್ಟು ಅದಕ್ಕೆ ಕಟ್ಕೊಂಡು ಕೊಟ್ಬಿಡ ಡಿಕ್ಟೇಷನ್ ಇಲ್ಲೇ ಇರಲಿ ಏನು ಮೆಮೊ ತಂದು ಕೊಟ್ನಲ್ಲ ಅವ್ನು ಯಾಕೆ ರಾಂಗ್ ಮೆಮೊ ಅಂತ ಬರ್ದವನಲ್ಲಪ್ಪ ಪುಟ್ಟಪ್ಪು
ಎರಡು ಒಂದು
ಎಲ್ಲ